Oh, chat. Hi. Good evening. It is day 6 of Kouri Richins. And why is my hair all flippy floppy? Anyway, it's day 6. Let's get started. Hope you guys are doing well. Hope you guys had a nice Sunday. A nice Sunday of like no more attacks on Iran. Totally joking. We did more and more and more. Apparently today the United States or Kuwait smoked out 3 F-15s, which is like pretty impressive. So, Aces, any recap of day 4 and 5? We're gonna recap day 5. Actually, the most important part. If you guys remember, day 5 is where the real big stuff happened. Into day 4, from day 4 into day 5, we heard from Carmen Lauber. She is the housekeeper for Kouri Richins, who was told multiple times, "Go get me pills." And eventually, she claims that they're claiming that they used her to go get um that they got her fentanyl. Um, from her, it then went on to so from here, guys, what we ended up with was Common Lover the Liar. Her story didn't make a whole lot of sense. From there, we then heard from uh Crozier, who was like the drug dealer. And what did he say the whole time? What did he say the whole time? He said that he was selling pills. He sold them to Carmen, and all he was selling was pills he got from prescriptions from pharmacies. He was saying he hadn't seen any fentanyl. After that, we then well, I'm sorry. Before that, we also heard from the undercover officer. And what did the undercover officer tell us when he testified? Well, he said some things. According to hold on, Chad. So, according to the undercover officer, his argument was actually back during this time there was a ton of fentanyl in the Salt Lake City area. He's like, there were tons of it. And he said it was very common to get the pills, which they were using the blue M30s, the propofol was actually just fentanyl at that point. People were just pressing fentanyl and making fake pills. But remember, the dealer said, I never ran into fentanyl. I was just selling straight up prescriptions. Um, so the star witnesses that were given all this immunity, um, I think probably may set Kouri Richins free, because if the people who gave Kouri Richins the pills didn't realize they were giving him fentanyl, there's no murder. And if Kouri didn't realize she was giving him fentanyl, then it's not murder. It's not even manslaughter. Although the problem is, I guess the rest of what Kouri did, and we haven't seen it all yet, but as of right now, that's reasonable doubt, in my opinion. That's actually reasonable doubt. I don't think they've proven it, especially with all this. Now, there's still a lot more trial to go. We're going to get through all the phone calls and all that stuff, but we haven't gotten to them yet. We haven't gotten to them yet. But for right now, um, also, I will get some water. In fact, 2.0 got me a cup, a little enamelware cup, and she brought me back home a gift that she showed to me today. So, um, so there's going to be an intent issue here, but that may get outweighed by everything Kouri Richins has said and done that's kept on the phones and everything else they did. We'll find out. We'll find out. We still have a lot more to go here. So let's get started. They probably just ended because remember, they're running full days for this trial, which is still absolutely obscene, but they are doing them. They are doing them, chat. And I can't no. So we are going to get going here. Let's hit this. Which one's the one here's our feed. All right, chat. Let's get to this. And remember, we are going to speed this up. Yeah, I agree, Kay. He probably knew it was Fent. Has the dog walking letter come up? Yes. That's where we're starting to get into all of that. Kay Alpha saying Crozier knew it was Fent. I'm sure he did. But people are lying. People are lying, but the problem is the jury has to sit there and say, well, then why'd you give all these people immunity if they're all fucking liars? It really makes the case look bad. It makes the case look bad. And we're not doing quarter speed. That would be horrible. All right, chat. So let's get started here. We are going to get going. It is time. We are now 8 hours and 26 minutes behind. So let's get to it. Remember, there is no closed captioning because there is nothing. These are not done yet, which sucks. But, say la vie, chat. Say la vie. Look, we just burned through a bunch of it here, guys. Check this out. Remember, there are going to be some pretrial.
The state that we haven't been able to.
There's going to be some arguments that they're going to put on the record here.
The jury in.
Your Honor, the state's first witness is Dr. Eric Christensen. I was notified by counsel this morning that they intend to move to exclude or suppress his testimony, and I will let them make whatever motion they want to make.
Counsel, tell me more.
Okay, so they're looking to exclude testimony of a witness. This happens sometimes at the morning of trial. This is not a... You're not like you shouldn't do this, but like sometimes that's the only time you can do it.
Simply that we have not been able to consult with Dr. Christensen. We have reached out to him.
Say that again.
I'm sorry. We have not been able to consult with Mr. Christensen or Dr. Christensen. We've reached out numerous times. Got on the phone with him.
I understand that. But half the state's witnesses are lying. Who do you believe? Which ones do you believe, Kay? I mean, that's a problem. That's reasonable doubt. If you don't know which witness to believe, I think you have reasonable doubt. ALR is saying, why do they allow suppression? Well, basically, this is like a motion in limine. They're trying to keep this guy's testimony out, Angela. It's not necessarily like suppression, but it's what they call it in Utah. But basically, this is a motion in limine, like right now. So let's see what happens.
He was unavailable, asked if we could get some time with him. That was about, 4 or 5 weeks ago. And haven't heard anything. Last week, we informed the state that we haven't been able to get in touch with him, asked the state to have him reach out to us. He has not reached out to us, so just based on just the rule, and he should be available to cooperatively consult with us. He did not.
I appreciate that. He's here now.
I understand.
Mr. Berman, sir, if we flip the order of events, can we allow Dr. Christensen to consult with the defense counsel since he's physically present, and then we can use the time for a different witness?
I have no objection to that. Indeed,
Now, guys, you hear him saying we never had the chance to speak to him. Most of the time, if a witness doesn't want to talk to you, tough shit. But this guy's an expert. Expert witnesses have to be made available because your expert has to be able to have information. You have to be able to talk to him. So this is a little different. Expert witnesses have to be made available. But you did hear the judge say, well, he's here now. Can you talk to him in the hallway? And this is one of those times where the judge is trying to fix it. Here's how he's going to fix it. And you're like, well, that's not really fair. And it's like, it's not, but, suffer. That's what you're getting.
ask counsel, time 3 minutes ago, that's not. So,
who else do you have on deck?
I don't know.
John, let me see. I don't know if we have anybody in until 9, but we'll see.
Okay.
Your Honor, we have an objection to have the witness that state intends to call today.
Let's do it all.
Okay, but let's stay focused on this one for the moment. Mr. Ramos, make a record for me. If I change the order of witnesses and just order Dr. Christensen.
I didn't say she's truthful. I say she's credible. Like, she's believable. I didn't say she's truthful, but I'm sure that her husband that she killed was fucking insane. Like, the idea that neither of those people were unstable is probably ridiculous, but did she have enough to kill him? I don't know. I thought the jury might buy it.
To consult with you since he's physically present. Anything further on that?
Just assuming that we can take that break. I'm not sure who's next and whether it's my witness or not.
Understood. Okay.
Absent that, I will make do. Obviously, I didn't want to do that rushed before we got here. So if we can have an hour or whatever we need,
Right.
That'd be great.
Let's figure out what the order of witnesses is going to be.
May I just have the benefit of the record for 1 minute? So I spoke to Mr. Christensen, or Dr. Christensen this morning. He says that he received a call several months ago from Mr. Bertram saying, hey, we need to set up a time. He never heard from them again. He received a call warning that he would be getting an email maybe a month ago or so. No, a subpoena. He subsequently received it by email, and then he received.
Some of you guys are wondering about audio boosters. Guys, I've got the audio booster, the enhancer plugin going. These audio feeds kind of suck. I'm sorry.
Received a call with no message this over the weekend, and that's where
I've
we are.
tried to
We
turn
are
it up. I've
forward.
used an extra booster
Mr.
as
Willoughby,
well.
talk to me about the other witnesses that are proposed for today.
Your Honor, I think that other witness is going to draw a motion.
Oh, who is it?
His name is Todd Davis. I guess I don't know.
Detective.
Todd Davis. Your Honor, Mr. Davis was not on the state's witness list. They added him on Thursday, which I believe is in violation of Rule 16. And I'll point the court to State versus Draper, 378 P. 3rd, 1261. In that case, the state had the manager of the store that was the victim of the theft on the witness list, and then later during trial added the assistant manager, and the Court of Appeals found it was an abuse of discretion for the trial court to allow that witness to testify without sufficient notice under Rule 16.
What was the amount of notice in that case?
I don't think it said exactly if it was during trial. It said it was during trial that they announced that she was going to testify, and I don't recall if it was the same day. But the state's had months and months. We've had 8 amended witness lists, and I think to continue to add witnesses during trial is not sufficient under the rule.
Help me out, Mr. Bloodworth. What is Detective Davis?
It's Lieutenant Detective. I think Lieutenant Davis, right?
Sure.
He, Your Honor, the state is calling him to authenticate the May 4th, 2023 interview video of Robert Crozier. In rebuttal to Robert Crozier's testimony, all he's going to do is authenticate the video.
Is that
That's the first I've heard that that's all he's going to do. But
is that issue in dispute? I mean, you reserve your arguments about whether there are other bases to bar the admission of that video,
which I believe there are.
but authenticity probably isn't one of them. Do we really need to call a witness, or can we just stipulate that it's authentic, and then the parties will reserve their arguments regarding admissibility?
I would agree it's authentic, but yes, we would have other objections.
So can we just have a clear stipulation on the record that the May 4, 2023 video recording of law enforcement's interview with Robert Crozier is authentic?
Yes.
Your Honor, may I add that the transcript for the video as well?
Is it a certified
It
transcript?
is certified.
I think that follows from the rule regarding certified transcripts. Ms. Lewis, do you agree?
I agree.
Okay, so it sounds like we don't need that yet.
Correct, Your Honor. We may as well use this time to litigate, I guess, what other objections to admissibility the defense has on it.
Forgive me, the state is offering the video under which rule or exception?
Your Honor, 801, it'll be D1A, and perhaps some of it will be D1B. The defense's cross-examination of Mr. Crozier elicited testimony that, and the state's direct examination elicited testimony from Mr. Crozier that was inconsistent with his testimony in the video. The defense's cross-examination elicited testimony that he was kind of out of it because of withdrawal and pressure to say certain things. And the video, rebuts that testimony. The video itself is, I think, 13 minutes long, and from the state's view, the entire 13 minutes, pieces of those 13 minutes are direct impeachment, but the entire 13 minutes goes to whether or not he was high and out of it, and whether or not he was pressured into saying certain things. Those pieces of evidence are throughout the entire 13 minutes.
The impeachment pieces, or the more specifically, the D1A inconsistent pieces, those would be, I think, fairly perceived off a cold transcript. The second piece, I'm not sure I or defense or you or the jury would be able to evaluate whether he was in a bad way from the transcript. Is the state seeking to admit both, or publish the video and admit the transcript? What's the scope here?
Your Honor, publish both. We have the transcript running real time beneath the video,
Okay.
so that the jury can watch, listen, and read all at once.
Just do long form video essays. Just have him talk for 10 hours straight. 20 million views each video.
All right. Ms. Lewis, do you have the video with the transcript?
I don't have them together where it shows it under. No, I have them separately.
Right. Sitting here today, are you prepared to make a record regarding this, or do you need a moment to go through the pieces of, or to make argument regarding certain pieces of the transcript versus other pieces?
I think I would need a moment. I would like to see the video with the transcript
Sure.
run under it, and then, yes, I would need a moment. I would need some time to look at that.
Okay. We'll need to play this out a little bit. The state makes a facially, if not valid, at least thought-provoking argument under D1A, 801 D1A, that the video and the transcript related to it are categorically not hearsay. But having not seen the whole 13-minute video or read the whole transcript, and without the defense having the same opportunity, I can't make a ruling sitting here at the moment. So can we provide the video with the running transcript to the defense?
We can, Your Honor. I believe we placed it in box yesterday, but we can, if they want to, perhaps we can go into a conference room here and we can just play it off one of our machines.
Sure. I mean, I would also understand if the defense said we just need an evening with it to go through it, collect our thoughts, have you make a ruling. Ms. Lewis, what's your request?
Depends on what's happening here next. I may be able to watch it now. I don't know where we're headed.
That's the thing, Your Honor. Those were our first two. That was our batter in the box and our on-deck batter.
Okay.
So we are scrambling to get the whole batter here.
No, it's fine. These things happen. We're going to let Mr. Ramos continue to consult with Dr. Christensen. Ms. Lewis, Ms. Nestor, if you would have a conversation with the state about the video with the running transcript, let me know where we end up.
All right. Thank you.
Okay. Before we take a break for that, Mr. Blevereth, anything else on the record?
No, Your Honor. Thank you.
Ms. Lewis?
No, Your Honor.
All right. Let me know when you're ready for me. Thank you. Court will be in recess.
All right, chat. Although a straight man's life would never allow him to have that haircut either. No, she probably does. She probably allows him. That's like the one thing she allows. Anyways, we're gonna take a break here, chat. Is this where they? Oh, they have a nice little stretch here. All gas, no brakes. All right.
Please have a seat. Good morning. Thank you for your patience. We'll now proceed with additional witnesses in the state's case in chief. Mr. Burmester, the state's next witness, please.
Dr. Eric Christensen.
Let's invite Dr. Christensen in. Doctor, if you would step in front of Brady, we'll get you sworn in, please.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury? Thank you.
Drag that chair wherever you need to.
Thank you.
Please proceed.
Thank you, Your Honor. Can you please state your full name and spell your last name for the record?
Sure. Eric Dean Christensen, last name Christensen.
Sir, are you employed?
I'm currently self-employed.
Did you were recently the chief medical examiner for the
She's
state
in
of Utah?
custody.
Yes, I retired in 2024.
And
Chief medical examiner. Here we
how
go.
long were you the chief medical examiner?
I began working as a chief medical examiner in July of 20.
Wait, that's all they needed was like 30 minutes talking to this guy? Like they were pitching a bitch about this, and now they're just like, 30 minutes, fuck it, good enough. What the fuck happened? What happened that they were fine with all of a sudden?
16.
Did you then supervise Dr. Ulmer?
I did.
Are you familiar with the death investigation for Eric Richins?
I am.
And how are you familiar with it?
I'm familiar with it from discussions with Dr. Ulmer over the time she was evaluating the case, as well as
Also, Kay said, you said there was a long recess. Was that it? Because it wasn't very long.
my subsequent review of the medical examiner's file.
Did you have an occasion to talk to Kouri Richins?
I did.
Okay. Have you testified as an expert in forensic pathology before?
I have many times.
Okay. I would like to first talk to you about cause and manner of death and the statutory requirement for that process. When you have a death investigation, could you please explain how, I guess, what the manner of...
Chat, let me know if this speaks any louder for you, because I tried using the volume booster, and I cranked it up all the way, but this volume is fucking awful.
death choices are and what's the purpose of that, and just describe that for the jury.
Okay. So two of the things that the medical examiner is tasked with doing under statute is determining the cause of death and the manner of death. The manner of death is a box that we check on a death certificate that is essentially a one-word synopsis of the circumstances surrounding that person's death. The options available to us, we can certify that a death is a natural death. It can be an accident, it can be a suicide, it can be a homicide, or it can be, in Utah, the death certificate reads could not be determined, what most commonly is referred to as undetermined. And in those settings, undetermined essentially means we don't have enough information to decide which of those other four options best fits.
What's the purpose of that whole exercise?
Again, it's something that's on the death certificate, and so it's part of the vital statistics function that the medical examiner's office provides. All of the deaths that we investigate and deaths that we certify provide information then back to the state. Sometimes that's public safety, sometimes it's Department of Health. Other people will utilize that death certificate data to evaluate the ways that people are dying within the state and attempt to intervene to minimize those types of deaths.
In this particular case, were you stuck between the first 4 you mentioned, such that you ended up picking undetermined or cannot be determined?
Yes, again, just to be clear, I didn't sign the death certificate, Dr. Ulmer did, but certainly was involved in discussions around that. And the determination, making a determination of undetermined means that we generally can't decide between two. In this case, I would say actually generally most cases where we certify death as undetermined, it's because in overdose deaths that we certify as undetermined, it's because I don't know enough about the person's own intent. We see it frequently in the setting, for example, of people that may have depression or other mood disorders, and maybe even prior suicide attempts, as well as they may have substance use history that they use to self-medicate their depression and things. And so if someone overdoses on a drug that they're known to abuse, but they also have depression, if they don't leave a note or something else, then I don't really have a means of, telling just from looking at that, did they mean to do this or is it accidental, incident to their normal drug use? That's the most common scenario in which we certify death as undetermined. In this case in specific, we did not really have any concerns about suicide in this case, but there had been concerns related to our office that perhaps someone had done something to provide this to him and that he didn't just take it himself, but we didn't know. We had no idea how he got the stuff into his system. And so with that, we were left with undetermined.
So the choice there would have been, as opposed to accident and suicide, it was accident and homicide.
Correct.
Okay. Could you describe for the jury the way in which the body processes substances? In particular, I'm looking at opiates and the different ways they can be ingested.
Okay, there's a lot in that question.
Yeah, sorry.
Opiates can be consumed in a lot of ways. Even things, for example, like pills that you might get from your doctor for hydrocodone or oxycodone, opioid-related medications, those can be just taken by mouth as they're usually prescribed, but it's not uncommon for us to see people take those pills, crush them up, dissolve them in liquid, draw them up into a syringe and inject them. It's also not uncommon for us to see those pills crushed and then heated, and people inhale the vapors from that, primarily as a means of getting the drug into their system more quickly. And there's lots of other reported ways that people use things, but those are probably the most 3 common ways that we see pills abused. People may directly inject just about any drug that's available in a liquid form. Fentanyl certainly is. Fentanyl is also available in patches and lozenges and other forms. And so it can get into the system in a lot of different ways. In terms of what your body does with it, fentanyl in specific is metabolized primarily by your liver. There's what they call...
Chat, did I make it any louder for you? I was trying to figure out, could you tell me yes or no? I cranked up all the volume boosters I have. Let me know if that made it any better.
A CYP enzyme that is primarily responsible for the metabolism of fentanyl in your liver. That metabolism is felt to be mostly determined by how much blood is flowing through your liver. So the more blood flow you have to the liver, the more rapidly it will be metabolized. There are other ways that sometimes people will metabolize it more slowly, but based on what specific genes they have for metabolism, for that metabolizing enzyme, but mostly it's a function of how much blood is flowing through the liver. And it's then converted very quickly, has a very short half-life in the body, minutes, and is converted to a substance called norfentanyl, which then is eliminated in the urine. Don't know if that...
Yeah, that's great. Thank you. Once it gets into the blood, then what's the intoxicating effect? I mean, how does that function?
Sure. So fentanyl in the blood distributes throughout the body. It's absorbed either through the mucosa, the lining of the mouth, or directly into veins, whenever it gets into the bloodstream. And then from there, it gets into the brain, it gets into other organs, where it exerts its primary effects on the brain and the central nervous system, where it causes respiratory depression and or cessation. Can also cause central nervous system depression, meaning it alters the way you think, can make you groggy or less than normally responsive and things. But its primary lethal effects are related to its effects on your breathing. And it is dose dependent. So a higher dose will do this more readily than a lower dose, but it will either slow or stop your breathing. And sometimes that has lethal consequences.
The lethal consequences then are from stopping breathing?
Yes.
Okay. And when you stop breathing, death ensues. Does that metabolizing process continue to happen, or does that stop as well?
Generally, it will stop. There are, once your circulation stops and blood is no longer flowing through the liver, you're not going to have that continued metabolism through the liver. But there are a number of changes, large number of changes that are described in the way fentanyl is present in the body after death that are related to changes in the pH of the body as you start to decompose and other things that will influence what those levels look like.
When a person, I'm going to give you a hypothetical. So we have a decedent, and in the blood you and the lab personnel determine that there is quetiapine below the threshold of their tools, there is fentanyl at 15 nanograms per milliliter. And then in the gastric fluid, there is quetiapine at about 16,000 nanograms per milliliter and fentanyl at 20,000 nanograms per milliliter. My question then is, based on that hypothetical, is there sufficient information for you to determine whether those two drugs were taken simultaneously or sequentially, and if sequentially, which one came first?
I can't tell you that.
There's just not enough information?
No, you can't derive that information from those values.
Okay. I just wanted to follow up. You said there's drowsiness as a consequence of taking, I assume, opioids of any type. Fentanyl just happens to be stronger?
Yes, fentanyl on a weight by weight basis, 1 milligram of fentanyl compared to 1 milligram of.
Guys, there's no, I don't have any way to do closed captioning. I know Afix does his stuff, but I don't know if he's here or if he's busy. I don't have any apps or anything that can do it. Afix is working on it, but it'll take him a minute. When he does send it, fix it, we'll use it right away. So just hang in there. So let's just keep going.
Oxycodone or morphine is the usual reference standard because it is the classic opiate medication. Fentanyl is just much, much more potent, 80 to 100 times more potent than morphine.
So you said there's depression of the respiratory system, drowsiness. How quickly might one start to metabolize, given the fact that they take some fentanyl and it causes their death? Would they be able to metabolize at least some of it?
You would expect so, yes.
Okay.
I mean, there are a number of overdose deaths reported in the literature where the death occurs so quickly, and these are primarily in the setting of intravenous drug use, that no metabolism is able to be recorded because they just die too quickly. But generally speaking, we see some level of metabolism.
Let me see. I wanted to. But someone takes an overdose, a fatal dose of fentanyl. It's not then instantaneous death.
It depends partly. I mean, generally speaking, no. It's a function of the dose and the route of administration. So it's going to get into the system more quickly as an IV, or smoking will generally get it there pretty quickly as well. But ingestion would delay that somewhat. But however it gets into the body is going to determine how quickly that happens.
In this case, we have the two things. I think one is there's some fentanyl in the stomach, the 20,000 nanograms.
Yes.
And also a measurement of, I know I'm saying it incorrectly, acetyl fentanyl.
Acetyl fentanyl, yes.
Does that information help you determine how it was ingested in this case?
It's suggestive that it's an oral ingestion. The presence of a large amount of fentanyl in the stomach, sort of the rough equivalent of several milligrams by volume is suggests that it was taken by that route, but there's not any way to definitely know that. There is some literature that suggests that the stomach will concentrate it, regardless of where it's from, but it is suggestive of that. And the presence of acetyl fentanyl in the stomach is also consistent with, is more consistent with this being illicit fentanyl than otherwise. Acetyl fentanyl is a variant of fentanyl that is in our office. We've only seen it in the setting of illicitly manufactured fentanyl.
When the body comes in for autopsy, in this case, Mr. Richins' body comes in, is it routine to check for injection sites?
Yes.
And
In this case in particular, there was visible pulmonary edema described at the scene, foam coming out of the mouth, and that is most commonly in somebody who didn't drown or have a history of heart failure is concerning for an opiate overdose, and so we would in that case do a thorough check for those.
Oh, for
injection
sites, and none found.
Again, I did not do the exam. None are described, and none were discussed by Dr. Ulmer.
Okay.
And I didn't see any in the photographs.
When you, in cases where you've seen an overdose death, particularly an accidental overdose death where you suspected inhalation, what's the sort of evidence that you would expect to see?
I'm not sure what you mean, inhalation of the substance?
Of fentanyl or opiates.
Yeah, I mean, they all kind of look the same from that regard. You may see evidence that they've been smoking. Sometimes you see little burns on their fingers or other things from heating it up to smoking, because they're not actually smoking it in the same way that you smoke a cigarette where you light it on fire and then you're inhaling the smoke. What actually is happening is that drug is being heated up and vaporized and you're inhaling the vapors.
So in those cases, do you tend to see evidence of that heating up? That is tinfoil or torches? Or
Certainly, yes, those things can be present at the scene.
Okay.
Commonly arson at the scene.
Okay. Now, is it common for the people who are left behind to call the ME's office to find out what's happening in the case of their deceased person?
I wouldn't say it's common, but it's not uncommon. I mean, I spend a lot of time, most days I was in the office speaking with family members.
Typically, that would be whoever did the autopsy would be talking to the person who's calling?
Yes.
Okay. Dr. Ulmer retired in January of 2023?
Yeah, technically, her last day of work was the end of December of 22.
Okay. And did you receive a call from Kouri Richins then?
I did, subsequent to her retirement.
And did you return her call?
I believe I didn't return her call. I believe she was just put on hold and then connected with me.
Okay. Have you had an opportunity to listen to a recording of that phone call?
Yes, I'm not sure where it came from either, but yeah.
Is it consistent with your recollection of that phone call?
I did not have any independent recollection of it until I heard it, but yes, it's me on the phone call.
Okay. And have you had a chance to look at the transcript of it?
I have.
Okay. And is that accurate to your,
Yes.
when you listen to the
Yes,
tape?
it appears to be.
Okay. State would offer States Exhibit 2-60 and 2-61T.
He's reviewed it. Certainly can ask questions. If he needs his recollection refreshed, I think he could move to admit at that point. But if the state would
Since the state's admitting it as evidence of defendant's words and statements in the relevant time frame.
okay.
And so, okay.
We'd ask permission to publish it, and if it's offered and admitted.
So 2-60 is the audio recording, correct?
Correct.
And 2-61T is the transcript.
Correct, Your Honor.
Those two are admitted. Scott, give me just a moment here, sir. Give that a try.
Okay. I'm going to ask you to listen to this. It's about 9 minutes long, and then I will ask you 3 questions regarding it. Okay. Thank you. Can we advance it 30 seconds?
Okay, thank you
The
so
first
much.
30 seconds.
Okay, sorry about that. I'm going to text you right now, okay? Thank you so much. Thank you so much.
I'm not hearing you.
Did we lose it, Scott?
I think so.
All right, no problem. Let's start over. We're getting quicker at this. Scott, if you would disconnect and reconnect on your end, I'll do the same on mine.
I'm going to text you right now, okay? Thank you so much. Thank you so much. Hey, this is Kouri Richins. Hey, I just have some quick questions for you. I'm just trying to understand the toxicology report, and I promise I won't take up a ton of your time.
Oh, you're fine. You're fine.
Can you just kind of explain to me, I guess, she was saying that this kind of supplemental report, I guess, was left out of the first autopsy, and so nothing has really changed. Do you have it in front of
Right.
you?
I do. Yeah, I got the file here.
Scott, did we drop that again?
Yes.
All right, I apologize, folks. Let's try that again. Scott, if you would disconnect from the system, thank you. Then reconnect, please.
Seeing if you do any additional microscope.
I'm going to text you right so much. Thank you so much.
Is that Chris?
Hey, this is Kouri Richins. Hey, I just have some quick questions for you. I'm just trying to understand the toxicology report, and I promise I won't take up a ton of your time.
Oh, you're fine. You're fine.
Can you just kind of explain to me, I guess, she was saying that this kind of supplemental report, I guess, was left out of the first autopsy, and so nothing has really changed. Do you have it in front of
Right.
you?
I do. Yeah, I got the file here.
So can
Yeah, so
you,
just so you know, so we issue supplemental reports. Like if once the original report's issued, if we do any additional testing, if we do any additional microscopic examination, anything like that, then we include that. And we issue a supplemental report to include that additional information. And sometimes it does change the cause or manner, but in this case, it didn't.
okay, it was just like extra testing done?
Extra tox testing, yeah. So originally the only toxicology testing that was done was on blood. And so then this was additional testing on stomach contents.
Okay, and so is there difference in that, I guess?
Well, they just tell you different things in the sense of, it tells you something about what, was it, is it been there a long time? Is it something a person's been using for a long time?
Okay.
Is it something they ate? Is it something they, injected? Is it, whatever? And there's different things you can learn by looking at different substances. I mean, we fully expected to find it in the stomach. It's just a question of what was there.
So does this tell you like if it was like injected, if he ate it, is that what this? Can you tell from this report?
Not definitively. I mean, it seems like with what the amount that's there that it probably was ingested. Probably taken by mouth.
Okay, and so the 15 ng, like, is that like a substantial amount? Is that like a trace?
That's a lot. That's a lot of fentanyl in the blood. Yeah, that's if people die with half that amount or less in their system.
Okay, so that's quite a bit.
Yeah.
So what's the next one down? The norfentanyl.
This is so fucking weird. This is so weird that she called the fucking coroner's office. Like, I will say that is the one thing I don't understand. This woman is so weird. Yeah. Why? What is she doing? This is so fucking creepy. I just like the whole music. Yeah. So, this is good. Let's keep going.
What is
It's a metabolite of fentanyl. It's what your body changes fentanyl into after you take it.
Oh, I gotcha. Okay. And then, sorry, just the third one, the acetyl. I don't know how you say that.
Acetyl fentanyl.
Oh.
Yeah, that's just it's a form of, it's a variant of fentanyl that is usually only present in the setting of illicitly manufactured fentanyl.
Illicit manufactured, like a pharmacy?
No. Like a lot of most fentanyl that we see that ends up leading people to die these days is related to fentanyl that's manufactured by drug cartels as opposed to by pharmaceutical companies.
Oh, good lord! So this is like more of like a cartel. No, I mean that's not what it is.
You call this the street fentanyl as opposed to
Prescription. Okay, I see. And then is the ethanol? Is that alcohol?
That's alcohol. Mm-hmm.
Okay, and is that like the 279? Is that kind of like a substantial amount, or is that like one drink? Is that 5 drinks?
You can't tell how much it is, and in this case, since the testing was sent, quite a long time after the original autopsy, most likely that's related to, postmortem change, but it could be stuff that he drank. There's not really a way to sort that out. It could be related to decomposition of the stomach contents, or it could be related to stuff he drank. But either way, in the stomach contents, there's no way to know what that level means in terms of, if that was a blood level, that would be the same as a 0.28, which would be, that person would be pretty substantially intoxicated. But because it's gastric contents, you could in theory pull something out and it would be 100% ethanol, depending on if they just drank a stomach full of, if they just drank a bunch of Everclear or something else.
Mm-hmm.
So it doesn't really tell you much about how much they drank or what they drank or anything like that.
I
What
gotcha.
in the stomach, and it's not present in his blood. So
I gotcha. Okay, so it's not present in the blood, just the
Not present in his blood. Interesting.
gastric or whatever.
Right.
Okay,
Yeah.
and then just the last one. What is quetiapine?
quetiapine is an antipsychotic medication. It's called Seroquel.
Okay.
It's a prescription mental health medication that's prescribed for different things.
I gotcha. Okay, and it has like 16,000.
16,000 nanograms per milliliter. Mm-hmm.
Okay, and is that? Quite a bit. Like,
That's a big number, but it doesn't really mean that much. A nanogram is a millionth of a gram, and a gram is not very big. So even 16,000 of them is not a huge amount.
Okay, is there could those have been mixed, or is that not kind of a?
What's that? Could what be mixed?
Quetiapine and like the fentanyl, or is that like a normal, I guess, drug thing? I don't know.
It's not. Most of the time, if we see those together, it's because somebody was taking quetiapine as a prescribed medication and they were abusing fentanyl. But there's do you have any indication he was abusing fentanyl?
No, that's why all of this is just like, what the heck is this and going on? So I guess that's why I'm confused just about all of this, honestly. So I don't know. So I know it doesn't mean anything now, but just kind of something for me to try and figure out, I guess.
Yeah.
And then I'm assuming the acetopin, is that like an aspirin or something?
Acetaminophen, that's just fentanyl. Yeah.
Oh, that's fentanyl too?
No, that's Tylenol.
Oh, Tylenol. I was like, holy shit. Okay.
Yeah.
So just like Tylenol, caffeine, and then the naloxone, I'm assuming is just something that they gave him while he was here.
Probably would be my guess. It'd be somebody that's unresponsive. It's a very common thing for EMS to give people.
Okay. No, that works. So I was just trying to figure out, if this is anything different, if we found out anything new with this up.
Oh, come on.
Pause there. It's okay. We can fix it. Scott, don't change anything. Okay. It seems like if I do this, press play.
Yeah, like she said, it doesn't change anything in the cause or manner of death. It's still, definitely, death from fentanyl intoxication, and we still don't know how we got it into him.
Yeah. I mean, is that anything you could ever find out if it was, I mean, do people normally eat that? Like take it, like, is that something you like shoot?
It's not usually something people eat. Well, that's not even true anymore. So with illicitly manufactured stuff, sometimes people take pills. They have that. So yeah, these days you can't really tell.
Yeah. All right. Well, I appreciate your time. I do. Thank you very much. And
Yep. If you have other questions, don't hesitate to give me a call.
okay. Awesome. What was your name?
Dr. Christensen.
Oh, Christensen. Okay. Perfect. Thank you so much. I appreciate it.
Okay.
Okay. Bye-bye.
Yep.
I'd like to follow up on a couple things there. You mentioned to her about if the gastric contents were blood, it would be 0.28
Yes.
blood alcohol, but it's in fact not in the blood, it's in the gastric. And so there's no way of conveniently figuring out how much it is, much less its source.
That's correct.
Are you okay? Do you need
I've got water. I'm good.
Okay. You mentioned in that call, at first you said, we typically don't see it eaten, but you can't say that anymore. Could you expound upon that? How, in cases where there's pills, is it common to see them eaten?
So yeah, okay, a few things about that. So over time, over I'd say the last 20 years, we saw a rather dramatic change in the deaths we saw related to fentanyl. Until the early 2010s, pretty much all fentanyl deaths were related to prescription fentanyl being used incorrectly, most commonly by healthcare providers and other people who would, have access to it and would abuse it. And it was just not a common thing. We just didn't see a lot of deaths related to that. Once patches became available, which were designed, primarily for, treating cancer patients with bad pain and things of that nature, people became creative with how they use those patches as well. Some people would, put on multiple patches, or they would put on patches and a heating pad to sort of drive it into their system more quickly. Seen people that would smoke them, people that would insert them into their rectum, people that would chew them up. Sometimes we find multiple chewed up patches in the stomach, and certainly other ways have been described as well with patches. But once the illicit drug supply and primarily the heroin supply came to be either augmented and or replaced by fentanyl, we saw we saw much less in the way of the prescription abuse and much more of the illicit stuff being used. And some of that was in the form of what was heroin. Most heroin in this area was black tar heroin, which then became ended up having fentanyl within it. So people that had been heroin users would still be using what they thought was heroin, and it would have fentanyl in it, many times mixed with heroin. Eventually, in some cases was not mixed at all, but was just straight fentanyl. Counterfeit fentanyl pills, or counterfeit oxycodone pills. Fentanyl in pill form made to look like it was an oxycodone pill also became a fairly common thing. And as we discussed before with other pills, people will abuse those in different ways. Sometimes they can ingest them directly, but they can also grind them up and inject them or smoke them. So they can be used in all kinds of different ways. But in the phone call, what I'm referring to, we mostly did not see anybody eating fentanyl. Before illicit fentanyl, with the advent of these counterfeit pills, we saw it somewhat, more often, or would assume that was the route. But we even then, most of the time, don't know how somebody gets the fentanyl into them, even if they have it on their person.
In this case, there certainly wasn't any injection sites noted.
No.
Are there tests, forensic tools that could aid in the determination of whether one is a chronic or habitual or a naive user?
It's a good question. So there's been a lot published on the assessment of fentanyl levels in people that have died, and ways that you can try and parse some of those things out. The bottom line for all of them is you can't look at a number in isolation and make a determination based on, this is a lethal level, so this level has to be the cause of their death. There are certainly people who become tolerant. Most opioids, people will develop tolerance over time, and so they can have very, very high levels and not have the same effect as someone who doesn't take it all the time. We had no history in this case in particular to suggest long-term chronic use, but also didn't know. And there are things that could potentially be looked at to try and assess longer-term use. The only published data I've seen around that revolves around comparing the fentanyl to the norfentanyl level, and levels where that ratio is more than 8 are believed to be consistent with an acute intoxication. Ratios of 2.5 or less are consistent with chronic use. In this case, that ratio is about 4.6, so it's right in between, so it doesn't really provide us helpful information either way.
That's the ratio between fentanyl and its metabolite.
Correct.
As you find it.
Yes.
Have you ever heard of pseudo-allergic reaction to opioids?
Yes.
Could you tell the jury a little bit about that?
Sure. Most allergic reactions are because the body has developed an immune response to some specific protein substance, whether it's nuts or grasses or whatever, pollens of different types, and your body reacts to that and triggers a reaction through your immune system that elicits what we typically think of as allergy symptoms that can range everywhere from, stuffy head all the way up to anaphylaxis and death. In the setting of opiates do not elicit a true allergic response, but there are many people that take opiates who have an allergic-like reaction, but it's because the drugs themselves are directly triggering those cells that cause those symptoms as opposed to going through the immune system route. And so some people will, that chronically take opiates and opioids for pain, will pre-medicate or medicate around the same time with things like Benadryl and other things to minimize those symptoms because they know they have that reaction. Certainly most people that take them do not have that reaction, but some do. And
If one didn't know and one took some opiate, could they have hives and those sorts of allergic-like responses?
yes.
Given all the symptoms that you talked about, the lungs, the edema, and the data from NMS labs, do you have any concern about the cause of death in this particular case?
No.
And the 15 nanograms, as you explained to Kouri Richins, was a lot.
Yes, it's well within the range of levels that we see in people that die from fentanyl.
Do you remember when that phone call took place?
Do I remember what?
When that phone call took place?
I don't off the top of my head.
Okay. Does your office take notes when you receive calls and reply to calls?
Yes.
Okay.
That changed a little bit over the time I was there. It used to be we'd get a little scrap of paper with a note written on it, return this call, and we turned that into a digital log before I retired, but yes.
Would it help to look at one of those notes to refresh your recollection as to when the call took place?
Sure.
May I approach the witness?
Of course.
I better show you. I'm sorry. Do you recognize that, sir?
Yes, this is from the log. Just said that an incoming call came to me from Kouri Richins, and she had questions, and that this is my notes.
And so what day did that phone call?
On January 12th of 2023, a couple weeks after Dr. Ulmer's retirement.
Thank you. That's all I want.
Could I get some more water? Thank you.
Good morning.
Good morning.
We've spoken before. I'm going to ask you some follow-up questions to Mr. Burmisters.
Sure.
I'll start off with that final thing that Mr. Burmister showed you.
All right, chat, here we go. Defense is up. Let's see what happens.
You indicated that you would take calls from different individuals, correct?
That's correct.
And did you receive other calls in this case from law enforcement?
I believe I did, yes.
Would it refresh your recollection, or do you recall a call around the same time in this case?
I don't recall the timing of it.
I'm going to approach you with the same case notes. And it's that first one.
Yes.
And did you in fact receive a call before Ms. Richins?
Yes, the day before.
And was that law enforcement?
It was.
And was that also regarding the supplemental report?
Yes.
Okay. And either your recollection or what's in your notes, do you recall if most of the questions were the same that Ms. Richins asked you on the 12th?
I don't have any specific recollection, but my general recollection was that we discussed the supplemental tox findings.
Perfect. I'll take that back. Now, the questions that we just heard Ms. Richins ask you, very similar to what we're asking today, correct?
Yes.
Okay. I'd like to talk to you about the allergen discussion you just had. You indicated that perhaps an individual could have a reaction like hives.
Yes.
If someone is allergic, in this case to an opioid, as you indicated, does that allergy disappear?
I'm not sure what you mean. Does it go away over time?
Over time or within a certain amount of time? Or
I mean, allergies certainly are things that can fluctuate. People can receive treatment and their responses to different things will go away.
were there hives on Mr. Richins' body, to your recollection?
No.
Okay. We were talking about illicit fentanyl and counterfeit pills.
Yes.
Containing traces of fentanyl?
Milligram amounts.
Okay. Now, the tablets or pills that would contain these traces, what kind of pills would those be, generally?
Objection. The discussion, if we're talking Oxycontin, is that what you were saying?
I've not said it. I've just said pills.
Okay, well, there's no pills that they have that you can make.
Would you provide a little more foundation for your question? Sure, you know what we're talking about.
Absolutely. Your testimony just now was that in your experience, you started to see that fentanyl overdoses were coming in through your office, correct?
Correct.
And in those overdoses, you gathered information, and because you would see that there was a presence of acetyl, I say that right? Acetyl fentanyl?
Acetyl fentanyl.
Acetyl
Acetyl is also fine.
Okay, acetyl fentanyl, that was more likely a result of illicit fentanyl, correct?
So it is a form of fentanyl that in some cases there were a variety over time of different fentanyl variants that were developed. Primarily in response to controlled substance legislation. If fentanyl is outlawed, then we'll add an acetyl group to that molecule, and then it's no longer controlled. And so we can distribute that as a non-controlled substance. And then that one gets controlled. And so then, there were dozens of variants of fentanyl that were developed over time. Acetyl fentanyl was one of the more common ones that we saw early in this wave of progression, but it was one that we saw not infrequently.
Now, with that, what was the acetyl fentanyl contained in, usually in your experience?
I don't recall ever having seen acetyl fentanyl in a substance form in any of our specific cases.
Because it was always inside whatever pill or however it was administered, correct?
I don't even know if it was pill administered. I don't know.
Or injection.
Or I don't know how we would see it in people, but I don't recall ever seeing that correlate with a specific pill that we had tested that was shown to contain that. I know generally the crime lab identified acetyl fentanyl in some pills, but I don't recall a specific instance in my casework where those two were correlated.
Describe counterfeit pills.
Counterfeit pills are essentially illicitly manufactured pills, and sometimes very sophisticatedly, where people will buy the same kind of a pill press that a drug manufacturer uses, and they put their stuff into it and press pills that look very, very similar to legitimate prescription pills. The most common counterfeit pills that we've seen have been fake 30 milligram oxycodone pills that, when tested, contained only fentanyl. And there are also some benzodiazepine pills, things like Valium and Xanax and other things where those, what look like Xanax pills, have also contained fentanyl.
And you just indicated two different things that in some instances, it was purely fentanyl. Those pills contained only fentanyl, correct?
Yep, guys, there are people who try to take, clients like, they bought Xanax, and it was just straight fucking fentanyl, just pressed and colored, and they're popping Xannies, and it's just straight fentanyl. Like, there's all kind, like, that's what you got to be careful about when you're buying drugs. Like, I'm buying cocaine. It could just be straight fentanyl, a little bit of cocaine on it.
Correct.
And then there were other times where perhaps they were still traces, or there were still the other benzos, for example.
Those would be different pills. I don't know. Sure. I'm not aware of anywhere it was both fentanyl and benzos, made to look like benzos that didn't. We've seen counterfeit benzodiazepine pills and counterfeit oxycodone pills, both of which contained only fentanyl.
Correct. Now, in this case, you were provided, or your office rather, was provided with a hydrocodone bottle, correct?
Correct.
Now, that bottle you keep in your office, correct?
We do, until the case is done. Eventually, it's discarded, but yes.
You talked about would it be fair to say that fentanyl, right now you discussed how you would find acetyl fentanyl, and that was one part of it, and then you had to make sure that legislation got that specific one into the books so that it would then become a controlled substance, correct?
Yes.
And so I imagine that was really fastly evolving.
Yes. I was a member of the state's Controlled Substances Advisory Committee that would provide recommendations to the legislature to include in the Controlled Substances Act. And every year for this time from the late teens to the early 20s, it seemed like every year we were adding things. They did eventually make some changes where relatedness became, if it wasn't changed enough, it was still covered. But it was an evolving process. And what we would see in the deaths that we saw related to fentanyl and fentanyl analogs also changed. And
with that, also peer review literature as to the effects of fentanyl, correct?
I would assume so.
That would make sense. You kind of hesitate? I would assume so.
Well, the peer-reviewed literature is evolving all the time, and so I don't know if there's a specific thing you're referencing. I don't know, but certainly initially there was not a lot of, as the fentanyl supply changed from primarily pharmaceutical to primarily illicit. There in the early stages of that, there was not a lot of new literature to look at the postmortem levels in people that have died of this illicitly manufactured fentanyl as compared to the different ways that people used to take it as a diverted pharmaceutical before.
And that's exactly where I was going, the postmortem. These levels that we've been discussing, Mr. Burmester asked you about the postmortem levels, and you received from NMS reference comments, correct?
Yeah, that's part of their report.
Correct. And do you recall what those numbers were in terms of ephemeral blood as it relates to accidental drug overdoses?
I don't recall specifically what the numbers were, but generally speaking, the levels that we see in accidental overdose deaths from fentanyl, overlap the levels that are seen as described with, prescription usage.
And part of the reason for that, going back to the literature, is that there is no, I'm trying to find the right words for it. There's no set number, universal number that the medical community can attribute in terms of what becomes lethal, correct?
That's correct.
Okay. And the reason for that, or part of the reason, and add to this, is both the individual's own use, prior use, if any,
Yes.
perhaps the toxicity or rather the amount of fentanyl in it, correct?
The dose.
In the dose.
Yes. Mhm.
The potency of that dose, correct?
I mean, fentanyl is going to be relatively equipotent, but the fentanyl analogs may have different potencies.
Okay. A fixed fatal threshold. Does that sound?
Yeah, there isn't
Yeah.
one.
Okay. You were discussing the ratio of fentanyl with norfentanyl with Mr. Burmester. Do you recall that?
Yes. Mhm.
I got lost, to be frank.
Not surprising. I'm not always good at explaining as I like.
No, I think it was just going over my head. But tying it together with the postmortem literature out there and this ever-evolving world that unfortunately we're dealing with now with fentanyl, is there any literature on how that ratio can be affected that you're aware of?
I'm not aware of any specific literature that looks at the ratio of fentanyl to norfentanyl in determining, is it a cause of death? Is it a recent, a one-time use or multiple time use? I'm not aware of any literature that discusses that. There certainly has been some literature added over the years to discuss comparing, for example, the amount of fentanyl seen in the heart to that seen in a peripheral site. We call it like something like from the femoral vein to try and assess, things, or looking at other what we call substrates, other sample types, fluid from the eye, testing the liver, urine, other things of that nature.
Let's talk about that. We discussed this when we spoke. You talked about things that looking back, you could have done.
Yes. Mm-hmm.
Could you explain to the jury some of those?
Sure. There is, I guess they say hindsight is always 20/20, but you can certainly. There are a number of things that are in the literature now suggesting that you might gain additional information if you test, for example, urine, which is not something that medical examiner's office routinely does in any case, because what's in the urine is simply a reflection of what has gone on before, and what we need to know is what's in the blood, what's in their system circulating at the time they die. So we don't routinely test that. There is some suggestion that can help you sort out how quickly or not quickly a given death related to fentanyl might have occurred. And then there's been other evaluation of other substances like fluid from the eye, what we call vitreous fluid, as well as liver, and looking at both of those as a means of perhaps augmenting the understanding of what's going on in the blood as well. When you take something, for example, by mouth, it goes through, down into your stomach, gets absorbed, and then anything that gets absorbed goes through your liver before it goes anywhere else. And so an oral ingestion, in theory, might show up as a higher level in the liver than if it's taken IV or something in some other method. So there are other things we could do that would certainly, potentially help our understanding of how the fentanyl played out in Mr. Richins' case.
And you also mentioned in our discussion, the brain, heart, maybe you mentioned blood. Are those also helpful? Looking back again, hindsight.
Yeah. So the brain, there's good literature that suggests the brain takes up fentanyl, and that is the cause of both the central nervous system and the respiratory depression because it's interacting with opioid receptors in the brain. There's not any published literature that I'm aware of that talks about what a given level in the brain would mean. Same with other solid organs. There's starting to be some literature discussing what a liver level might mean, but I'm not aware of any other specific organ sampling sites that might add light to that.
What about hair follicles?
Hair testing in the setting of drug use is primarily used as a means of evaluating drug use over time. Drugs do get taken up into the hair. And when we collect samples to send for hair testing, which pretty much we only do when we're requested to, but you tie off a bundle of hair. They want usually about a centimeter, so a little under half an inch bundle of hair, and we tie it off at the roots, cut it off, and then that gets sent to the lab, and they take sections of it starting at the root going back to see, based on how fast hair grows, how long has this person been exposed to this substance.
And you indicated unless you're requested, I imagine, for example, law enforcement.
Yes.
Okay. That wasn't done in this case.
That was not done in this case.
Now, as we heard, Ms. Richins, she indicated that Eric was not using fentanyl, correct?
Correct.
And there was, going back to the initial conversation or the initial testimony regarding the different categories, when you're trying to really determine what to put down on the death certificate, one of the unanswered question was, well, was he using, correct?
Yeah, that was part of it, certainly.
And in our prior discussions, you've indicated that, at times individuals didn't tell family, correct?
But that would be not uncommon, yes.
Okay. And certainly in this case, a hair follicle test, if it had been requested of your office, you would have sent it out.
We would. I don't know. I think, as I told you, I don't know what the literature says about hair follicle testing for fentanyl specifically, whether that's a useful endeavor or not. I don't know.
Fair enough. Certainly it wasn't asked of you, and certainly you didn't get the results back.
No.
Now, had that been done, had you gotten the results back, and it did show long-term, that certainly would have played into your determination as to the manner of death, correct?
Objection calls for speculation. The testimony has been.
Yeah, I want to have it.
Huh. Ariel's saying, I'm saying fentanyl cocaine is stupid. Yeah, but you're selling to junkies and you'll get them hooked and then they'll start doing fen if they don't die. I mean, they're drug dealers. They're also not the smartest people in the world, too. So, and then my cat's name is Karen says, a nurse friend of mine was injecting it off a patch. You can liquefy patches. People will do that with Suboxone. They'll liquefy Suboxone. Like, you can liquefy Suboxone tabs and then, load up a rig and inject them. So it's not impossible. It's not easy, but you can do it. You can do it. You found her dead at a shift change in the bathroom at the hospital. Whoa. Well, that's one way to go. It's one way to go. So, this is getting to be a pretty good discussion here. Let's see how this keeps going.
You are not aware of a hair follicle test in your experience being done for fentanyl.
I'm not.
Okay, you don't know if it can be done.
I do not know.
Had a hair follicle test just for any drug, including fentanyl, any just hair follicle test to be sent out to see if there's any type of drug use whatsoever, your office would have done that, correct?
Overruled.
If we were requested to, that's certainly not something we would ever routinely do.
Absolutely no, and I'm not implying that. And to be fair, the reason you wouldn't do that is because your office is tasked with what's at hand, which is what do you have in front of you to determine the manner and cause of death, correct?
Correct. Why is this person dead right now,
Correct.
as opposed to some other time?
And in terms of your checklist, the hair follicle just doesn't come in terms of what you do, correct?
I mean, it can, or it could in theory, but yeah, mostly no.
But if it were to be requested of you, you would or could do it.
We could.
Objection, I think the answer was for this particular,
What's the objection, Mr. Burmester? Asked and answered.
asked and answered, and calls for speculation.
Sustained. Okay, ask a different question.
So I'm going to go back with all that in mind. If you send out a hair follicle test, is your practice generally, when you receive the results of said hair follicle test, to use those said results in your determination of whether or not to change a manner of death?
They would be part of all the information that we look at to come up with our final cause and manner of death. Yes.
Thank you for that. Fair. Mr. Burmester asked you about the sequence of items that were ingested or not ingested. Do you recall that?
Yes.
You indicated that there's simply not enough information at hand to be able to determine that, correct?
Yeah, not just from this case. In forensic toxicology, generally, you can't tell when something was taken just based on a number.
And that's what I wanted to make clear, whether it was just in this case or just generally.
Generally, you can do that.
And that means that there are no tests or nothing else that you can go back and do to make that determination, correct?
Correct.
Bear with me, I'm almost done. Okay. Now, in your involvement in this case, something unusual did occur in this case in terms of the investigation, correct? In terms
You
of,
have to be more
I'm sorry,
specific.
yes, I will.
Yeah.
In terms of,
talking about,
I'm going to refer.
We're about to find out.
Yeah, I apologize. Poor question. I'll start all over. We saw your case notes.
Yes.
And there you spoke with one law enforcement officer, correct?
Yes.
Now, you also received other communications from other law enforcement officers, correct?
I believe so, yes.
And do you recall being invited to a meeting to have a discussion about this case?
Yes.
And do you recall if the DA was involved in that case?
I believe so.
And other prosecutors, correct?
I believe so, yes.
As well as other law enforcement agencies, correct?
I don't know.
And that was unusual in your practice.
It's not common. It happens, but not commonly.
Okay. No further questions. Thank you so much, Doctor.
Mr. Burmester, within the scope of cross, please. Oh, my apologies. Maybe not yet.
Apologies.
You have some more, sir?
Yes, I do.
Okay, very good.
We're good, Judge. Thank you, Doctor.
Thank you, Mr. Burmester.
just trying to figure out this meeting you said. Is it the one you testified earlier when you got a call from law enforcement?
I believe so. From my notes that were in the log that I looked at, I was invited to a meeting. It was
Yeah, that was pretty
my
good
recollection was some
cross.
sort of virtual meeting. I don't know if it was WebEx or Zoom or whatever. And I believe it was with Mr. Hemingway's computer, but there were other people in the room who
You
were
don't-
introduced to me, but I don't recall exactly who was.
You don't know who that was.
I don't know. I couldn't get
And
it.
when defense counsel says the DA, presumably the Salt Lake DA was not interested in this case.
I think it's DEA.
DEA.
Oh, yeah, I don't recall. I misunderstood that. I thought I was asked DA as well.
So my apologies. I want to make sure I don't get involved in confusion here. Would you please clarify what this testimony is?
I think you've said you received notice to attend a virtual meeting and law enforcement was there.
Yes,
And you don't know who specifically in law enforcement was there.
besides Mr. Hemingway, no.
And this was the day before Kouri Richins called.
That's what the log says. I don't have any recollection of that specifically.
Hydrocodone doesn't look like this M30 you talked about, imprint of M30.
No, I've not seen any counterfeit pills made to look like hydrocodone pills.
In this case, there were no traces. That is, you testified there was a lot of fentanyl in the blood.
Yes.
And there was no traces of anything else related to fentanyl.
In the blood, yes, correct.
These other things you talked about, urine, vitreous, liver, brain, heart, blood, none of those, based on your understanding of the literature, et cetera, would give you a definitive forensic proof of long-term use or not long-term use.
Definitively, no.
I have no more questions.
Mr. Ellis, anything further for Dr. Christensen?
Yes, Judge, 1 second. I apologize. We're good. I apologize. Thank you so much. Thank you, Doctor.
Is this witness released, counsel?
Yes.
Yes.
You're free to go, sir. Thank you. Please watch your step.
Mm.
Let's do this. You want to keep going, counsel? Or you want to take a rest break?
Your Honor, may I just confer briefly with?
Of course. Yes.
I think this is correct, Luke. It comes down to which drug-addled piece of shit do you believe? Robert Crozier or Carmen Lauber? It's going to be your call. It's going to be your call, chat. Which piece of shit do you believe?
Your Honor, this might be the time for a break.
Okay, folks, let's take a rest break. Please rise for the jury. Please have a seat. Mr. Blevin.
Your Honor, back to the video of the May 4th, 2023 interview. I think, and I want to be informed, defense had a chance to review it, but we'll still have an objection.
Ms. Lewis, please.
Yes. Your Honor, we still object on 2 grounds. One, we still hearsay. There's not only just the statements of Mr. Crozier and Detective Davis and Detective, I think Hamilton maybe was the other one there.
It was Ben Carino.
That's okay. That's fine.
I'm certain it was Ben Carino. You can think all you want. It was Ben Carino.
All right.
We have law enforcement side, and then we have the Mr. Crozier side.
Right, but then we
Hi,
also
Jorgen.
have law enforcement making statements to Mr. Crozier, statements from Nicole Cummings and Carmen Lauber, so there's those hearsay statements in there also. And the other thing is, it says that it can be admissible under 801D if, when the person's subject to cross-examination. I know Mr. Crozier was subject to cross-examination, but he's no longer subject to cross-examination. It seems as if this video should have been introduced prior, because then we would have had the opportunity to show persons the video and cross-examine them on video. That opportunity is now lost.
Why?
Well, he's been released from his subpoena. We don't know if he's been out talking about the case. I suppose
You could ask him about that, but he's not unavailable.
well, that's correct. We can subpoena him and bring it back in. That's true. But
And I just want to make sure I understand the procedural history here. Defense had the video, right?
yes,
To the extent it had wanted to cross-examine him regarding the video when he was on the stand, you had the opportunity, and there may have been good reasons to not do it at the time.
well, the main reason was he had no memory of it, so that made it difficult.
That's exactly the condition that triggers 801D1A.
Well, 801D1A is if there is inconsistencies in it.
Or has forgotten.
Now, if you report, no, no, no.
I mean, I think that is the basis to have a discussion regarding admission of the video, his side of it, right? Under 801D1A is that he was testified numerous times under oath in open court that he couldn't remember the interview, even to the extent of saying that piece of transcript does not refresh my recollection.
Correct.
So I can instruct the jury to not consider anything other than Mr. Crozier's statements for the truth of the matter, that they can only consider the law enforcement have for context, as to provide context for why Mr. Crozier is responding. Other than that, any other hearsay concerns?
No, no other concerns.
Any other concerns?
No.
Yeah, 2 reasons you said.
Yeah, I gave them the hearsay of the other people.
And, okay.
Subject to cross-examination
All right.
on video.
Okay, Mr. Bloodworth, anything further on that?
No, Your Honor.
How would you propose we do this, Mr. Bloodworth? Play the video with the scrolling transcript for the jury nowish?
Yes, Your Honor. Maybe in 5 minutes-ish.
Sure.
Stay drink a lot of coffee.
No, you and I both. Let me make a ruling here and see if either side needs clarification.
Yes.
Mr. Bloodworth, as I understand it, the state seeks to admit and publish to the jury a 13-ish minute audio-visual recording of Mr. Crozier's interview with law enforcement in May of 2023. The recording is accompanied by the transcript that plays below the video in real time. Is that correct?
That is correct, Your Honor. And it is labeled 8-64 D as in dog.
Okay.
864.
Thank you. Having had the opportunity to listen to Mr. Crozier's sworn testimony in open court, and given that defendant had the opportunity to cross-examine Mr. Crozier when he was on the stand, has had the video, and that there's no evidence before the court currently that Mr. Crozier is unavailable to be re-subpoenaed and brought back into the courtroom by defense if they determine it's necessary to do so. The court determines that Mr. Crozier's half of that interview with law enforcement from May 2023 is admissible as categorically not hearsay under Rule 801 D1A because he testified under oath that he couldn't remember the statements he gave during that interview. And therefore, the statements that he makes in the interview qualify as statements regarding which he has forgotten, quote unquote. The court will instruct the jury that they cannot consider any portion of the law enforcement side of that interview for the truth of the matter, which resolves any hearsay issue with regard to the law enforcement half of the interview. Mr. Bloodworth, any clarification?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. It will be 8-64D as in Delta is admitted on that basis. Let's take a 10-minute break. This clock in here shows 20 of 11. We'll come back at 10 of 11. Thank you.
Before we
Yes.
Can we get this line up just while we're
Now, chat, I hope that made sense there because they were trying to argue his statements made to the police are hearsay. And to Judge point out, you've had a chance to cross-examine him. You could have cross-examined him over this stuff when he was here, or if you really, really want to, go out and subpoena him and bring him back in if you really, really need to. That's, it's different when it's a witness you have, you know he exists. But more importantly, Crozier says he doesn't even remember it anyway. So I don't know what value he's going to give to it other than saying, yeah, that's my voice. I don't remember saying any of this.
we can take advantage of that and prepare for
Who's coming in?
Yeah, it hasn't changed from what I emailed you on Saturday, so I think.
Okay, perfect.
Yeah.
All right, folks, 10-minute break.
Anyways, hi,
Thank you.
Texas Farm Girl. Hi, TM. Hi, Maddie. You get mixed up between me and the live. Yeah. Why did the state have to refresh his memory when he was on the stand? They didn't have to because he didn't need to. I mean, they asked us some basic questions he knew the answers to because they probably went over those answers with him ahead of time. So that's probably why, if that's what you're asking here. But yeah, he didn't remember what he told the cops, but he probably remembers enough of the basic background information. Maddie says he knows why we haven't seen the police interview. Okay, well, I don't know yet why. All right, here we go, chat.
Mr. Woodworth, I understand, will be admitting State's Exhibit 8-64D, a recording.
Clyde signs
of
life.
a
Let me see if I'll
May
get him.
2023
Clyde!
interview with Robert Crozier. Is that correct?
That is correct, Your Honor. The state moves to admit and publish
Hey, Clyde.
8-64D.
Ms. Lewis, any other objection other than the one I've already ruled on?
No,
Bubba.
Okay. State's 8-64D is admitted.
Come here.
We'll get that queued up now.
Come here. He just looked at me and turned around. He's like, not today, fat man. Not today.
Please proceed.
Robert, how are you? Good.
No.
I imagine you are. We'll get to why we're here in just a minute, real quick. Let me see a little basic information from you, okay? How about an address for you? 60 East, 350 South. South, what city?
Robert, I'm so sorry. You were going to give an instruction?
That is true. I appreciate that. Thank you for the reminder. Ladies and gentlemen, Mr. Crozier's side of this interview, this conversation, you may consider that for the truth, give it as much weight or as any as you determine it deserves. There are other speakers during this conversation. So the other side of the conversation, there may be 2 or 3 other people on the other side of the conversation. You cannot consider any of what they say for the truth. The only thing you can consider them for is to explain why Mr. Crozier is responding or to provide context for his responses. But the non-Robert Crozier side of this conversation is hearsay that cannot be considered for the truth. Anything further, Ms. Lewis?
No, Your Honor.
Okay. Please proceed. That's all right. I'll fix it. Scott, please give it a try.
And the phone.
Yeah, I'm going to get to that. We'll get to that in a minute.
We'll get to it. I know you haven't, but you've had involvements with people in some kind that we're looking at. That's what we're talking about. Phone number for you, Robert.
385. I can even tell you if you right now.
Okay.
I like my phone doing this.
Okay. Tell me your phone number then. Yeah. Okay. So we'll get to why we're here to talk to you in just a minute. But before we do that, I'm going to advise of your rights because you're obviously in custody here in jail, okay? So you have the right to remain silent. Anything you say could be used against you in court. You have the right to talk to an attorney with you during questioning if you wish. You can't afford to hire an attorney won't be appointed for you before questioning. If you decide to answer questions now that having a lawyer here, stop questioning you anytime there's no lawyer. There's no rights I explained to you. Having the rights of you want to talk to us today. Okay. So we're here to talk to you about a transaction that you made a little over a year ago with a female named Carmen Walker. Then Nicole that you're in touch with. You met her at a Maverick and Draper on 2 separate occasions in February of last year, so a little over a year ago.
Okay. It's not ringing a bell at all. She's in the
Okay. Well, let me give you a little more information. And so we talked to Carmen, we talked to Nicole. We talked to Nicole yesterday. Got her phone and downloaded everything we got from her phone. You sold Carmen blues on 2 separate occasions there at the Draper Maverick. As a result, somebody died from that transaction. So we're not interested in jamming you up or anything like that. We're simply here for information. But we know that you sold those, and we can prove that through cell phone records and that kind of stuff. But right now, your information for us is more valuable than you being charged federally with selling fentanyl. Like, now you're going on some drug stuff. Do you know anything about the federal rules with fentanyl and 30s? And
I don't know anything. I know you have that distribution of cop 30 in December.
the M30s?
Yeah.
Okay. So tell us what you know. Like I said, right now, your information is more valuable, but at this point, we can prove. We know that you met with Carmen that Draper on 2 separate occasions. Sold her fentanyl. That fentanyl is then used in a death case, basically. So we tracked it back at this point. But we're not interested in jamming you up. We're here to try and corroborate information. About
I don't know
what Carmen and Nicole have already told us. So you're in a position right now of either telling us what you know about it and basically not hurting anybody because Carmen and Nicole have both already talked to us here and you're verifying information we have. Or if you don't want to talk to us, that's fine. We'll pursue it federally because we know that you sold them the fentanyl that resulted in death. So that's kind of where we're at. And I'm not trying to bullshit you. I'm just kind of laying it out exactly how it is right now.
So I know who Nicole is.
Okay.
I got it a year ago.
February 5th and 25th is when Carmen messaged Nicole. Nicole gave her your information. Then you guys set up 2 transactions at the Maverick and Draper.
Of last year.
Yes. It's not this previous February.
Only the most honest pen dealer.
Yeah, so like this. So like this. I'm not trying to be a different type of nothing. So remember that much time passed. And do you have a number that she bought for me? Was it a quantity?
She said between 20 and 30 pills both times.
Okay. Then probably. Yeah.
Do you remember going to that Maverick and Draper? Were you living down there at the time? Or?
She lives. I want to say she lives pretty far away.
She lives in Heber.
Yeah, so like that was just one week.
Where were you coming from? Where were you living at the time?
I've been living a little bit everywhere. Okay. Maybe the last couple of years.
So it's kind of bringing back, you kind of getting a little bit more. Well, tell me what you can remember about them.
I remember Nicole called me and saying, "Hey, can you be my friend?" And I was like, "Yeah." And then she was like, "Oh, she wants a lot." And I was like, "All right."
Is 30 a lot for you, or is that a lot for Nicole?
I think it was a lot for Nicole, but a lot for me. But I was like, I didn't know anybody died. You know what I mean?
Yeah, and we didn't expect you to do that. And like I said, that's why at this point, your information, we're not interested in jamming you up with the distribution or anything like that. We're doing our investigation. You're kind of just on the edges of it a little bit as kind of an involved player as being a hook basically for it. We're not interested in jamming you up or anything like that, but we are interested in the information you have to provide to us. That validates what people have already told us.
Okay, as far as I know, I met her just 2 times. I think I talked to her a couple more times after, but just to see, you know what I mean? Hey, because somebody's spending, you know what I mean? $500-600
Is that what they're around about $500-600?
Yeah,
so, okay. And did you hit her up afterwards to see if she wanted more, or did she hit you up afterwards?
I think I asked her one other time, but then she just didn't.
She's like, "Hey, you looking for any more?" Or something?
Yeah, something like that. She didn't respond to me. You know what I mean?
Do you remember how you contacted her? Was it through text messaging, messenger?
Well, I think it's text messages, but I haven't had that bad. I think it was on the longest time.
What phone would it have been on?
My phone. Fuck. Maybe a 3361569.
You still have that phone? Okay. The phone you have now is a newer one then? Yeah. Okay. So you contacted that Carmen at all? That phone or anything? Do you know where that old phone would have been that would have those text messages on it?
No, I lost that phone. A lot of it.
Okay. What do you think the phone number was you said?
385-333-615.
Okay. So with these transactions, when Carmen hit you up, what did she tell you?
No, she told me she had a friend. they wanted, you know,
Well, did she ask for blue specifically or fentanyl specifically, or did she ask for oxys, or what did she ask for?
no. I think she might have for blue. I can't remember.
But you sold the M30s, right?
Yeah, I told her what she knew what she'd buy.
Okay, so she wasn't like she's asking for oxy or something like that. She got the M30s.
Right, no.
Okay, so she knew that there was fentanyl in those pills. Okay. Do you remember where you got those pills from?
I don't.
Okay. What else can you tell us about that? That's all we're here to talk to you about was that transaction, those two transactions, I guess, a little over a year ago. We don't care about anything else, but what else can you remember about those?
She was with the older guy.
You remember what kind of car they showed up in?
No. One time it was like a truck. A little white truck or something.
Okay. When you say she was with an older guy, do you remember about ballpark how old he was?
I don't know. These probably basically.
You thought maybe one time in the truck, but you couldn't remember the other one.
I was never in the car either, so I don't remember what car.
Okay.
The first time she was in the truck for sure.
When you guys would show up at Maverick, where would you go? Would you run back to Maverick or just run there in the box?
Yeah.
Just to put your hand to hand.
Yes, there you go.
And you said about $600 or so. What you charge for those? Okay. Do you remember? So I think she would have ordered more the second time. Do you remember the quantity?
I don't remember the exact.
Maybe remember meeting her twice.
Yeah. Okay. I really remember meeting her twice. She told me that, so I thought it once.
But do you remember now? They're kind of jog your memory.
Yeah.
Okay. Do you think of anything else about those meetings with her or anything?
No, that's the only 2 times I talked to her.
Okay. How do you know Nicole?
Did in camp. I was staying with him really for a while, and then she stayed there for a while, and then she took off. And then camp to fucking middle. We all go take another one. So.
Okay. So Nicole just hit you up and said, "Hey, would you want to be with my friend?"
Yeah.
You're like, "That's cool." When you were in the apartment. Did she call you or text you?
I believe she called me.
All the time, or just that one time? Or
I think she would like say like 2 take like hey, what's up, and then one was probably the other one.
like Nicole's friend or whatever.
Yeah.
Okay. All right. How long?
I'm going to slow this down, chat, but wow, this is a little different than what we were told. This is a little different of a interview than what he counted in court, don't you think?
How long was your Nicole's friend or whatever?
Yeah.
Okay. All right. How long was your
I think she would like say like 2 take like hey, what's up, and then one was probably the other one.
Oop, would you press pause? We'll fix that. Yeah. My apologies. Go ahead, Scott.
Out there, or drug court or some shit, whoever she was living. She was on, yeah, she did run APNP or on drug court or something. I don't remember, and she had to hurry. It was always in a hurry. Like she was like, okay, well I'm leaving here now, so I can meet you like halfway. Can you meet me halfway? Oh yeah, I can do that.
And halfway was that Maverick there?
Yeah.
Very first.
Yeah.
Okay. You said one time she came with an older guy. Do you remember if that was the first time or the second
I
time?
believe it was the second time.
First time, do you remember she showed up with anybody?
I don't know.
Okay. Okay. I think those are all the questions we had for you. If you have any more follow-up questions, you want to talk to us again as we kind of progress with this a little bit further?
Yeah.
Okay. I appreciate you talking to us, Robert. Like I said, we're not here to jam you up over anything. We're just here to try and get some information and see what you
Might
got.
fucking one day wake up with some fucking manslaughter charges.
No. We're not going to pursue that. Like I said, if you didn't want to help us out or anything, we kind of have this for you right now that the people we're interviewing, we've got enough information and we're just trying to verify it. You're kind of either helping us out or you're not. And if you're not, you might, honestly. But all you've done right now, so we've already talked, Carmen's already talked, and Nicole's already talked. So you're not telling us anything we didn't know. You're not protecting anybody by not talking to us. All you'd be doing is basically rolling the dice with your future if you didn't want to talk to us. Because when the deaths are involved, the prosecutors do get a little spun up over it. And with fentanyl in the federal system, if you don't know this, if you get caught dealing fentanyl that results in death, you could potentially face federal charges. It doesn't matter if you intended to cause the death or anything else like that. They're cracking down on it. So I don't know how long you're in for with. I know you're on possession with the 10 stuff, but if you are still dealing, don't be dealing with that shit anymore because the feds are coming down hard on it. And it's only a matter of time, especially how nasty that shit is.
And these, most of this gave me my name. Well,
we already verified it through phone records. We already knew that they got it from. It wasn't like they told us anything we didn't know either.
Yeah.
We've been able to find everything we need through digital evidence and all the contacts, all the messages on Facebook, and all that stuff.
Yeah, we knew all of that before we made contact with anybody.
Yeah. So it wasn't like they were diming out or anything.
Yeah, but I don't think me and Carmen even were friends on Facebook.
We actually were the ones that brought up your name to Nicole because we already knew that Nicole had put you in touch with Carmen, and we already knew all of that information. So we're just trying to verify stories is all we're trying to do at this point. So, do you have any questions for us or anything like that?
Other than is he gonna backdoor me here?
No.
All right.
We're not here to jam you up or anything like that. We don't give a shit about what's going on down here or anything like
I
that.
was just going to ask you, do any of your people ever tell you what they're going to use it for themselves, if they're going to try to sell it to anybody else, what their intents are?
Everybody that I deal with does it themselves. You know what I mean? Like I do it myself, they do it themselves. You know what I mean?
Okay.
So it's
Did Carmen ever mention anything about hooking it up for somebody else or anything like that?
like I said, like she was just I met her twice. You know what I mean?
Yeah, and I figured it was a long shot. Twice you met her a year ago. I knew it was going to be
Yeah.
a bit of a stretch for you to remember. But
Okay.
anything else you can think of, or anything else you remember?
No.
Okay. As you think about it, if you do think of something, let one of the COs know or one of the investigators at the jail know. They'll reach back out to us if you have anything else you want to talk to us about or anything like that. Okay. Any other questions or anything like that for us? Okay.
Thanks.
Okay, well, all right. We'll go grab the CO and let them know you're ready. Okay.
Mr. Bloodworth, the state's next witness, please.
Your Honor, the state calls Molly Cross-White.
That was very interesting. That was very interesting. That was super interesting. Yeah. Well, a little different than what he told them. I mean, is it like Kouri's going to jail from this? No. But still interesting to me. Let me see if there's any fucking like change to the closed captioning yet. No. Okay. Well, that was gay. All right, here we go, chat.
It calls Molly Cross-White.
Oh, god damn, that got loud. Hold on. Jesus. Hold on, chat. I gotta turn some sound boosters down. God damn. Damn, that got loud.
W-H-I-T-E.
Yes,
Do you know who Kouri Richins is?
not personally, but through this trial, yes,
Okay. Did you purchase a home from Kouri Richins?
I did.
When did you purchase that home?
It was January 26, 2022 is when we closed on that property.
Scott, can I get 8-12, please? Your Honor, permission to publish. This has been admitted already.
It's up.
No objection.
Ms. Cross-White, do you recognize that house?
I do,
Is that the home that you purchased from Kouri Richins?
yes.
Did you ever move into that home?
No,
Did you rent that home?
I did.
When did your renters occupy that home?
They moved into the property March 30th of that year. Their lease began March 1st, but they did not move here until the 30th.
You said you closed on that home, I'm sorry, the 26th or 27th?
I think it was January 26th.
January 26th, 2022.
Yes,
And was that home occupied between the date of the closing and the end of March when your renters moved in?
it was not.
Were the locks on that home the same as they were on January 26th when you closed to the time your renters moved in?
They were the same.
And did Kouri Richins rehab that home for you?
Prior to us purchasing it, it's our understanding she had done a renovation.
And did she have the keys to that home throughout that renovation process?
I would assume so.
Am I right then, as far as you know, that home was unoccupied between January the 26th, 2022 and the end of March 2022?
That's correct.
Thank you, ma'am. That's all the questions I have.
Yes, Lewis.
Good morning.
Good morning.
So, excuse me, I grabbed some water. So before you closed on the home, you entered into a real estate purchase agreement,
That's right.
right? And can you pull up Defense Exhibit 1024, Katie? Thanks, Alex. Ms. Crossway, do you recognize that as the real estate purchase contract that you entered into?
Yes.
And do you know the date that you entered into that?
Looks like it was January 14th, 2022.
Murder, we move to admit Defense Exhibit 1024.
No objection.
Defense 1024 is admitted. Would you like to publish?
Sure.
Okay.
And then, Ms. Crosswhite, you closed on the home January 26th, was your testimony.
Yes.
Between January 14th and January 26th, did you do a walkthrough of the home?
Yes.
And what was in the home at the time that you did the walkthrough?
The home had been staged when they were marketing it for sale. So at that time, there was furniture in it. I think by the time we did our final walkthrough, which was a couple of days before we closed, all of the furniture had been removed from the property.
Was there anything else in the home once the furniture was removed, such as boxes?
Not that I recall. I don't remember exactly what was still there, but I do know that we had wanted the home to be fully vacated and all of the debris, and there was some garbage and things on the premises, like old cars even, that we had asked to have removed.
So do you recall if there were any boxes or cups or any items left in the closet of the home?
I don't remember.
Had there been, would you have asked that that be removed when you did the walkthrough a couple of days before closing?
I think that if it was something significant that we would really notice as a bunch of garbage or something that was going to be troublesome for us to remove from the property, we would have asked for it to be removed. Like a small item like a cup, I can't say would have stood out.
All right, that's fair. Now, you said the renters, their lease began March 1st. They didn't move in until the end of March. But was there work being done on the home during the time you closed and the time the renters moved in?
There was.
And particularly, was there work being done throughout February of 2022?
Yes, I think I provided a list of dates that was on record with our contractor. I think there was maybe 7 different days in February when there were contractors working on the property.
Okay, would some of those dates have been February 10th, 11th?
Yes, that sounds familiar.
12th, 13th, and 14th? Does that sound familiar?
Yes.
All right. And you think there were additional dates other than those 5?
I think there was 2 more dates the following week, maybe that the 19th and 20th, if that's, I'd have to look back at the records, but according to my contractor's records, there was 2 more dates in addition to those 5 that you named.
Okay. And when they were working on the house, do you know if they were there all day, most of the day?
I don't know how long they were there. We were having things like insulation added into the attic and mortar added to the pot rock because there was animals coming into the home and things like that. We need to get it ready for the tenants.
Okay. When you closed on the home, did you take possession of the keys?
I think that the key that was provided for us to access the home when we toured the property and made our offer remained at the property. I can't remember if it was hidden underneath, like somewhere at the front door. And we left that same key there for our contractors to use while they were working on the property.
All right. Did they keep the home locked?
I don't know.
Did you ask that they kept the home locked?
I would expect for them to. I mean, that's the point of a key.
Right. And the key wasn't in a visible spot. True.
No. I remember us having it hidden somewhere near the front door, maybe under a pot or under where anybody would think to hide a key. Probably not a great place to hide a key.
And it was your expectation the home would be locked throughout that time?
Yes.
Is that fair? All right. After you closed on the home, did you have any further conversations with Ms. Richins?
No, I never had any conversations with her directly. She was represented by another real estate agent.
Did you have conversations after you closed on the home with that agent?
I doubt it. I can't remember, but I would be surprised if I did.
Would you have told them the work that was going on in the home and who was in and out of the home? Would they have been aware of that?
I think that prior to us closing on the property, we definitely communicated our plans. It was part of our negotiations because we discovered quite a bit of work needed to be done in addition to the renovation that Ms. Richins had done. So I definitely had communicated, hey, we're not going to be able to rent this out the way that it is. We need, I think it was a $10,000 credit so that we were able to, complete the renovations in a way to make the home habitable.
Okay. And is there any reason they would have known the Ms. Richins or her agent they were talking to when, in fact, renters were moving into the home?
I don't know if we shared that or not. I know that we definitely communicated we could not rent it out right away. And we had to take care of quite a bit before we felt comfortable having people move in.
All right. About 1 moment. Do you recall Ms. Crossway being interviewed by Mr. Bertram, in this case, the defense investigator?
Yes.
And do you recall telling him that when you took possession of the house, there was nothing in the house at that time?
Yes.
All right. And do you recall telling him at that time that you actually turned the key over to the contractors?
I don't remember. I never met the contractors on site, so I'm sure I did communicate to them where the key could be found on the property.
All right. Nothing further.
No, Your Honor.
You may step down. Is this witness released, counsel?
Yes, Your Honor.
Yes.
Okay, you're free to go. Thank you. Mr. Blower.
This is
Oh, sure. I shouldn't make assumptions. I apologize.
Allison Wright, Your Honor.
Let's do it.
that really didn't do much for me, chat. So, anyways, hi Joe. Yeah, that's really that didn't really. There's no aha there for me. Maybe for some of you, but not for me.
Yes, if you step in front of Brittany, we'll get you sworn in right here, please.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
Good morning.
Good morning.
If you could please state your name and spell your last name.
Allison Wright, Wright.
Ma'am, where do you work?
C&E Stonemasonry,
How long have you worked there?
since established in 2010.
Did you know Eric Richins?
Yes.
How did you know him?
I first met him in junior high. He was a friend of my sister's. They were both in high school. He spent time at our house, and eventually we ended up in high school at the same time.
And is your husband was his business partner? Is that
Yes.
correct? Did you know Kouri Richins?
Yes.
How did you know Kouri Richins?
When I met her when she was dating Eric.
I want to talk with you about a couple of handwriting items before I ask you a few other questions. That states Exhibit 8-49 for the record. Sorry, I've got too many things on my podium here. All right. So I'm going to hand you this booklet. Okay.
So it's very clear she's gonna fucking hate Kouri Richins. This is not a very supportive witness for Kouri. This is probably about as anti-Kouri other than the sister-in-law.
If you could turn to tab 4
Oh.
for me. Do you recognize those items in tab 4?
Yes.
Is it, and if it's multiple pages, you can look through all the pages. Is it just the one page?
There's multiple pages.
Okay, and the first page is the one that you recognize, is that right?
Correct.
And go ahead and turn to tab 12 for me.
Okay.
And do you recognize those items?
Yes.
What are, in tab 4 and in tab 12, what are those items?
They are returned checks from C&E Stonemasonry's banking account.
And are those checks that you gathered and gave to Katie Richins Benson?
Correct.
And you gathered those from C&E's accounting books and things like that, their bank records?
Correct. The check on tab 4 was collected on an online banking, and the other ones were printed checks from our files.
What do you do for C&E?
Admin and bookkeeping.
Okay. So I want to switch gears. I want to turn your attention to February of 2019. Do you recall that time frame?
Yes.
Was there a time in February of 2019 that you took a vacation with Eric Richins and Kouri Richins and your families?
Yes. No, just the adults.
Just the adults. Okay, no kids were there. And do you remember a conversation during that trip with Kouri Richins that stood out to you?
Yes.
Go ahead and describe for the jury what you remember about that conversation.
On our vacation, Kouri and I ended up alone for a moment and just talking about our families, life, kids.
Your Honor, objection, can you approach?
Yes.
All right, chat. This is yes, I like the idea of we were friends in high school. Like, there's nothing wrong with saying yes. When we were in high school, Eric bawled me out repeatedly. Like, there's nothing wrong with saying that. Just say it.
Up and stretch your legs. One leg out of quarter. Please rise for the jury.
Yes, it sounds. Yes, this also could be another Karen Reed Aruba story. Yes. Yeah, I'm sure that they were fucking.
Please have a seat. We're still on the record. Ms. Shrivniak, if you would just ask your next several questions, we'll see where this goes.
Certainly. And so now.
So we're just go straight into voir diring on this one, chat. Let's see. Let us see where this goes.
We're outside the presence of the jury. We're just going to get a preview of how you would answer the question that I just asked you. So describing what you remember from that conversation with Kouri Richins from the vacation.
While we were sitting there, we were discussing life, and Kouri then explained how things weren't super great in her marriage, how she felt trapped. She explained to me that there was a prenuptial agreement that was put in place, and I'd never heard of that. She continued to say how I think the trap was mostly due to financial, is Eric would, because of the terms of the financial agreement, Eric would end up benefiting financially and continue to live as they currently were, where she would be in a different circumstance. She explained how she feared that the kids would be drawn to Eric's life and felt like she was unhappy in there, but feared what it would look like if she ended the marriage.
And is it okay if I ask a follow-up question?
Of course.
Did that conversation kind of give you context or inform you about Kouri, kind of what she was doing with her business at that time?
Yeah, things started to make sense. Like, I was impressed that she went and got a master's degree. Kouri's motivated, hardworking, and I always admired that. And she was very motivated, it felt like, to become financially independent.
Your Honor, this conversation, can we get a foundation of exactly when in 2019 this conversation took place? Sometime in that year?
Mid-February. Okay. I think the trip started on the 17th, and I'm not sure what day.
Do you want to have this discussion with witness
I
present?
do, outside that, if she could step down and step out.
Do you want any more for recollection before we have the conversation?
No.
Okay. Do you mind just waiting out in the lobby for us for a minute? Thank you.
Your Honor, may it please the court. According to Mrs. Wright, this conversation took place in February of 2019. 3 years prior, more than 3 years prior to Mr. Richins' death. In the interim, in between 2019 and 2022, the Richins attended marriage counseling and worked on their marriage and a bunch of water under the bridge. To allow a conversation on a vacation in a situation where two women are just chatting about the condition of their marriage, 3 years, there's certainly no allegation here that Kouri Richins was planning to murder her husband 3 years in advance. Outrageously prejudicial due to the temporal distance in the statement that is being made. No relevance because it's 3 years prior.
Why isn't it relevant to show that Ms. Richins was aware of the outcome financially that would flow to her from a divorce based upon the prenuptial agreement?
She's aware of that when she signs the prenuptial agreement. They've entered the agreement that she signed.
This is, well, I mean, I think you've answered my question. It is relevant to show she's aware of it.
No, sir. The conversation in 2019 certainly isn't relevant. They have introduced a prenuptial agreement that she signed. It's clear that she knew.
I apologize for interrupting you. It's not clear because it doesn't, I have no evidence that she read it. I don't have any evidence that she understood it. Here, I have a witness saying she understood it, was aware of it, was fearful of it, was taking steps to mitigate.
Okay. If that's going to come in over my objection, certainly respect your ruling. We've made our record, but I would ask that all the rest of that conversation be stricken as too far away about being trapped in her marriage, about being unhappy. Everything about that is utterly irrelevant and outrageously prejudicial. And we would ask that it be stricken and only be allowed to say that she discussed her prenuptial agreement and that's it. And we also would like a continuing objection to any questions of this witness about any conversation in 2019. We respect your ruling on that.
Okay. So defendant's objection to this series of questions of Ms. Wright is overruled. The testimony that was put on the record through the voir dire requested by defendant.
I mean, I understand what they're trying to do. I understand where the judge is going with this. That yes, they introduced the thing, but yeah, no, this is proper. I mean, it's really fucking detrimental to your case, but it's 100% proper. So I don't see the problem here. Like I see the problem for the defense, like I see the problem this causes, but like I can't, I don't agree with them that they need to strike this and everything needs to be stricken here. Like I totally get it though. Yes, this is really this is going to kill them. This type of conversation can sink Kouri like fucking immediately. Like this could be the thing that ruins it. So like I totally get it. I totally get what she's trying to argue here. It's just I do agree with the judge. Like, yeah, no. And you're like, even though you're like, come on, judge, do that thing, judge. And he's like, no, I'm not doing it. So let's keep going.
Is relevant because it shows defendant's genuine subjective awareness of.
No, Karen, this is not in front of the jury. They excused the jury to do this voir dire because they had to the state had to make a proffer. So they did this proffer outside the jury's presence. Because technically the judge may have agreed with the defense. And if he did strike this testimony, then it'd be too late. So yeah, this is done all outside of the jury's presence. All outside of the jury's presence. And they'll never get to know if this conversation and these discussions ever happened.
What she believed were the financial.
Very good question to ask.
Consequences that would flow to her if she and her husband divorced. It provides additional probative value because it shows that she was concerned about having less money than her husband if they divorced by virtue of the prenuptial agreement. She was taking steps to mitigate that potential financial effects. She was concerned about how her children might associate more with her husband by virtue of the lifestyle that he would be able to maintain in a post-divorce financial environment. That is all probative to the issues in this case, and it is not substantially outweighed by the danger of unfair prejudice.
Your Honor, can I also get a ruling just to avoid having to take another break when the jury comes back? Obviously, I have a right to go into her credibility and bias at this point, no matter what's being asked on direct, correct?
That's a very broad statement. You can certainly go into potential sources of bias.
Thank you. That's all I need.
Okay. Okay. Folks, let's take a 10-minute break. We'll come back at 10 of 12. Thank you. No one is allowed to speak to Ms. Wright.
Oh, I 100% agree with the judge. He's like, that is very broad and vague. But yes, generally, yes. But I think he almost wanted to say, I don't know what you're asking. But yes, absent you being fucking retarded, you can do it. But yeah, she generally has the right to attack her bias and credibility. It's just a matter of what do you intend to attack in terms of bias and or credibility. So, that becomes the issue here of what the fuck is it that you plan on doing, lady? What is it that you plan on doing? So here we go.
During this break, please give her some space. Thank you. Court's in recess.
All right.
So here we go, chat. Gonna take a break. We still haven't had lunch yet. So, here we go.
All right, jury.
Please have a seat as you come in. All right, please have a seat. Mr. Bennett, please proceed.
So, Ms. Wright, before we took our break, I had asked you about a conversation you had with Kouri Richins on a vacation you took. When did that vacation take place?
February of 2019.
And what was that conversation? Describe for the jury what happened during that conversation.
Kouri and I were finally in a position where our husbands were no longer with us. We were just discussing life. We both have kids, our marriages, and Kouri opened up and shared that things were difficult at home, and a word I remember is that she felt trapped. At this time, I learned that their marriage had a prenuptial agreement, and she explained that she felt like she was frustrated in the relationship, but also it would be difficult to leave. Eric would end up financially secure, and her the opposite. She feared what would happen in divorce. She mentioned that maybe the kids would prefer him with the lifestyle that they had, four-wheelers and toys and opportunities, where she would have less. She feared how she would be represented by him in the community. I felt for her. It was a hard conversation. I knew that things had been hard since their youngest child was born, and I was tender towards her current circumstance.
Thank you. And did that conversation give you any context to what was happening in terms of Kouri's business at that time?
Yeah, Kouri is super ambitious. She went back to school and got a master's degree. I was impressed. I had young kids. I wasn't sure I could do that. She then went and got a real estate license and was trying to build that business. That conversation kept playing in my mind as I think this is a way to become financially independent and secure.
Thank you. Those are all my questions for you. The defense may have some. Thanks.
Thank you.
May I please the court? Good morning.
Good morning.
This conversation you're talking about happened in Hawaii, didn't it?
No.
Where was it?
Costa Rica.
I'm sorry, Costa Rica. And the reason you all were talking about her marriage, there was a reason she was upset in her marriage at that time, wasn't there?
Not that I know.
Think hard.
She was upset. But I understood from the conversation is things were frustrating at home.
And that's because she believed he was having an affair with a coworker. Is that right? Is that right?
She and I never discussed her thinking about an affair.
Is that the context of the conversation you were having that day, that she believed he was having an affair with a coworker, and that's why she was upset with her marriage and talking about divorce?
I don't recall that.
Were you aware of it at that time, that there was an affair going on between Eric and a coworker?
I don't recall that conversation versus when I found out.
When did you find out?
I'm sorry, will you repeat that question?
When did you find out that Eric was having an affair with a woman that worked with him?
These are facts, not evidence. Assumes facts, not evidence.
Foundation. You got to lay foundation for this. I'm not sure this witness knows anything about it. What you asked.
You just testified that when you found out, you weren't sure if it was during this conversation. So when did you find out?
That's not accurate. You have to ask it open-ended.
Okay. When did you find out? Was it any time near this conversation?
Will you repeat that question with more detail?
When did you find out that Eric was supposedly having an affair with another woman in context to this conversation? Before, after, during?
I'm having a difficult time understanding because help me understand affair. Because like I think there was a friendship with a lady, but I don't know exactly what was going on.
Understood. That's fair. So let me rephrase it. Did you become aware that Eric had intimate feelings towards a woman that he was working with?
Your Honor, assumes fact, not evidence.
She's
Argument, not
asking
question.
whether this person ever became aware of it. Overruled. It's a yes or no question. Ms. Wright, can you start there?
Can you repeat the question?
Did you become aware that Eric, at around this time, 2019, had intimate feelings towards another woman that he worked with that was causing problems in their marriage?
I don't remember when I became aware of it.
Ballpark.
I'm sorry. I think I heard of it like twice, and I don't remember. I'm sorry, I don't remember.
When you were having this conversation with Kouri, did you know at that time?
I don't believe I did.
All right, these vacations, you had vacations with Eric and Kouri on more than one occasion, didn't you guys?
Yes.
And then at some point, those totally stopped, didn't they?
Yes.
And what happened that made you guys stop going on vacations together?
COVID was the next year.
Besides COVID.
Our family life was busy.
In fact, didn't Cody and Eric have a big falling out? Your husband is Cody, right? Correct?
My husband is Cody.
And how does Cody Wright know Eric?
We were friends in high school. They went on to work together, broke off and started a business together, and maintained their friendship.
So they were business partners.
Correct.
And they both own C&E stonemasonry together, right?
Correct.
And at some point, your families quit hanging out. Personally.
We continued to go to birthday parties and like that kind of an event. No longer vacations. I think we had a vacation plan.
Ma'am, are you aware of hedonism 2? Do you know why they call it hedonism 2 instead of hedonism 1? Yeah, no, this sounds very sketchy. I like how it says no, Eric Richins. No is dick.
In 2020 that got canceled due to COVID is the one that I recall.
In fact, didn't Eric and Cody have a falling out over Cody calling the police on Eric?
Cody didn't call the police on Eric.
Did Cody provide testimony against Eric with relation to an investigation against Eric for violating hunting laws?
Lack of foundation.
Well, this is a different question. Ask her if she's aware.
Are you aware that Cody provided
That is 100% fucking relevant. Bias like a motherfucker. So one of these guys snitched him out in a game trial. Wow. Whoa. Snitching to the fucking fish police. Pathetic. Sad. Pathetic. Snitching out to the fish police is never cool, chat.
information to law enforcement against Eric for a violation of hunting laws? Okay.
Yes.
And Eric and him, as I would say, fell out over that. I don't know another word. Had a disagreement about that.
Yes, temporarily.
And you guys never vacationed together again after that, did you?
No.
All right. Now, you said that you did the payroll and the bookkeeping at C&E. Is that right?
We have a payroll service company.
Oh, sorry, sure. Okay, but you do the bookkeeping.
Yes.
So you know how much money's coming into that company, right?
Correct.
And you know how much money's going out, right?
Yes.
And do you and your husband have joint, do you share your marital money, or does he keep his business money separate?
We share our marital money.
Pause for 1 second since you're good. Mr. Red.
Outside the scope, correct?
Sustain.
All right. Setting aside your personal financial affairs, you're very aware of C&E's financial affairs, correct? Because you do the bookkeeping.
Correct.
All right. And
Objection, Your Honor, this is still outside the scope.
no, it's not.
Yeah, please approach. I'm not sure where you're headed here.
This is interesting. 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 Young. Yes. That shame says, why is it called hedonism 2? I don't know, because technically it's hedonism 1. There used to be like another bar or resort way back. Here's
Your next question, please. Ms.
So,
Sister.
when you Google it, apparently there was like an older resort called hedonism, but it's not the same place and it's not the same thing. So they called it hedonism 2. So Yeah, this is that's why they call it hedonism too. But thank you for that, Shave, for $1.99. Also, I got your email. I will take a look at that. Thank you. I'll reach out to that guy. Oh, stop, chat. Oh, Sean knows. We all looked together because we had to figure out what the fuck. Like, we didn't know. We all did this research one night on locals. I'm pro poaching. I'm anti fish police. So everything is fine over here. It says, how did Eric have his hunting rights still? Usually for like most game violations, you don't really lose them, maybe for a year or so at most. It's not long term. It's not long term. And also, if I lose my hunting rights and I'm in America, if I go down to like Mexico, they probably don't give a shit. So Ariel's saying it's because Eric asked Cody to tag an elk Eric shot. Well, yeah, that'll get you fucked all the time. Tech Guy Sal says, I guess in reality, she was actually Miss Wrong. So, anyways. Is this tips about hunting and even talking law? Yes. Yes. Don't violate the fish police rules. Nick goes to Hito too. Jared goes to Hito poo. Although technically that counts as going number 2, so maybe they both go to Hito. Maybe there's a special Hito room for scat, for poo. Texas Farm Girl says Sean knows, yeah. Oh. Visit Hito says, Sean, don't pretend you haven't been here.
Since Eric's death, you and your family have grown pretty close to the Richins family. Is that fair?
Objection, Your Honor.
Goes to bias. Goes to bias.
Overruled. If you would please restate the question.
Since Eric's death, you and Cody have become very close to the Richins family. Is that fair?
I would say the relationship didn't change.
So you were very close to them before?
Yes.
All right. And it's true that since Eric's death, your husband has even accompanied them to court hearings and sat beside them. Is that right?
Yes.
Right. Have you?
Yes.
And I think everything else is going to be when we recall. Ma'am, we're going to recall you later. We would ask that you're not releasing your subpoena, and the judge will instruct you about that. That's all we have at this time, Your Honor.
Okay. Anything within the scope of cross, Ms. Sherman?
I could just have a minute.
Of course.
No, Your Honor.
Okay. Ms. Wright, you're free to go today. You're still subject to the subpoena that you were served with. You may be called back. Between now and then, please do not speak to anybody about your testimony, including your husband. Okay? And please don't watch any coverage of this case. Don't read, listen, watch anything about it. Do you agree to do those things?
Yes.
Very good. You're free to go. Thank you for your time.
Thank you.
Good time for a lunch break, counsel? Or do we have another short witness you want to get on and off?
Too bad she didn't like with any of these witnesses. Will be like when they're getting ready to leave, they're like before they get up, they like reach down to the thing and it's like shout out to like Defense Diaries, Courtroom Confidential, Emily Baker, like whoever they watch. Shout out to Andrea Burkhardt, Potentially Criminal, to Kurt. That would be, Peter Tragos. That'd be so funny. Shout out to Runkle. That'd be so fucking hilarious if that ever happens at some point. Yeah. Shout out to Phil Holloway on MK True Crime. That would be so fucking hilarious when that happens. At some point it will.
Your Honor, we can break. I understand there's some legal issues to address too, so.
Understood. Okay. Any objection to a lunch break, counsel? All right. Please rise for the jury. Folks, quick reminder. You know what I'm going to say. Please don't discuss the case. Don't read, watch, or listen to anything about it. Please don't do any research. Enjoy your lunch. 12:40, counsel. Is that reasonable?
Yes, sir.
Yes, sir.
Okay. 12:40. Thank you. Have a seat. Thank you. We're on the record.
So overall, that did not go very well for the prosecutor. I think they meant for that to be a relatively minor witness, and then they just kind of blew that open. So,
Your Honor, we're going to quickly next call Detective O'Driscoll just for a phone download. We'll have perhaps more time later.
Okay.
But then it's Mr. Coach, and I understand the defense has some objections related to Mr. Coach.
Mr. Ramos, tell me more.
Thank you, Judge. I figured we'd do this just outside that we can speed things along.
like did he say Mr. Kojima? I think he said Mr. Kojimos, but it's like Mr. Kojima. It's like, oh my god, that'd be interesting.
We've been provided with some exhibits that appear to rely, correct me if I'm wrong, on some CDR data, call detail records from Verizon and T-Mobile, I believe, and AT&T. Those items, we were not provided notice of their use under 901.11, and so we just make an objection under that.
Forgive me. They were provided some reasonable time after being received by the state.
Yeah, no, the information was provided to us. We've had that for a while. Just notice of their use under that business record exception.
Give me that citation one more time.
Yeah.
Full 901.11.
Full 902.11, I believe is what it would be, comes in through. And specifically, I'm referring to the written notice.
Why isn't inclusion of these records on the state's exhibit list fair notice under 902.11?
Just based on the case law, Judge, I could give you a citation. I have two cases I think are fairly on point. 32P 3D 976, State v. Webster.
What's the other one?
And then 322 P3D.
Chat, when you hear him say P means the Pacific Reporter. So remember how you've seen reporting, like case reporters, like out west, they have the Pacific Reporter. So that's why you'll see that.
624 State v. Pereira. We just bring this up, Judge, now. We could have it rolling after lunch is fine. And that would be our only objection.
Okay.
Thank you, Judge.
Mr. Bloodworth, I made an assumption there, if you could just confirm it for me. These call detail records were in fact included among the state's proposed exhibits on this exhibit list?
Yes, sir.
Okay. Anything further on this, sir?
Yeah, right, Your Honor. Just to clarify that, they didn't disclose, and the disclosure included the certification from the whoever returned the.
Right. The declaration. I understand your point to be slightly different than the self-authenticating piece. Got it.
Correct.
Okay. Yeah. Pause there for a minute. I'll take a look at those two cases, Mr. Ramos. We can pick this up at 12:40. After Ms. Crosswhite testified, and after we took that break, one of the jurors passed out the following note. I'll read it. I don't think this is an issue, but just letting you know. Quote, Judge, I have met witness Molly Crosswhite professionally. She has done one transaction for a home where I work. Any concerns, Mr. Bloodworth?
No, yeah.
Okay, chat. So they're jurors saying, wait, I actually know this person. Like that happens. That happens. So what they were focusing on here, what we're going to, we'll get to this in a second. Hold on.
My to-do list. Either following lunch or at the end of the day, may we address the motion for mistrial that you made at sidebar following the mention of jail calls by Ms. Gibson?
Yes, I'm prepared whenever you are. Just let me know.
Let's do that after lunch as well.
Okay.
Thank you. We will be in recess until 12:40. Thank you.
All right, chat. So who is asking here? I tried to bring this back. Did I miss it? Is it still around? There reminded of Beavis and Butthead with the glasses. Half Seamus is saying, is it 901 self-authenticating? Actually, no. In Utah, 902 is self-authenticating. I think that's actually, I think in Ohio, it's. In Ohio, it's, let me see here. I think it's 902 for us too. Let me see here. This is Ohio's rules of evidence. We'll go to the top. Sorry, I'm going to check Ohio's while I'm at it. Is it 902? Yeah, 902 is self-authentication. So what they're arguing here is that in Utah, self-authenticating documents. So they go down to here. these are business records, records that the originals are records that meet the requirements, and they're shown by a certification, a custodian that's signed in a manner falsely made. Basically just somebody certifying these records are true and accurate copies. So that's what they're getting to there, yeah. So that's all they were trying to get to there, that they're going to bring those in. They're going to take a look at it. And he's saying, should the state's rules number mirror the federal rules? Generally, they do. But they don't have to. Because there are some states that recognize certain exceptions that the federal government doesn't. There are privileges that some states have that the federal government doesn't recognize. Some states have extra privileges. They might have different rules on how things are. It all really depends. The juror told the juror realized, oh my God, I know that person. And that's okay if you know a person. That's okay. Like, you're not expected to be 100% on the ball. So we're going to get to, oh no, we lost Meme. He doesn't have the stamina to stay with us, chat. The Japanese women have sucked it out of him. Yeah, the juror had done business with the witness. They knew him from outside. So, which happens. It happens. Nothing's perfect. And they're like, yeah, that's not really that big a deal. So, but anyways, let's keep moving here through lunch. I still can't believe he only gives him like half hour. Like, an hour flies with trial. An hour flies by like, wow, like that. So how long do they get? Yeah, they barely got. Oh, they got a 45-minute lunch this time. Good for them.
Under Rule 9. Talking.
Here we go.
To be.
Here we go, chat.
Okay, we're back on the record 231-500-139. Mr. Ramos, may we talk about the defendant's objection regarding the call detail records that I understand Mr. Koutridimos is going to testify regarding? Is that correct, Mr. Nick?
That's my understanding.
Koutridimos is the gentleman that they'll come in through.
I'm not going to be seeking to admit the call detail records.
I'm confused.
I imagine they were used for some of the demonstrative exhibits.
You relied on call detail records to create some of our exhibits.
Got it.
But I'm seeking to admit the visual representation of those call detail records that he helped create, he'll testify came from the call detail records, although the call detail records themselves, the state is not seeking to admit as an exhibit.
Got it. Okay. Look at the Webster case. It certainly talks about notice with respect to Rule 807, which has a notice provision, and case law talking about how that notice provision works. The Webster case doesn't mention 902 at all. I'm not sure I was following your argument, Mr. Ramos.
Judge, the 902, 803 rules and those identified in the residual exception in Webster, they reference the same language, which is the notice language. That's what we were focusing on. I think Your Honor has enough to make a ruling. Okay. I understand your position.
Got it.
Yeah.
All right. So under Rule 902, subsection 11, records that can be self-authenticating under that rule before the trial or hearing, the proponent, in this case the state, must give an adverse party reasonable written notice of the intent to offer the record and must make the record and certification that makes the record self-authenticating available for inspection so that the other party, in this case defendant, has a fair opportunity to challenge them. All of those things have occurred. The call detail records and the certifications under Rule 902 that are included with them from the mobile service providers have been made available to defendant for inspection through the discovery process. And by virtue of the fact that those records have been part of, or at least the portions of those records that the state seeks to publish to the jury have been part of the state's exhibit list, the state has given the adverse party reasonable written notice of the intent to offer the record. The court finds the defendant has had a fair opportunity to challenge those records. Any objection to the admission of that call detail record information under 902.11 is respectfully overruled. Anything further, Mr. Ramos?
No, Judge. There will be through Mr. Koutridimos some testimony regarding the .pmg files of the gist. I would, at that point, probably ask why you were with this, assuming they're going to be asked to be introduced evidence. So I just let the court know now and get some sure of that.
Okay, guys. So what that was all about, and this is an argument you make. You're not sure you're going to win, but you make it anyway. Basically, they're arguing, look, Judge, we have a right to, like they're presenting this evidence late. It's not fair for us. How do we actually prepare here? we weren't given real notice. And the judge is like, well, really, how much notice did you not get? And they're trying to cite under the rules that, we're entitled to notice. The judge is like, but you had noticed previously this stuff existed. You just didn't get it like, oh, we intend to use it here at trial specifically. And he's not going to let them kind of like, well, axiomally their way out of this. So that's what they're losing on right there. I hope that answers the question. I know some of you are probably trying to figure out what the hell is actually going on with that. So
which file type was that?
They're those GIFs that were presented during.
Oh, the pathways that link to those.
Right.
Got it. Okay.
Can I ask just a general question, just to avoid, because I think it's going to come up. So it's my understanding that the extractions have now been put into evidence, correct?
Yeah, but not the physical documents, but the extraction, but the testimony about who extracted or downloaded the phones. Yes.
And we put the phones in, but we have not put in the actual, we've not put in the report, the data that's been fed into the Celebrate software platform. Is that in?
The raw data is not readable.
I know. The raw data is in through the phone, but is the Celebrate data that has been extracted by Ingtao, was that put in?
Not yet.
Okay, so if that's not in, how do we have from Kostradimos, how can he put in the demonstratives that are based on that? Because it's just basically it just makes it into a picture, but it's the data from what's not in yet.
So you have witnesses talking about the physical device containing electronically stored information was secured.
Correct.
You have testimony creating a chain of custody to the people that downloaded it through a two-step process.
Right.
The gray key, right, forensically mirrors that phone. And then Cellbrite is how, among other people, I imagine Mr. Kostradimos would say, I was able to read and process and parse out, quote unquote, that information. Not everything on that phone is relevant, so not all of it goes in. We're going to see what parts the state believes are relevant through Mr. Kostradimos. He hasn't testified yet.
So he's going to be allowed to testify what's the information that's in something that hasn't been put in yet. Because without putting in the extraction,
there is no basis to admit the extraction. There is a lot of information on that phone that I imagine is not relevant under 401 or 402.
Agreed.
So there's no basis to put in the entire extraction.
So
it's not like an encyclopedia.
Okay. Well, then this is getting to the core of what my concern is.
Yeah.
And I'm just thinking out loud to try to avoid wasting Kostradimos' time. But let's say, hypothetically, we want to get some of the extraction information in at a later time.
Do you have an expert that has looked at those extractions with Cellbrite and can testify and lay foundation?
We do.
Okay.
No problem. But my question is whether our expert can do the same thing theirs is doing, which is relying on data they saw in Cellbrite and parsing it out without the Cellbrite extraction coming in. Because as long as we can do it too, I'm totally fine with this whole process. But what's worrying me is we're going to get to my side and they're going to say the extraction's not in, your expert can't testify. So I guess I just want to make sure we're all on the same page. The extraction doesn't have to come in as long as our expert has reviewed the extraction and they've laid a foundation for authenticity of the extraction, which, by the way, I don't think either side is challenging the authenticity of the extraction ultimately. But the same thing's going to apply when our side gets up and our guy says, this is what I pulled out of Cellbrite. I'm going to use this in what we're going to present.
Are you talking to me or them?
I'm talking to you.
I'm not sure what you're asking for.
I'm asking if we need to have a hearing now about whether the extraction has to be admitted for all this to come in, or if the extraction doesn't have to be admitted, there's no problems.
The only reason we've talked, as I understand it, about the extraction process at all is to lay foundation for the expert testimony of people like Mr. Kostradimos.
Perfect.
You guys might like she's actually asking a very, very good question. No. I understand you guys don't like her. I get it. She's fat. She's retarded, whatever. No, this is actually an important question you need to sort out. How are we setting the stage for this? Because if I try to go down this road, I don't want to get hamstrung by the prosecutor who's going to, I don't want to get sandbagged over this. Like, I get what she's asking here. It may seem kind of goofy, basically. You guys talking about pimento cheese. Oh my God. Ahmad saying, admit the extraction. The problem is that's the entire cell phone. So not just the text message to this guy or anything about it, but like if she's got cat pictures, those aren't relevant. Every little bit of that phone is not relevant. Most of that phone's not relevant. Probably 95% of that phone is not relevant. And that's even being generous. It's going to be probably less than a gigabyte worth of information out of, 150 gigabytes of information is going to be important. So yeah, her porn history, like all that would be invalid. Draw from the void. How you doing, man? How you doing? Says, thank you for being here. Can she introduce out of court statements by state actors? Yes. 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 Maddie says, what is she wanting to hide? I don't know. Dave says, when's Billy Wagner going on trial? I still think they're sorting that out. I don't think that's been set yet. Cyanide Colossus cat pictures are always relevant. I stand corrected.
So you will not require for Coaster Demos to testify about the data that he read from the extraction. You are not going to require the extraction to be admitted into evidence, because if that applies, then that applies to us too, and we're fine with that.
As long as your expert is an expert and doesn't have to say or do something else objectionable. I don't know who your expert is or what they're going to say, so I need to be a little bit circumspect here. But the fact that a copy of the extraction from Gray Key on a portable hard drive has not been admitted as an exhibit is not an impediment to this kind of expert testimony.
That is exactly what I needed to know, because if it is, we need to have a hearing on it, and if it's not, then there's no problem. But I just want to make super clear that we're all on the same page, that it doesn't have to come in for us to pull things out of it and admit it.
Yeah, I think we need to keep in mind the life cycle of these things. There's information gathering, there's chain of custody and information preservation, and then there's what's admissible and how it comes in.
Sure. The only reason it's just unique is because the phone itself, without the extraction, the hard data is not readable, as the witnesses have talked about.
Right.
I mean, like, if the juror was given what was extracted out of the phone, they couldn't do anything with it anyway.
You and I agree.
Okay, I just want to make sure that we don't do that wrong, so that the extraction, the hard drive extraction itself doesn't have to come in, and we can all pull pieces out of it that we want because the foundation's been laid.
Yeah, I want to be careful. You're saying the extraction. There are several.
There are.
I'm familiar with the ones for which foundation has been laid so far. I don't know whether you're talking about some other devices regarding which foundation has not yet been laid.
Eric Kouri's phone.
This is, again, I feel like you're talking to the state, not me.
No. I think we're all in agreement that the extraction doesn't have to come in. As long as the extraction doesn't have to come in and we can use pieces of it, I'm totally fine.
Provided sufficient foundation.
Sure,
for the
to show it's
extraction has been
admissible. To show it's admissible under other grounds, 401, 403, hearsay.
Authenticity, yeah.
Well, authenticity is an issue, right?
If you're talking about a device that we haven't talked about yet, you're going to have to lay some foundation.
No, assume for purposes of this conversation, it's only devices that have been admitted. So
for the purposes of this conversation and putting aside other 702 related objections that the state may make when your expert witness is testifying, what's good for the goose is good for the gander with respect to the extractions.
Perfect. That's all I needed. Thank you very much for taking the time. I do think that's really complicated and strange because of the way that the extraction is a different data set than the actual guts of the phone, which is unreadable. So that's why I just wanted to clarify that. So thank you very much.
Okay. I forgot how that began.
The juror issue. We got to talk about the juror issue.
We can switch to that. Anything else regarding Mr. Contreras before he takes his stand? Ms. Sherbanek?
Nothing from the state.
Mr. Ramos? Okay. The juror note. Go ahead, Ms. Lewis.
Your Honor, we do have some concerns about the note that came out from the juror. First off, I believe that had we had this information during jury selection, this juror would have been weeded out in the process because they had a business transaction with the witness. So now we have someone on the jury who I believe, based on our parameters, wouldn't have even made it to the final pool. So that's concerning. The other concern is we don't know anything about the reaction, the interaction with Ms. Crosswhite, positive, negative. I did have to push back a little. That concerns me a little bit that, if he thinks very highly of her, that could be some bias that I did have to get up and push back. And our position would be out of an abundance of caution. We dismiss that particular juror.
Are you prepared to address this now, Mr. Bloodworth, or do you need some time to think about it?
Your Honor, we can address this now.
I want to be transparent. I'm not going to rule in this moment. I will need to just take a look at what legal standards, if any, there are regarding this. But if there's anything you want to put on the record now.
Can I just add, I'm sorry, Brad. It is our understanding that Ms. Crosswhite went by a different name, so I'm not implying this juror intentionally withheld information. He may have known her by a different name.
Understood. Go ahead, Mr. Bloodworth.
Your Honor, I don't know that the jury note provides the court with sufficient information to make a determination at this point. It seems to the state that a little bit of voir dire would probably benefit the court. But based on what the information the note contains, I don't see cause to strike or dismiss this juror.
All right. Ms. Lewis, my sense of this is I don't need to rule on this right now. I can give it some thought. There's no harm in leaving the juror right where they are for the time being.
Agreed.
Okay. I won't lose track of this. Let me think about it for a minute. It may be that I just need to ask this person a few questions and then we'll go from there. Okay. Motion for Mr. Robinson?
Sure. Just really briefly. As the court will recall, during the time that I had Ms. Chelsea Gibson on cross, I was trying to lay a foundation to later get in some of the home wave calls that had been downloaded. According to her reports that we were provided, she was the individual who downloaded all of them and stored them into evidence. And I believe that I had to at least lay a foundation of authenticity if I later wanted to admit those calls. So I was trying to do that. I was trying to do it very carefully. I warned her to please copy my language. I looked right at her. I used very specific language, and her response was, "You mean the jail calls?" I understand things like this happen in trial, but the case law that's relevant, I believe, is it implicates Ms. Richins' Sixth Amendment right to a fair trial. It affects the presumption of innocence because if the jury is aware that she's been incarcerated, there's been case law that says that can impact your presumption of innocence. There is a case, a pretty recent case in Utah, State versus Bernejo, Bernejo. The site is 476 P. 3rd 148, which acknowledges that evidence of custody status can carry the risk of prejudice. I will absolutely concede all the case law gives you so much discretion in this area because every circumstance is different, every situation is different. They really, really do rely on the trial court judge to make a call in the moment. Now we have this situation through no fault of mine where
that's not true. If she tried to stay out of it, depending on how retarded your the witness gets, sometimes it's not your fault. And real quick, this is we'll get to this question here in a second, Farm Girl. You ask a very good question, and I'll bring that up.
The jury now knows that at least for some period of time, my client was in jail and communicating with family, and she did use the phrase calls with an S to indicate there were multiple calls, although she didn't say how many or for how long, and I concede that. So we would, and also the case of State versus Atkin, Atkin, 135 P. 3rd 894. Again, there's a quote, "It may be prejudicial in certain cases." Full disclosure, both of these cases, the court did not find sufficient prejudice to overturn the call the court made in the moment. I think actually Bernejo may have been not that they weren't, they were challenging whether the lawyer was ineffective, I think, for failing to make a mistrial objection. If I'm not mistaken, I think that was Bernejo. So I'm not even sure the judge made a call on that case, but I do believe on Atkin they did. So based on the authority, the recognition that it can bring prejudice, based on the fact that this case did happen so long ago, so the jury would put two and two together and realize my client's been in jail the whole time, possibly. It's an inference that could be made. We did move for mistrial. I will say for the record, the court did provide a special instruction, limiting instruction, warning the jury not to consider that. That's one of those, difficulties because it does then again highlight that comment was made, but we were trying to do in the moment the least amount of damage going forward. I did agree to that instruction being made. I did not object to it because at that point I felt like something needed to be addressed. But that was the basis of the motion, and that's all the record we need to make.
Okay. Anything further, Mr. Valero? I think I have this firmly answered.
Yes, Your Honor. The state rests on the record that we made at the sidebar.
Okay, very good. The issue before the court is a motion for mistrial made by defendant following Ms. Gibson's reference to jail calls, quote unquote, during her cross-examination. A court finds that that statement, while improper, was not intentionally elicited by either party. It was inadvertent. It was made in passing. It was a short, quick reference. It is relatively innocuous in light of both the volume of testimony that the jury will hear in this case over the course of 5 weeks. It is relatively innocuous in light of the fact that this is a homicide trial, and so it would not come as a surprise to jurors that the defendant in a homicide trial may have been in custody at some point in the case.
Bullshit.
And moreover, the court gave a curative instruction that specifically instructed the jury not to consider that comment and not to speculate about whether defendant was or is in custody at any time in this case. Based upon those findings, the court finds that a mistrial is not required. Defendant's motion is respectfully denied. Anything further on that, Mr. Glover?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Okay. Ms. Shervaniak, anything else before we invite the jury in?
No.
Ms. Lewis? Ms. Nestor? Okay. We're ready for the jury.
Okay.
Folks, have a seat as you come in, please. Thank you. Please have a seat. Ms. Sherman, active state's next witness, please.
Detective Jeff O'Driscoll, please.
Detective, let's get you sworn in.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury? Thank you.
All right, chat. Sorry, I was away for 1 second here. Another for $10 says, it's not poo. Thank you. Draw from the void for $9.99 says, I administer the party opponent rule. Can a state introduce out-of-court statements from Kouri Richins' mouth? I keep thinking Karen Reed. Could they get in the out-of-court statements from a witness who is adverse to Kouri? Yes, 100% you can. It's a party opponent statement, and you know she has like basically everything can. Yeah. So, for example, if a witness says, "Here's what Kouri told me," it's a party statement of a party opponent. It's hearsay, but it's party opponent. So that's then just so you understand, we're gonna go to we're gonna fire this up real quick, draw from the void, and then text farm girl. I'm gonna get to your thing here. So here is actually hold on. I don't want to do that. View all. Okay, so we're gonna switch to this real quick, chat. These are the Utah rules of evidence, and we got to get to the biggest one. The one that's so short, it's only technically 7. It's only 7 rules. There's only 7 of them, but it's everything. Hearsay. It's where it all comes in at. And hold on here. So hold on, shit. I gotta search something here so I can. Let's see here. Hold on, chat. I don't know. How do they have this listed here? Statement. Where is it in their thing? Okay, I found it. Sorry, I had to do some Googling here. Okay. So we'll switch to this now. We'll switch back to this. All right. So I don't understand why this is here. This is so monstrous. They need to get rid of that. That's so obnoxious. All right, chat, hold on. If you get sick, don't watch. Okay, 701. Okay, 801, where is it? We went too far. Okay. So, definitions, exclusions from hearsay. So, how does this work? Statements that are not hearsay. A declarant witness's prior statement. Okay, so if you've had a prior statement that's been subject to cross-examination. And then 801D2, the opposing party statement. So how does this work? So here's where you get to them. You have to have your opposing party statements. Are they made in an individual representative capacity? Is one the party manifested that it adopted or believed to be true? Was made by a person whom the party authorized to make as a statement on the subject. So if you hired somebody or if you had an attorney or a spokesperson, was made by the party's agent or employee on a matter with the scope of that relationship. So, for example, if I hired somebody like a realtor and that realtor starts making statements on my behalf in a real estate deal, I could be on the hook for that. Was made by the agent within the scope of that relationship. It was made by the party's co-conspirator during and in furtherance of a conspiracy. So a fellow criminal can do that. So, yeah, literally anything Kouri says comes in. It's all fair game, to quote Ethan Ralph. So I hope that answers your question. If you are out there still. If it doesn't answer it, let me know. But yes, it's 801D2. That is traditionally where you find statement of party opponent. I just had to make sure because Utah may organize it differently. So, well, Aaron says guilt by hearsay. I mean, well, there's exceptions to it. Co-conspirators working together, yeah, that can be, but there's limits to hearsay. Although police abuse hearsay the shit out of it, so don't use Corey's COD lobby transcripts. Well, yeah, we'll find out. All right. Now the other question here, and I wanted to address this. How much input do you have on a client's attire? Pretty much everything. Pretty much everything. You're the one basically responsible for dressing them. Now, your client may have family and friends who have clothes and stuff that they'll supply, then fine. But for the most part, like if my client has clothes, I let what are you gonna wear? And as long as they tell me it's not something completely retarded, I'm fine with it. Now, every once in a while, you get clients who are like, I'm gonna wear, my t-shirt, I'm gonna wear some jeans and my Charlie Daniels band t-shirt to court. And it's like, not like that, brother. Not like that. But yeah, like normally what I would tell you is, especially if you're poor, you're an indigent client, I'm court appointed to represent you. And we're going to trial, I'll say, like, what do you have any clothes at home that are nice? Like, what would you wear to a funeral? You're like, I don't have anything like that. Okay. So I'd say, what size shirt do you wear? Are you medium, large, extra large? What size pants do you wear? And then I'd start with that. And then I'd say, okay, what color is your favorite color? Like, do you like blue? Do you like green? What colors do you like? Because I'm not gonna make you wear shit you don't want. And then I go then I go out to try to find you some clothes. If there's stores that are on sale, I'll go to like TJ Maxx or Marshalls, depending on the situation. Sometimes I'll go to, sometimes I'll go to the thrift shop. If I can find really good looking, you can find decent stuff there. I'll ask you, what size jacket do you wear? Like I had a guy once, he told me he used to have a jacket, but he had a house fire. I'm like, what size jacket do you wear? He's like, oh, I wear an off the rack 30, like a 38. I'm like, all right. So I went to the Goodwill and I found a jacket that was a 38. And he's like, it was perfect on him. So it happens. It happens. But yeah, you're the ones kind of helping him out with that. You help him out with that. That's a very good question. Thank you for asking. Yeah, you're not gonna wear orange because then everybody thinks of. I've had clients though. I've had clients say like, "Well, what if I like orange?" I'm like, that makes people think of jumpsuits, so we're not doing that. So Charlie's about beating the devil, not a judge in a robe. Well, that too, yes. uh, so mint green like Elmo green. Yeah, I tried to find you everything I could. I could. So how about dressing in Hugo Boss? If you look good in it, go for it. Oh. Aaron says, what's a good, not guilty color? It's more about how do you look and present yourself. Are you clean shaven? Or you have a trimmed up beard? Is your hair nice and cut and combed? That does more than the clothes do. That does more than the clothes do. High profile case like this. Yeah, they're gonna do what they can to get her selections of clothes ready as much as they can get a hold of. Because you don't want to repeat because that looks bad. But some days she's probably like, I'm cold. I want to wear a sweater. But yes, they're limited in what they could get her because remember, they don't have money to pay for all this. So they're probably scrimping and finding clothes that she has around her house or that her family holds on to. All kinds of stuff. It seems sloppy to you. Well, that's a problem. That's a problem with the criminal justice system that on the defense, you don't have the resources the state has. Say la vie. Say la vie. It's probably never going to change. I think that we're getting into the cell phone stuff now, chat. shit, chat. Sorry. Here we go. Dead air. I was watching the damn trial while you guys are screaming at me.
If you could state your name and spell your last name, please.
Detective Jeff O'Driscoll, O''Driscoll.
Where do you work?
Summit County Sheriff's Office.
How long have you worked there?
10 years.
What's your assignment with the sheriff's office?
I am a detective in the Major Crimes Investigation Unit.
During your investigation of this case, did you seize a cell phone belonging to Miss Carmen Lauber?
Yes, I did.
Was that in April of 2023?
Yes, it was.
Was that a black Samsung phone?
Yes,
Was the phone number on that phone ending 6127?
I believe so, yes.
Did you book that phone into evidence at the Summit County Sheriff's Office?
I think it was collected by crime scene technicians on the scene and they booked it in evidence.
Did you later retrieve that phone from evidence and with the help of Miss Chelsea Gibson, download that phone?
Yes.
Was that done using the Celebrate software?
Yes, it was.
Those are all my questions for you.
Just to make very clear, good afternoon, sir.
Good afternoon, Ms.
You are the O'Driscoll, that's the chief investigator in this case, right?
Yes, ma'am.
Okay, that's all I have for now, Your Honor. Thank you.
Hey, this witness step down, Mr. Sheriff.
For now, please.
Yeah, okay, very good. The state's next witness, please.
Chris Kotridemus.
Sir, if you step in front of Brittany, we'll get you sworn in.
Please return. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
Please proceed.
Sir, if you could state your name and spell your last name, please.
Sure, it's Chris Kotridemus, Kotrodimus.
The most authentic of Mormon names in Utah. Kotridemus.
Let's go through your employment background. Where are you currently working?
I currently own my own business. I own a company called M20 Solutions.
What's that company?
We do investigations, training, and consulting for prosecutors, defense teams, and law enforcement.
Is part of that business focused on digital forensics?
Yes.
Prior to that, where did you work?
I worked in law enforcement. I started my career in North Carolina with the Raleigh Police Department. I worked there until 2003. I took a position with the Salt Lake City Police Department, where I worked there until 2017. My last 5 years at Salt Lake City were spent in the homicide unit. In 2017, I took a position with the Salt Lake County District Attorney's Office as an investigator in the homicide unit and worked there for just shy of 6 years until my retirement in 2022.
And that's when you started your own business?
Yes.
Were you asked to analyze phone downloads and phone records for this case?
Yes.
Were you asked to do that process, look at the phone downloads and the phone records for 3 phones belonging to Kouri Richins?
Yes.
1 phone belonging to Eric Richins?
Yes.
Phone belonging to Carmen Lauber?
Yes.
Phone.
Oh shit, chat. What the fuck happened here? Hold on. No, that guy's smiling. Somebody said he's smiling. He's smiling because he's gonna fucking make money for his business. Like he's getting free PR here. So that was weird. All right, we'll put that back up. What the hell happened there? All right, hold on, chat. I got you. Also, still, like, we're 4 hours in and no that crap's over. Yeah, thank you. Let me see if we can get any closed captioning yet. Still no closed captioning, chat.
Please return. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
Please proceed.
Sir,
There we
state your
go.
name and spell your last name, please.
Sure, it's Chris Kotridemus, Kotrodimus.
Let's go through your employment background. Where are you currently working?
I currently own my own business. I own a company called M20 Solutions.
What's that company?
We do investigations, training, and consulting for prosecutors, defense teams, and law enforcement.
Is part of that business focused on digital forensics?
Yes.
Prior to that, where did you work?
I worked in law enforcement. I started my career in North Carolina with the Raleigh Police Department. I worked there until 2003. I took a position with the Salt Lake City Police Department, where I worked there until 2017. My last 5 years at Salt Lake City were spent in the homicide unit. In 2017, I took a position with the Salt Lake County District Attorney's Office as an investigator in the homicide unit and worked there for just shy of 6 years until my retirement in 2022.
And that's when you started your own business?
Yes.
Were you asked to analyze phone downloads and phone records for this case?
Yes.
Were you asked to do that process, look at the phone downloads and the phone records for 3 phones belonging to Kouri Richins?
Yes.
1 phone belonging to Eric Richins?
Yes.
Phone phone belonging to Carmen Lauber,
Yes.
a phone belonging to Josh Grossman,
Yes.
and phone records related to Robert Crozier.
Yes.
Let's talk a little bit about your qualifications. What type of specific education or training have you received to be able to analyze all of this phone data?
Sure. As it relates to this case, I've taken some formal training. Of course, once you get the formal training, then you get a lot of your experience in the field, in practical experience using that training. I'm a Cellbrite certified operator course. I took that. I took the Cellbrite certified physical analyzer course as well. And then from the call detail records standpoint, I am certified and took a course in, it's called TRACS. It's owned by LexisNexis. It's a location and data analysis program for call detail records and geolocation.
Have you testified before as an expert in digital forensics?
Yes.
How many times?
At least a dozen times in major cases.
And have you testified for prosecution and defense in those cases?
Yes.
How many phones have you done analysis for in your time doing this work?
Phones, hundreds. And call detail records are probably over 1,000.
Have you done downloads yourself?
I have.
For other cases?
I have.
So let's start, we'll treat it like a funnel. We'll start big picture. Let's talk about digital forensics. What is digital forensics?
The best and easiest way to describe it is the analysis of electronic devices. As it relates to this case, and my specialty is mostly phones and some computers.
So let's talk about specialties within digital forensics. What is, you mentioned that you're certified Cellbrite analyzer user
Yes.
or certified
Yes.
in that program. What is Cellbrite?
Cellbrite, they have several products, but generally what they do is they provide extraction tools to extract data from devices, and then they also provide analysis tools so that you can analyze then those readable files.
You mentioned call detail records. Is there an acronym we refer to those in shorthand?
Yes, CDR.
What is a CDR?
So a call detail record or a CDR is exactly what it sounds like pretty much. Okay, it's a record from your carrier, from your cell carrier, like Verizon or AT&T. And what it is it is a record of all your call details. So your incoming and outgoing calls, texts, data sessions, things of that nature.
You mentioned location analysis. How do you perform something like location analysis using cell phone data or CDR data?
Yeah, so you can map both, but prevalence is call detail records. So law enforcement can obtain call detail records that include location data with them. And location data is essentially the carrier reports and maintains a record during the normal course of business, which towers you're using, where that tower is located, and what antenna or sector of the tower that you're utilizing for that communication.
When you're analyzing phone data, what are the two main sources of that information?
Oh, so like for phone data, like in general?
Yeah, when you analyzed phones for this case, what were the two main sources of the data?
So the phones themselves, which is the content of the device, and then the call detail records, which are the communication records associated with those devices.
So when we're talking about call detail records, I think most people understand the phone contents. That comes from the actual device, correct?
Correct.
And the call detail records, you said they were stored by the carrier. Is that correct?
Correct.
And the call detail records, would those be located on anyone's device, or are those solely maintained by AT&T, Verizon, T-Mobile?
Yeah, the records themselves are maintained by the carrier.
And what is contained in a call detail record?
There's a lot of information in there. There is typically a timestamp, so there's a date and a time that the communication occurred, amongst whom the communication took place, or between which carrier or which numbers the communication took place. So, which phone numbers, whether it's incoming or outgoing, the duration if it's a phone call, and then of course the tower information, the tower location information.
Would a CDR record contain, for example, it would say a text is incoming or outgoing? Would any of the content of those messages be in the call detail record?
No, not in a call detail record.
How do you start or how do you analyze the contents of a phone? What do you use to do that?
So in this case, I used Cellbrite Physical Analyzer.
And how do you use Cellbrite Physical Analyzer? What does that provide you to allow you to analyze the contents?
So Cellbrite Physical Analyzer is a software package, and what it does is it allows you to analyze readable files from the extraction. So the phone is downloaded, a readable file is created, you load that readable file into Analyzer, and then you can analyze those results.
How often are there other programs besides Cellbrite that can perform that function?
Yes.
Is Cellbrite the most commonly used one?
Yes.
Why is that?
It's very popular because it's got a very user-friendly interface. It's widely known, it's widely regarded. Analysts and people that do extractions and downloads have learned that they can rely on the results of those. They're pretty good. And so it's commonplace in this industry, particularly in law enforcement.
So now you testified that you've done downloads yourself of some phones.
Yes.
Can the person doing the download, extracting that raw data from a phone, can they change the contents of the phone when downloading it?
No.
can they manipulate it in any way when it's going from the raw data into the Cellbrite reader format?
No, I don't know a way to do that.
Why might a cell phone be downloaded or extracted more than once?
Usually it's different products are being applied to the phone. There are software updates, but more importantly, there's different products that might be available to obtain more data versus the other, particularly.
When you receive the download report from the phone in the readable format, what is contained in that report?
In the report is going to be all the system files. So there's going to be, most importantly, is the calls, texts, the web history. There can be biometrics. There can be like activity, movement of the device, biometric information, web searches. There's pretty much everything that is contained in a phone that a user might utilize or it would be available in that download.
Can a download report show if there have been things deleted off of the phone?
Yes.
How does it show that?
Yeah. In Physical Analyzer, if the extraction software recovers something from a database that has been set for destruct or for deletion, it can find that and then repopulate it into the phone as to where, actually into the report for where it belongs. And when it does that, in the program, it signifies that with like a small red X in a column next to it to let you know that it had been previously deleted from the device as an active user or by the active, the active file. But the software has been able to go in, find it in the database, and repopulate it.
So if a user deletes an item, it might still be stored on the phone that can be pulled by that report.
Correct. They may not be able to see it and think it's gone, but it may still be within a database that can be retrieved and repopulated.
Now, is that possible for all items that a user deletes?
No.
Why not?
Some of those deletions are system files, and so they're maintained in the background. The average user would not, or probably be able to delete system files. They're just, they literally run the phone.
So if I'm a common user of a phone and I delete a photo, how long would it be kind of in the background of that phone and able to be downloaded by this report before it's gone forever?
Right. Well, it kind of varies, and it varies by, there's a lot of variation there. But typically, when an item like an image is deleted, the image itself, that process, the original, like if it was sent to you or whatever, and you deleted it, it would be gone from your view in the phone, but it would be in a deletion file. And so that deletion file eventually has to make room for more deletions. So then it pushes deleted files out to make room for more deletions so that it can refill it. It only has so much room. So it has to purge that at some point. And that time can vary. More deletions are going to make that process typically happen more rapidly than less.
So if items have been deleted by a user and that phone gets downloaded in maybe that sweet spot where it's still somewhere in the background of the phone, right, that could be in the report.
It could be.
But if you miss that window and then the item is gone for good and can't be found in one of those extraction reports.
Pretty much once it's deleted from the system file, there's a process called a vacuum. Once it's vacuumed out and those files are reduced, it's essentially, you're probably not going to find it.
Now, if a user deletes a text from a phone, from their own phone, does that affect how the text message would show up on the receiving end?
No.
Shifting over to the CDR, the call detail records, you kind of described what that is and that it's stored by the cell phone carrier. How long is that data stored by the different major cell phone carriers?
They're all different, so they maintain their records for varying amounts of time. Verizon typically will keep call detail records for 18 months to 24 months, but they will only keep the associated location data for about a year, whereas AT&T and T-Mobile will keep that information for a much longer time.
Now, because this data is maintained or kept by AT&T or Verizon, can a user access that information?
No, those are business records maintained by the carrier.
Okay, I feel like we have a good groundwork now, and I want to turn your attention to what you did, what you did in this case. When were you brought on to work on this case?
I came on in May of 2023.
And in general, what were you asked to do for your part in this case?
Analyze phone downloads and analyze call detail records for pertinent information related to the case.
And so you analyzed phone downloads for this case, and you talked about the process for doing that. Did you perform any of the downloads for the phones in this case yourself?
The downloads, no.
And in viewing the download reports for the phones you analyzed, did you learn who the phone belonged to?
Yes.
How do you do that?
Well, besides the record or file being designated as belonging to that person, when you open the physical analyzer report, it gives details about the phone number, the IMEI number for the phone, and whatnot, and that can be matched to the user, whomever was using it at the relevant time.
As you analyzed phones for this case, did you generally become familiar with the people involved?
Yes.
Did you become familiar with what they look like?
Yes.
How did you become familiar with what these people look like?
Again, law enforcement shared that information with me, but in most instances, when I looked into the phone downloads, there were pictures of those people inside those phones doing various things, hanging out with family or contact photos, that type of thing.
I first want to turn your attention to Eric Richins' phone. Did you do an analysis of Eric Richins' phone?
Yes.
And was that a phone with the number 801-792-9317?
Yes.
Did you receive a download report from the Summit County Sheriff's Office for that phone?
Yes.
And was that download performed by Changi Engtao and Marcos Garicachia?
I believe so.
When you reviewed the report for Eric Richins' phone, did you find any evidence of mass deletions on his phone?
In Eric's phone, mass deletions, no.
How would you be able to tell if somebody had made batch or mass deletions from their phone?
Usually, if it's not evident in the actual phone download, whereas you can actually see the software has reported that those items were found as deleted and recovered. Outside of that, you would compare it to other types of evidence, such as like the call detail records.
So how would you be able to tell if there were deletions when comparing the phone to the call detail records?
It's basic. You just take the call detail record and you look and you see who that person was communicating with through their call detail record, and then you would be able to verify if those communications were maintained in the call logs on the phone themselves. So if I called you 5 times today, it would show in my call detail record, but if you downloaded my phone, it would also show in my call log that I called you 5 times today and what time of day and how long our phone calls were.
Did you review text message conversations from Eric Richins' phone?
Yes.
And in addition, did you review device activity data?
Yes.
You mentioned biometric data. What type of biometric data can you recover from a phone or review?
Right. It's kind of hand in hand with the activity report that you just mentioned. When a device moves or a connected device moves, it reports that movement to the device, and it's found in that activity sensor report portion of the download.
Did you look at Eric Richins' phone for evidence of THC gummy use?
Yes.
And did you find text messages between Eric Richins and Kouri Richins as it related to THC gummy use?
Yes.
Was that 3 conversations?
It was.
Okay. Was that 1 conversation in November of 2021?
Yes.
And 2 conversations in January of 2022?
Yes.
Scott, if we could show the witness 2-118D. Is it on your screen?
It's not. I got
Okay.
Desktop.
You have blue there, Elijah.
No, my screen.
Oh, my apologies. That's okay. 1 second. Council.
Chat, I will.
Is this the conversation you referenced from November of 2021?
You may need Scott to zoom in, please.
It is. I'm wearing my
There we go.
Yeah, better. Thanks, Scott. Yes, this is a November of 2021 conversation.
And that's between Kouri Richins and Eric Richins?
Yes.
Scott, if you could show the witness 2-119D, please. Is this a conversation between Eric Richins and Kouri Richins in January of 2022?
It is.
Thank you. And Scott, if you could show the witness 2-124D. And this is another conversation from January of 2022 from Eric Richins to Kouri Richins?
It is.
Did you also analyze Eric Richins' phone for information about illicit drug use?
Yes.
Did you find anything in Eric Richins' phone about illicit drug use?
No, outside THC, I didn't find anything.
Any communications on Eric Richins' phone about buying drugs?
No.
Now I want to talk about Kouri Richins' phones. Did you analyze 3 phones that belonged to Kouri Richins for this case?
I did, yes.
Scott, if you could put up 3-37D, please. Do you recognize this?
I do.
What is it?
This is an exhibit that represents the 3 phones that you just mentioned that were being used by Ms. Richins that are relevant to this case.
Did you help create this exhibit?
I did.
I'm going to move to admit 337D.
Okay. States 3-37D is admitted.
And publish, please. Okay. I have a pink pointer, but I'm going to try to use this.
All right.
What do you think, Scott? Okay. Let's start at the top.
All right.
What phone is at the top of this exhibit?
Okay, so the phone at the top of the exhibit on the left-hand side is Ms. Richins' white iPhone. And the 2 numbers that are there next to the 1 and the 2, those represent the phone numbers that were being used on that device during the time of September 2020 to April of 2022.
What do those dates represent?
That's the duration of the time that phone was being utilized.
So you mentioned for Kouri Richins' white iPhone that there were 2 numbers on that phone. What number were you able to determine was maybe the primary or most used number for that phone?
Right. So the number ending in 1987 is going to be the primary number. That is the carrier subscriber number through Verizon that phone was utilizing. And then the 1152 number is a VoIP number that was being used on that device as well.
So you said VoIP number, but tell the jury, how do you get 2 phone numbers on one phone?
You just use an app.
Okay. How is, in this case, the number 1152. How is that different than what you called the subscriber number, the 1987? How is it different?
Right. So that number, a VoIP number, it uses the internet to make calls, make and receive calls, make and receive texts. You can use that number like you would your normal carrier number. The difference is it uses data, and so it typically doesn't show up on your call detail records when you use it.
Did you view a download from Kouri Richins' white iPhone?
I did.
And that came from the Summit County Sheriff's Office?
It did.
And that download was performed by Cheney Ingtow and another download by Marcos Gary Cuchilla?
I believe so, yes.
Did that download contain text messages, call logs, web searches, things like that?
Yes.
In addition to that, were you also able to view what we were calling activity data or device sensor data for that phone?
Yes.
When you did the analysis for that white iPhone, was there evidence of deletions?
Yes.
Was there evidence of text message deletions?
Yes.
Evidence of call log deletions?
Yes.
Describe what time frame you were able to recognize those deletions happening.
The time frame essentially for that device is mid-March. So specifically as it relates to some of the other items I looked at related to this case, we're looking basically January 1st through middle of March 2022.
What was missing from that phone for January 2022, February 2022, and March 2022?
Hundreds of text messages at least. They were also missing most of the web history artifacts in that device.
Call histories as well?
Call logs, etc.
So turning your attention to the middle phone here, what are the dates for the use of that phone?
April 14th, 2022 to May 8th, 2023.
Now I noticed that silver iPhone has the same number as the white iPhone. How did that occur?
So this is a new device that Ms. Richins began using on April 14th, and she basically just had her old number assigned to this new device.
Were you able to view a download for this phone?
Yes.
And that was performed by the Summit County Sheriff's Office?
Yes.
Now, comparing Kouri's silver iPhone that she began using in April of 2022 compared to the prior phone, the one that she was using leading up to that point, were there patterns of deletions in this phone similar to the white iPhone?
There were some deletions noted, but not in the same manner as the previous phone, no.
What do you mean not in the same manner?
Meaning there were not big chunks of hundreds of text missing from the device that I noted, compared to the new phone did not have that type of deletion in it.
So now let's talk about the third phone on this exhibit. It says Kouri Richins' blue iPhone. Did you also view an extraction for this phone?
I did.
Or I guess extraction and download. I'm using them interchangeably. Is that okay?
That's fine.
They're the same thing.
Yeah.
And that download came from the Summit County Sheriff's Office?
Yes.
Now, similar questions about the blue iPhone. It seems that the date ranges for that are the same as the silver iPhone. Is that correct?
Correct.
So based on your analysis, Kouri Richins was using the blue iPhone and the silver iPhone at the same time?
Correct.
Same question for the blue iPhone. Were there mass deletions on the blue iPhone when comparing it to what you looked at for the white iPhone?
No.
Now, you did an analysis of a phone belonging to Carmen Lauber, is that correct?
Correct.
And that's the phone with the number ending 6127?
Yes.
Did you analyze CDR data for Carmen Lauber's phone?
I did.
And did you view an extraction or a download for that phone?
Yes.
And that came from the Summit County Sheriff's Office?
Yes.
On Carmen Lauber's phone, were you able to tell if there were deletions on that phone?
Yes.
What were you able to note about items being deleted?
Essentially in the same manner as with Ms. Richins' original phone. When comparing Ms. Lauber's call detail records, there were hundreds of texts and dozens of calls contained in those call detail records for that period of time, but they were no longer contained inside the device. Like there was pretty much all of those gone.
Did you also look at call detail records for Robert Crozier's phone?
Yes.
And was that for a phone with a number ending 0540?
Yes.
All right, turning your attention to Robert Josh Grossman. Did you analyze a download for a phone belonging to that person?
Yes.
And that download was given to you by the Summit County Sheriff's Office?
Yes.
One download that was performed by Marcos Gary Cuchilla, is that correct?
Yes.
And that phone had two different numbers associated with it, 1260 and then 0904?
Correct.
When looking at all of these different phone downloads, did you analyze communications between Eric Richins and Kouri Richins?
Yes.
Scott, if you could show Mr. Kotradimas Exhibit 2-3D, please. Just zoom in a little bit so he can recognize it. Is this a message between Kouri Richins and Eric Richins from December of 2020?
Yes, it is.
Scott, if you could show the witness Exhibit 2-5D. Is this another message between Kouri Richins and Eric Richins from June of 2021?
Yes.
Scott, if you could show the witness exhibit 2-17D. Is this a text message between Eric Richins and Kouri Richins in January of 2022?
Yes, it is.
Okay, before we jump into communications between some of these other parties, I want to see if you have analyzed these messages as well. Scott, if you could show the witness exhibit 2-121. Do you recognize this message as a text message thread that you analyzed from Kouri Richins' phone from December of 2022?
Yes.
Scott, if you could show the witness 2-112. Similar question. Do you recognize this as a text message from Kouri Richins' phone that you analyzed from February of 2023?
Yes.
And exhibit 2-113. Do you recognize this message as a text thread with Kouri Richins from March of 2023?
Yes.
And Scott, 2-14, please. Do you recognize this as a message from Kouri Richins' phone from March of 2023?
Yes.
Thank you, Scott. Did you analyze communications between Kouri Richins and I know he goes by Robert Josh Grossman?
Yes.
Did they communicate as far back as 2020?
They did, yes.
And through October of 2022?
Yes.
What were the typical volume of calls and texts between Kouri Richins and Josh Grossman?
Particularly from November of 21, which was essentially when the 1152 number showed up on his phone, daily, with a few exceptions.
Now, Scott, if you could put up 337B again, please, for the jury as well.
Wait a moment.
Now, you mentioned that the 1152 number showed up on Josh Grossman's phone. What number did Kouri Richins and Josh Grossman, from Kouri Richins' side, what number did she use to communicate with Josh Grossman?
By text, 1152.
Were you able to tell if she communicated with other people using that phone number, or was it mostly Mr. Grossman?
Mr. Grossman.
Did you find information on Kouri Richins' phone about these communications, or was that mostly from Mr. Grossman's phone?
I found none on Ms. Richins, and everything I found was on Mr. Grossman's.
In analyzing Kouri Richins' communications with Josh Grossman, did you locate documents that pertain to this case?
Yes.
Scott, if you could show the witness exhibit 3-1. And then if you could, I believe there's a second page, if you could show the subsequent pages. Do you recognize this?
I do.
What is it?
This is
generally speaking, is it a document you found?
Yeah, this is a vacation reservation made, or that was located inside Ms. Richins' device.
I'm going to move to admit 3-1.
Can you zoom out for a second, Scott? Go back to page 1 for me. It's a 2-page document, is that right?
I don't know if there's a third page. There's a third page that's the...
4 pages. Mr. Rom. Talk to me about authenticity. Why don't you folks approach for a second?
And looking at Mr. Cotradimos and analyzing Kouri Richins' phone, did you find documents that were pertinent to this case?
Yes.
And you located those on Kouri Richins' device?
Yes.
And looking at exhibit 3-1 in front of you, is this one of those documents that you located on her phone?
Yes.
Move to admit 3-1.
Mr. Reynolds, any other objection? Okay. So the record is clear. The objection asserted at sidebar is overruled. Scott, forgive me, you got to go back to page 1. 3-1, a 4-page document is admitted. Do you want to publish?
Yes, please. And Scott, if you could zoom in on. Thank you, Scott. Did you analyze communications between Kouri Richins and Carmen Lauber?
Yes.
Did they begin communicating around December of 2021?
They communicated prior to 2021, but in relation to this case and in relation to the cell phone, the CDR records, in relation to that extraction or her phone download, yes, 2021, December.
From January of 2022 to, say, March 15th of 2022, what was the volume or approximate volume of text messages between Kouri Richins and Carmen Lauber for that 3-month period?
Between the two of them, about 800 text messages.
Doing some quick math, that's about 11 per day?
Yes, about 10 or 11 a day on average.
So from March 16th, 2022 to the end of that year, so March, April, May, June, July, August, September, October, November, December, approximately how many text messages between Kouri Richins and Carmen Lauber for that 9-month time frame?
About 600, 650.
Okay, we're going to do some quick math. Is that about 3 per day?
It's about 3 per day.
Now, to be clear, I'm not asking you if they communicated 3 times a day, right? Just doing the average, that's about what it would come out to.
Right. It's about a 70% decrease if my math is right.
Where does that data come from?
The call detail records between Kouri Richins and Carmen Lauber.
And because of the call detail record, we don't have the content of any of those messages.
Correct.
They've been deleted from Kouri Richins' phone?
Yes.
They've been deleted from Carmen Lauber's phone?
Yes.
We don't know what they said.
Correct.
I want to turn your attention to February 11th, 2022. Did you analyze CDR records for Kouri Richins from that time frame?
Yes.
If you could look at Exhibit 3-6, please. Do you recognize this?
I do.
Is this a call detail record for Kouri Richins' phone?
Yes.
Is this one of those documents that you reviewed in your analysis for this case?
Yes.
Remove to admit 3-6.
Stage 3-6 is admitted.
If we could please publish that document. Okay, we've been talking about call detail records. Is this a call detail record?
Yes, this is a billing version of it, but yes, this is a call detail record.
Why does it say Eric Richins at the top?
He's the subscriber, the Verizon subscriber, so it has his name on it.
Now, when we're looking at the phone number at the top, this clicker is not liking me, but I wanted to point it out. It says 1987, and that's the number that belonged to Kouri Richins, correct?
Yes.
So when we're looking at each of these individual calls on this particular document, how do you know if it's an incoming or outgoing call?
On destination, so there's, what is that, about 7 columns over where it says destination. There is it denotes that in there. And so it'll say incoming. If it's got a switch location on there, like Salt Lake, Utah, that typically is an outgoing.
Does this call detail record show the duration of a call?
It does.
Where is that on the
So
document?
just to the right where it was highlighted, where it says minutes, MIN, right, the abbreviation, that is the minute. Or that is the amount per minute of the call. Or, sorry, it's in seconds sometimes, so yeah.
Is this duration in
This is in minutes, yes. I apologize.
Did Kouri Richins make phone calls on February 11th, 2022 at 11:27, 12:36, and 12:39?
Yes, I think it was 12:27, but yes.
I might have said the wrong minute.
It's okay, yeah.
Did you determine who these calls were made to?
I did.
How did you do that?
I Googled the numbers.
Okay, and who do those numbers come back to?
Those are IRS numbers.
So on those 3 occasions, Kouri Richins was calling the IRS.
Correct.
Still talking about, thank you, Scott, for that. Still talking about February 11th of 2022. Did you analyze communications or CDR records for Kouri Richins and Carmen Lauber from that day?
Yes.
And did they communicate that day?
They did.
And do you know that from the CDR data?
Yes.
For February 11th, 2022, do you have location data related to Carmen Lauber's cell tower use on that day?
Yes, from her device, yes.
And did that come from the call detail records?
Yes.
Scott, if you could show the witness exhibit 3-8D, sorry, 38D. If you could zoom out just a little bit so that we can see the whole.
We can access screen.
Oh, it's my screen. I see. Everyone else can see the whole thing. Okay. Do you recognize this?
I do.
Did you help create this?
I did.
And did you do that using the CDR data we've been talking about?
Correct. I provided the call detail information to the graphic designer that created this exhibit.
Does exhibit 3-8D accurately depict the raw data that you analyzed?
Yes.
Move to admit 3-8D.
Okay. Stage 3-8 Delta is admitted.
If we could please publish. So what are we looking at here? Describe for the jury. And if it's easier for you to step down, you can. But what's at the top?
You know what? Yeah, maybe I will step down actually.
Because I have this clicker, but maybe it will work better. You can try to use this. It's just a little bit.
That does not work.
That wasn't just me.
You can tap that like this. Thank you, sir.
Yeah, okay,
Okay, go ahead and describe what we're looking at here.
Right. What we're looking at is a representation of the call detail records that Ms. Shervinick mentioned. What you have on the right-hand side is going to be the text communications between Ms. Richins and Ms. Lauber for February 11th, 2022. There's just a photo so you know whose device we're referring to. A photo of Ms. Richins, a photo of Ms. Lauber. The blue bubble with the 3 dots indicates that this is a text message, and then the arrow is going to depict which direction that call. So, for instance, the very first one at 3:22:44 is an outgoing message from Ms. Richins to Ms. Lauber at that time. And so these are on the right-hand side. These are going to come up so that you can see when the two communicated, the volume of the communication, and then also the direction. Okay. On the left-hand side is a representation of essentially the Davis County and Salt Lake County Valley areas. And you're going to see locations pop up on these on this map as we move through the record chronologically. What those, for instance, there you go, thanks, Scott. So this is a tower location. It's pointing to the location of the tower. That's important, not the device, but the tower. of that Miss Lauber device is utilizing at 4:11 p.m., for instance. Okay, Mr. Crozier's record was also populated into this as well. And at the same time, at 4:11 p.m., Mr. Crozier is pointing towards a tower location in the Davis County area. So you know which tower their devices are using. On the left-hand side, these are going to move. And what that depicts is the movement of the device as they reacquire different towers. Okay. And then on the right-hand side, as we go through the slides, it's going to start populating. So Scott, you can start populating. So at 4:11, this represents a phone or a communication between Miss Lauber and Mr. Crozier, and this is their respective locations. You can see on the right-hand side through the 4 o'clock and the 5 o'clock hour, beginning in the 5 o'clock hour, Miss Richins and Miss Lauber continue to communicate via text. At 5:05, Miss Lauber is still in the Heber Valley area. And that picture that you just saw was a photo from that time frame that was recovered from Miss Lauber's cell phone device. All right, so you can see at 5:05, Miss Lauber is now, her device is now hitting on a tower in the Provo Canyon area out near the reservoir. And Mr. Crozier's device is using a tower at 5:20 p.m. up in the Davis County area. And on the right-hand side, you're going to see
have a nice night.
Miss Richins and Miss Lauber continue to communicate with one another. And Miss Lauber's device is traveling down Provo Canyon and into the Utah County area. That device is now heading into roughly the Utah County area. It's utilizing towers in those locations, and eventually it's going to move north. And you can see Mr. Crozier's device has now jumped significantly. I want to explain this to you, the jury, because this is important. Mr. Crozier's carrier is T-Mobile. Okay, so his carrier does not provide location data for these records for text. It's only calls. So the only time Mr. Crozier's location is going to appear to change is when his device is utilizing a tower for a call. Miss Lauber's was more detailed. This isn't all of every single pinpoint of every single tower, because every single text she made utilized the tower. But for the sake of not cluttering this up with a bunch of repeats on top of each other, you can assume that from the previous point to the next point, she was utilizing the tower before it. So she was utilizing the tower near the reservoir for several texts, and then now she's using this one in the Utah County area. All right, Scott. Yep, so Mr. Crozier's device is now moved a little bit farther south and utilizing a tower there. In the 6 o'clock hour, Miss Lauber and Miss Richins are communicating via text, and Miss Lauber is now arriving on a tower at or near the area of, it's in Draper, Utah, near the area of a Maverick store that's there. Mr. Crozier is heading in the same general direction, utilizing a tower in the same area. You can see on the right-hand side, Miss Richins and Miss Lauber are continuing to communicate via text. And then at 7:21, we have Mr. Crozier and Miss Lauber utilizing the same tower. They're not talking to each other, but they are utilizing the same tower near that Draper location. And this is that location. So on the left-hand side, you can see there, Mr. Crozier and Miss Lauber at 7:21 are making their respective communications. Their devices are using this tower, which is located across the freeway from this Draper, from this Maverick store in Draper, right off the freeway. Miss Lauber and Miss Richins continue to communicate into the 7 o'clock hour. This photo was recovered from Miss Lauber's phone download, depicting her with another woman during this time. There's another photo. And by 8:20, Miss Lauber's device is now moving south and utilizing towers south of that Draper location. And by 8:47, Mr. Crozier has made or received a phone call, because we know that's the only records his denote towers, and he's moving back north towards the Davis County area. And then Miss Lauber by 8:56 is utilizing a tower in the Heber Valley area. Miss Lauber remains in the Heber Valley area, and then on the right-hand side, sorry, Scott, but if you can go back one slide, Miss Richins and Miss Lauber continue to communicate into the 9 o'clock hour via text. So from 3:42 to 9:02, the defendant, Miss Lauber, communicated 34 times via text. During the same time, Mr. Lauber, or Miss Lauber and Mr. Crozier communicated 50 times via text and 6 times via voice call.
Did you also look at communications from February 11th, 2022 between Carmen Lauber and Robert Crozier?
Yes.
Did they communicate on that day?
Yes.
And is that information from the call detail records?
Yes.
Scott, if you could show the witness Exhibit 3-33D. Do you recognize this?
I do.
Similar to the last exhibit, something that you helped to create?
Yes.
And using the call detail records that you were just describing?
Yes.
Does Exhibit 3-33D accurately depict the raw data that you viewed in this case?
Yes.
Move to admit 3-33D.
Your Honor, no objection. If the following testimony is going to be similar to the last one, perhaps we can ask some questions. I think we all understand where they're traveling and what it means now, just to move things along.
3-33D is admitted. Would you like to publish?
Yes, please. Okay, so similar to the last exhibit that we looked at, is this one laid out the same way?
It is, yes.
And the last exhibit was depicting communications between Carmen Lauber and Kouri Richins, and this one is between Carmen Lauber and Robert Crozier. Is that correct?
Correct.
Otherwise, the different indicators, the bubbles, the arrows, those things remain the same as the previous exhibit?
Yes.
The map that we're looking at, the area of the Salt Lake Valley remains the same?
Yes.
And then similarly, as we see the different pictures of the people moving, that is the cell phone towers that their device is utilizing at those different times.
Correct.
Scott, if we could move through this exhibit, and Mr. Kouri, if there's anything that you want to note regarding the communications between Robert Crozier and Carmen Lauber.
Right. I think if we just, for the sake of time, like Mr. Ramos just said, we can just slowly click through those, Scott, and I can just describe to the jury what they're saying. It's the Miss Lauber and Mr. Crozier are communicating at 11 p.m., almost noon, and then into the 5 o'clock hour, and then again you see Miss Lauber's device move out of the Heber Valley area into the Utah County area, where it will ultimately end up in the south end of the Salt Lake County area, and I believe utilize a tower at or near the Draper once again. And Mr. Crozier's device is moving south out of the Davis County area once more. They're located in at or near the exact same location for a period of time, and then they return. Mr. Crozier returns back to the Davis County area, and Miss Lauber returns back to the Heber Valley area. Yeah, there's another. That's that representation of that 721 phone call.
Thank you, Scott. I want to turn your attention to February 14th of 2022. If we could put up Exhibit 3-6, that one's already been admitted.
Do you want to show it?
Yes, please publish it to the jury. And Scott, if we could expand on the phone call at 8:53 a.m. So from these records, did Kouri Richins make an outgoing phone call on February 14th at 8:53 a.m.?
Yes.
Did you determine who that number belongs to?
I did.
Who does it belong to?
As the Mirror Lake Diner.
Thank you, Scott. For February 14th of 2022, did you analyze communications between Kouri Richins and Josh Grossman?
Yes.
Scott, if you could show the witness 2-27D and scroll through so we can see all of it. Do you recognize this?
I do.
Did you help to create this, or did you create this?
I created this one.
And does Exhibit 2-27D accurately depict the raw data that you analyzed for this case?
Yes.
I'll move to admit 2-27D.
Okay. States 2-27D is admitted.
If you could publish that, Scott. And if you could scroll through the pages, and then I'll ask Mr. Kouri about the last page. What are we looking at that's depicted here on the last page of this exhibit?
This is an image that was contained within that text thread that was sent by Ms. Richins to Mr. Grossman.
And it was sent approximately an hour before that arrival time. Is that correct?
Correct. This follows the text in which Mr. Grossman asked Ms. Richins about an hour, and she sent this below.
Thank you, Scott. Did you also analyze communications between Kouri Richins and Eric Richins on Valentine's Day, 2022?
Yes.
If you could show Mr. Kouri 2-28D and scroll through it so he can see the whole exhibit, please. Do you recognize this?
I do.
Is this an exhibit that you created?
Yes.
Does Exhibit 2-28D accurately depict the raw data that you analyzed in this case?
Yes.
Move to admit 2-28D.
Okay. States 2-28D is admitted.
We could publish, please. And Scott, similar to the last exhibit, I'll have you move through. And Mr. Kojidimas, it's kind of clear from the to and from, but who is going to be typing the messages that are in the green bubbles?
All right, so the green is from, and that's the 9317. That's Eric Richins, and the to, or the recipient in this would be 1987, which is Kouri Richins.
And so her responses, Kouri Richins' responses are in blue. Is that correct?
Correct.
If I may, perhaps for purposes of these messages, if you're going to give the instructions and what that you've done in the past as to the hearsay, as to Mr. Richins, maybe just at once we all know if I saw them.
So, fair reminder. The statements.
Okay, sorry guys, I was trying to. Somebody sent me something. Sorry. Okay, what am I reading? What am I reading? What's the tampon attack? What's the thing? Like read it. What? What am I reading? Somebody sent me an email. I was trying to read the email. What's up? What's up? What are we jizzing our panties for here? Guys, what are we jizzing our panties for? I was trying to read an email. Go back like 2 minutes. The text. What? Okay. Okay, sorry. I was busy trying to do something. Okay, good morning. I'm carpooling and Valentine's Day. Cool. Ooh, good text. Good text, chat. Leaving the school. Headed that way. More bangers. More bangers. Liked, headed that way. More bangers. Hour-long ride. Another banger. I love you. Another banger. K-Babe to Josh Grossman. That's the her new boyfriend, right? Wanna be one of my Valentines? I love you. So from Josh to Kouri, okay. I'm just saying, you guys are like, ah! It's like I'm trying to work while we're doing this. Want to be one of my Valentines? Well, these are a bunch of drug losers, so. Words coming is very unique. Those feelings coming from you bring up different feelings in me. Your love reminds me how much God loves me. Reminds me that I am secretly the luckiest man on the face of the earth. Gives me immense amounts of appreciation, gratitude, and honor. I would trade your love in for a million of you name it, whatever is next best. Darling, you better believe that I'll be one of your Valentines. Will you be my Valentine tonight? I was writing this on the way to Salt Lake. I know you feel the need to apologize, but so you know, I like to see you on phone calls. I like to watch you text and hear what you read aloud. I see beauty, intelligence, quick wit, cuteness, and authenticity. It's like seeing a white tiger in a tropical forest instead of remembering one at the zoo. I love it. There you go. Who says romance is dead? Who says romance is dead? I apologize, guys. I was in the middle of trying to take care of something really important. I'm making sure, like, okay, it's just you guys are like, go back and read. It's like, what's going on?
An image that was contained within that text thread that was sent by Ms. Richins to Mr. Grossman.
And it was sent approximately an hour before that arrival time. Is that correct?
Correct. This follows the text in which Mr. Grossman asked Ms. Richins about an hour, and she sent this photo.
Thank you, Scott. Did you also analyze communications between Kouri Richins and Eric Richins on Valentine's Day, 2022?
Yes.
If you could show Mr. Kotrodimus 2-28D and scroll through it so he can see the whole exhibit, please. Do you recognize this?
I do.
Is this an exhibit that you created?
Yes.
Does exhibit 2-28D accurately depict the raw data that you analyzed in this case?
Yes.
Move to admit 2-28D.
Okay. States 2-28D is admitted.
We could publish, please. And Scott, similar to the last exhibit, I'll have you move through. And Mr. Kotrodimus, it's kind of clear from the to and from, but who is going to be typing the messages that are in the green bubbles?
All right, so the green is from, and that's the 9317. That's Eric Richins, and the to, or the recipient in this would be 1987, which is Kouri Richins.
And so her responses, Kouri Richins' responses are in blue. Is that correct?
Correct.
I didn't get all pissy. I'm trying to mock you guys a little bit. You're like, Sean, read the text. Ah! It's like, calm down. Like, I thought you were gonna tell me like there's like a "I'm gonna fuck you to death with a cactus" text. Not just being a little gay. I mean, I'm more romantic to 2.0 in text.
We give the instructions that you've done in the past as to the figure state next to Mr. Richins. Maybe we just do it once. We all know identify all of them.
So, fair reminder. The statements by Ms. Richins on her side of that conversation, you may consider those for any purpose. You may give them the weight you deem appropriate.
Your Honor, may we approach?
Sure.
And I'm just fucking with you guys. Like, just yes. Read the text. You guys are awesome. Love you guys. Yes, you could almost say polyamorous. Yes, Joe's right. More like read the text.
Eyes for the jury.
All right, chat. I'm gonna refresh and see, because I still haven't heard from Afix. I hope he's okay. He did not. He was working on this. I promised Sean to be shirtless tonight. Well, yes, they're aggressively monogamous. They were in a very serious and romantic relationship. Let's see if we can get closed captioning finally. There we go.
Okay.
About damn time.
This is a good time to take a restroom break. If everybody would please rise for the jury. Which were specifically regarding 2-28D. And Scott, I don't have control over these, so I need you to go back to page 1, zoom in for me. Okay. He's an expert. I imagine the state's going to tell me the exclusionary rule won't apply to him, but
I'm just curious.
Yeah, so I don't think so. Yeah, if you need to use the restroom, that's one thing. Okay. So the first green bubble in 228, I've already ruled is a present sense impression and is admissible. Any further record there, Mr. Ramos?
That was early on.
Yeah. Okay. So keep scrolling, Scott. Then we have a blue bubble that represents. I need the second green bubble, please, Scott.
Just the green ones.
Oh, okay. Second green bubble, please, Scott.
So
that's the first one.
On the first page. So there's first page. There's only one green on ours.
Oh, I'm sorry. Okay, can we go to the second page, please? And then the.
No, we did that one.
No, we didn't. It's okay. So highlight that one for me, Scott. Oh, I can see it. I'm sorry. I'm so sorry, Scott. Go back to page 2 on Zoom. Green bubble states, "Are you home?" Any objection, Mr. Ramos?
No.
Okay. Third bubble says, "In the office, I've been sleeping out here." That I think is also present sense impression that I previously ruled on. Okay, go to page 3, Scott, if there's one. Green bubble. No, it's quiet out here. I think it's the same. And then, Mr. Ramos, I'm going to pause if I just. Okay. And then get to the end of this 228D, Scott.
This is a total of 7 pages.
Oh, I'm sorry. One page at a time. I just need to analyze each green bubble.
This is the next set of green bubbles here.
This one's good. We can go to the next one.
No, we're not seeing the same thing Scott is. Hold on a
Oh,
second.
we're not seeing what you're seeing. That's fine.
My apologies. Scott, if you'd unplug and plug back in for me, I'd appreciate it.
I think we're on page 4. Page 4, Your Honor, didn't have the green bubble.
Understood. Let's go to page 5. Okay, wish you were here. And then a question mark. Mr. Ramos, any objection?
No.
Okay, go to page 6. Thanks for answering. Any objection?
No.
Okay, page 7. I can't read it, Scott. Sorry, can you? Thank you, sir. We are headed in there. Food is on the front seat of my truck. Any objection, Mr. Ramos?
No.
Okay, so with respect to 228D, there are no hearsay issues. we've already admitted certain exhibits. Ms. Sherbanek makes a fair point at sidebar. We'll need to be a little bit precise about these going forward. So we can just slow down. If there comes a time when you need to make a specific objection regarding a specific part of a conversation, just say objection, maybe approach.
If we can go slow through them, and then I'll just, yeah, we'll be fine.
Okay. Anything further on that, Ms. Sherbanek?
Yes, Your Honor, only that, can you give the jury an instruction now that what you told them before?
I didn't complete the thought, but I can clear it up.
If we could just clarify for them that that blanket rule
Yeah,
does
I
not
can-
apply to this exhibit.
Well, no, and also I shouldn't call it a blanket rule. So that they may consider both sides of 228D for any purpose. Okay.
Thank you.
Thank you.
What we'll do is we'll meet with them during this break real quick and see if I can just go through them.
I appreciate that. All right. Let's come back at, to allow you time to do that, 2:40. Thank you. Court's in recess. You're welcome to use the restroom. Don't talk.
All right, guys. So they're gonna skip ahead here. Wet Droid. Wet Droid edition. Hello. Hi. Hello. Stephen Cooper, I have returned. Well, hello. Good to see you too. Yes, there's an exhibit that Scotty doesn't know. Because Scotty doesn't know. Because Scotty doesn't know. Oh. Don't tell Scotty. Scotty doesn't know.
All right, the jury.
Folks, feel free to have a seat as you come in, please. Have a seat, please. Ladies and gentlemen of the jury, before we took a break, I misspoke and created some confusion. Let me clear that up now. States Exhibit 2-28D, as in Delta, is a February 14, 2022 text exchange between Eric Richins, as depicted in the green bubbles, and Kouri Richins, as depicted in the blue bubbles. The jury may consider either and both sides of that conversation for any purpose. You may give either and both sides any weight you think they deserve. Ms. Sherbanek, take it from there.
Thank you, Judge. If we could put 228D up on the screen. I don't know if we got through the whole conversation before. I forget where we left off. So I'm going to have Scott go through this conversation for the jury with that new instruction in mind.
On the front seat of the truck, chat food.
In addition to these text messages, did you also analyze Eric Richins' device data, sensor data, I guess, for February 14th of 2022?
Yes.
If we could show Exhibit 314D, please. Do you recognize this?
I do.
Is this an exhibit you helped create?
Yes.
Does Exhibit 3-14D accurately depict the raw data that you analyzed from Eric Richins' phone?
Yes.
Move to admit 3-14D.
Okay. States 3-14D is admitted.
If we could publish, please. When you analyzed the movement data from Eric Richins' phone on Valentine's Day 2022, we're looking at a graph here. What does this graph depict?
The graph depicts travel, so in distance in blue, and in energy exertion basically in green, and the in frequency hour to hour on February 14th, 2022.
Was there a gap in Eric Richins' movement and the other data that you just referenced during the middle of that day?
Yes,
Is that denoted here in the blown up portion? What do we see?
it is. There's a data set on the left-hand side for flights climbed, distance traveled, and steps depicting. So this is a portion. Well, actually, this is the 12 o'clock hour. And then on the right-hand side, there is device activity for depicting steps and distance traveled at 1:32.
And so from this data, we can tell that from approximately 12:05 to 1:32, there was no movement data recorded on Eric Richins' phone.
Correct.
Did you analyze his phone for similar types of movement on other days?
Yes,
And did you compare the data from Valentine's Day to those other days?
I did.
Was it unusual for Eric Richins to have an 87-minute gap in his activity in the middle of a workday?
It wasn't typical, no.
Thank you, Scott. I want to turn your attention to February 26th of 2022. Did you analyze communications between Kouri Richins and Carmen Lauber on that day?
Yes,
Scott, if we could show Mr. Kotrodimus 3-16B. Do you recognize this?
I do.
Did you help create this?
I did.
Is this using the CDR data that you analyzed for this date?
Yes, this is essentially the same type of exhibit that was created for February 11th.
Does Exhibit 3-16D accurately depict the raw data that you viewed for February 26th?
It does.
Move to admit 3-16D, please,
States 3-16D is admitted.
and publish to the jury, please. So we saw an exhibit like this before for
Yes.
February 11th.
Yes, we did.
Are we looking at information now pertaining to February 26th?
We are on this. This exhibit is text communication between Ms. Richins and Ms. Lauber on that day.
And similar map of the same area?
Yes.
Arrows denoting who sent the message?
Yes. The times they were sent and received and direction. Yes.
Now, these pictures are kind of small, but similar to the last exhibit from February 11th, Ms. Richins is denoted with the red background. Is that correct?
Correct. She's on the left side there.
And Ms. Lauber is denoted with the green background?
Correct.
And then we also see Robert Crozier on these exhibits, and he's in the yellow background. Is that correct?
Yes. He will come up. There he is. He will come up on the map there on the left-hand side.
And again, Scott, if we could move through this exhibit, and Mr. Kotrodimus, if you could describe what we're seeing as we go through this
Sure.
process for February 26th.
Sure. On the right-hand side, similar to the other day, there was text
There's
communication
quite a
between
bit
Ms.
of
Richins and Ms. Lauber through the
circumstantial
2 o'clock hour. It picked back up in the 5 p.m. hour. And at some point during the 5 p.m. hour, Ms. Lauber's device started utilizing towers in those same locations from the previous day. Provo Canyon, Utah County area, traveling north until it finally stopped in the area of the southern end of Salt Lake County. Same thing with Mr. Crozier's device, beginning once again in Davis County and moving south and utilizing towers along the way. So Ms. Lauber is now on the left-hand side. You can see by 7 p.m. or so, she is utilizing towers back in Provo Canyon, heading back to the Heber Valley area where she ultimately ends up. Mr. Crozier has returned back into the general area of the Davis County area by 8 p.m. And then you saw all the communications between Ms. Richins and Ms. Lauber, 71 texts between 2:25 p.m. and 10:33 p.m. that day. And Mr. Crozier and Ms. Lauber, 65 texts and 3 phone calls.
Now, similar to February 11th of 2022, did you look at the communications between Carmen Lauber and Robert Crozier for February 26th of 2022?
Yes.
If we could show Mr. Kotrodimus 3-34D, please.
Excuse me.
Do you recognize this?
I do.
Is this an exhibit that you helped create?
It is.
And does 3-34D accurately depict the raw data that you analyzed for that date, February 26th?
It does.
Move to admit 3-34D
States 3-34D is admitted.
and publish to the jury, please. Okay. We've seen one of these before.
Yes, we have.
We know the data that's on here. If we could, Scott, move through this at Mr. Kotrodimus, as you just described.
Yeah, so there's the 4:01 p.m. Call from the previous slide. Mr. Crozier is in Davis County. Ms. Lauber is in the Heber Valley area. To the right, those are the communications between the two. There's text and some phone calls. You can see the date stamps next to those. Essentially, what this exhibit shows is the other side of that communication or that incident or event between Ms. Lauber and Ms. Crozier. Mr. Crozier and Ms. Lauber. Sorry. The two devices appear to travel in the same direction until they come to the same generalized location, utilizing those towers, and then return back to their respective starting points.
And that location that they're meeting up at, same as February 11th, 2022?
Yes, it's consistent with that, with the Draper area near that Maverick.
Thank you, Scott. Did you analyze, moving now, to March 2nd of 2022, did you analyze CDR data for Kouri Richins' device from March 2nd, 2022?
Yes.
Scott, if we could show Mr. Kotrodimus 3-17, please. Do you recognize this?
I do.
Is this the call detail record for Kouri Richins that has March 2nd?
Yes.
We'll move to admit 3-17.
317 is admitted.
And if we could show the call from 10:22 a.m., please, from March 2nd. And 10:27 a.m. Is that the same
same number that we see from the call at 10:22 and the call at 10:27?
It is the same number, yes.
Are those-
Ending in 1040.
Are those outgoing phone calls from Miss Kouri Richins?
Yes.
Who was she calling at 10:22 and 10:27?
That's the IRS.
What is the duration of the call made at 10:27?
The first call is 3 minutes, and the second call at 10:27 is 101 minutes.
Still talking about March 2nd of 2022. Did you look at communications between Kouri Richins and Eric Richins on that date?
Yes.
If you could show the witness 2-37D. Do you recognize this?
I do.
And is this an exhibit that you created?
Yes.
Is this a text message thread between Eric Richins and Kouri Richins?
Yes.
We will talk about the content of this exhibit at a later time. I just wanted to lay out the information that you're aware of what it is and where it came from.
Okay.
I now want to turn your attention to March 9th of 2022. Same questions as February 11th and
I
February
do.
26th.
Always
Did you look
blame
at
Kat.
communications between
Kat's
Kouri
always
Richins and
wrong.
Carmen Lauber for March 9th of 2022?
Yes.
We could show Mr. Kotrodemus 3-35D.
Jeez, so mean.
Do you recognize this?
I do.
Is this an exhibit that you helped create
It is.
using the CDR data that you just talked about?
Correct.
Does 3-35D accurately depict the raw data contained in that CDR information?
Yes.
We'll move to admit 3-35D
States 3-35D is admitted.
and publish to the jury, please. Okay, so we've seen these before.
We have.
We're looking at the same area of the Salt Lake Valley, and again, communications for March 9th, 2022 between Kouri Richins and Carmen Lauber. Is that correct?
That's correct.
Scott, if we could move through this exhibit, please.
And this is just the same representation of those records. It shows essentially the same travel, and it depicts the conversations, text conversations or communications between Ms. Richins and Ms. Lauber's devices. So we got 10 o'clock hour, 11 o'clock hour. Ms. Lauber's moving. She moves a little north in this. If you want to stop it right there, Scott, just for the 12, 11, 12, 13. She moves north out of the Heber Valley for this particular event. That tower at 12:11 p.m. is located very close to the Richins residence. Other than that, the travel is going to be depicted in a similar manner. Ms. Lauber is going to travel same route through Provo Canyon into the south end of the Salt Lake County area, in an area consistent with being at or near the Draper, the Maverick and Draper. And Mr. Crozier is going to do the same thing. He's going to travel south, and his device is going to utilize towers in that direction as well. On the right-hand side, you're just seeing more communications between Ms. Lauber and Ms. Richins from that day. So Mr. Crozier and Ms. Lauber's devices are coming together, utilizing the same tower in that area. Again, that's the tower across the freeway from the Maverick and Draper. Then the two will depart, or presumably depart, and their devices are utilizing different towers until they return to their respective starting points.
Did you look at communications between Carmen Lauber and Robert Crozier from March 9th, 2022?
Yes.
We could show the witness 3-36D. Do you recognize this?
I do.
Is this an exhibit that you helped create?
It is.
Is it using the raw data from March 9th, CDR data from March 9th, 2022?
Yes.
Does 3-36D accurately depict the raw data you just described?
It does.
Move to admit 3-36D.
3-36D is admitted.
Again, we've seen this before.
Yes.
This is for March 9th of 2022. And this exhibit, who are the communications between in this exhibit?
This is communication between Mr. Crozier and Ms. Lauber for that day, March 9th.
And Scott, if we could move through this exhibit, please.
And you've essentially seen the map before on the previous slide between Ms. Crozier and Ms. Lauber. The thing that's different on this is the communications are just between Mr. Crozier and Ms. Lauber, or Mr. Crozier and Ms. Lauber. Again, 11 o'clock hour, 12 o'clock hour, they're communicating. The devices essentially come together into the same general location, utilizing a tower there. Again, that depicts the tower and across the freeway from the Draper Maverick. The two parties continue to communicate until they return to the Heber Valley area and the Davis County area, respectively.
So far, we looked at communications and location data for February 11th, 2022, February 26th, 2022, and March 9th of 2022. Other than those three occasions, did Carmen Lauber ever visit that Maverick and Draper in all the data that you reviewed?
No, her device was never in that general area.
Did she ever meet up with Robert Crozier? Did their devices come together at any other time other than those three occasions that we've talked about here?
No.
I want to turn your attention to March 3rd, 2022. Did you analyze data from Eric Richins' phone from the night he died?
Yes.
You looked at call records
Yes.
and you looked at text messages and web searches.
Yes.
We could show the witness 3-39D. Do you recognize this?
I do.
Is this an exhibit that you helped create?
It is.
Does it accurately depict the raw data that you reviewed from Eric Richins' phone?
Yes.
Move to admit 3-39D.
3-39D is admitted.
You could publish this to the jury, please. So you might want to step down for this so we can just describe for the jury what we're looking at here.
Sure. So this is at the top. It's headed. The heading is Eric Richins' phone activity, March 3rd, 2022. This is from 8:30 p.m. that evening until midnight. It's basically just a moving timeline, so you can see what Eric's device was doing during that time period in context to text messaging and web searches, that type of thing. So at 8:30, there's a text to a contact named Pedro Sonora, and then there's a text from like 9 seconds later. Those continue. There's a few of those, and then there are texts between Eric Richins' device and a contact named Scott Wagner in that device. Those continue into and through 8:30. There is a discussion going on between Mr. Richins and Scott Wagner, kind of back and forth during that time. And then at 8:50 p.m. on that day, Scott Wagner calls Eric Richins, and they talk for 8 minutes and 32 seconds. At 9:45 p.m., a Google search is made from Eric Richins' device. There's a misspell in it, but he's basically searching how far is it from Scottsdale to Nogales. And then at 10:18 p.m., there's an incoming text from a contact titled Raul C&E.
Thank you. For that last text message that's listed in the 10 o'clock or 10 p.m. hour, was there any indication that that message was opened by Eric Richins?
No.
During this time frame from 8:30 p.m. to 12 a.m. on March 3rd,
he died leaving
it made on Eric Richins' device.
Imagine that you're the last person that sent him something, and he was alive when he received your message, and he left you unread for the afterlife. Like, he's like, I don't want to read your stuff so much, I'm willing to die in the meantime. That's got to be very embarrassing. Very embarrassing.
One.
That's the phone call that you talked about to Scott Wagner.
Correct.
No other phone calls made on that device that night.
No, between 8:30 and midnight, no.
Talking about same time frame, the night of March 3rd, 2022, did you look at Kouri Richins' phone for that same time frame?
Yes.
Did you analyze the data and device events for that phone?
Yes.
If we could show 3-18D1. Do you recognize this?
I do.
Is this an exhibit that you helped create?
Yes.
Using the raw data from Kouri Richins' phone?
Yes.
Does 3-18D1 accurately depict the raw data that you reviewed?
It does.
I'll move to admit 3-18D1.
No. 318D1 is admitted.
We could publish this, please. Similar to Eric Richins' device, I guess not showing communications, but what are we looking at here for this device data?
So there's an activity sensor and device events for that device.
When you say device events, what do you mean?
So there are certain events that are captured in a device in the system files that detect various things. One of those things is locks and unlocks, meaning when you locked or unlocked your phone. The activity sensor is device movement. So there are accelerometers and gyroscopes and whatnot inside your device. And
we
when
learned
it
from
moves and
Alex
it detects
Murdaugh.
movements, it reports that to the system files and it retains that.
I now want to talk about March 4th of 2022. For Kouri Richins' phone, did you look at movement and device events for Kouri Richins' phone for March 4th of 2022?
Yes.
If we could show exhibit 3-18D. Do you recognize this?
I do.
Did you help create it?
Yes.
Does it fairly and accurately depict the raw data that you reviewed from Kouri Richins' phone?
Yes.
Move to admit 3-18D.
Okay. 3-18D is admitted.
So walk us through, there's some different things here. Maybe you want to step down to the screen to show the jury what these different markers on this exhibit mean.
Sure. So we have a device event. The first thing we have per device event on that day or in that morning is 3:06:50. The phone is unlocked. That unlock is for 28 seconds. Ooh. At 3:07:04, there's a speaker activation.
Okay, here we go.
What that is there's an audio output route. There's audio routing in a device through the system files, and it detects when the speaker is activated. So anytime the phone is using the external speaker, you should get a system file report or an audio output report on that, and it'll tell you that the speaker's in use. Okay. At 3:08:10, the activity sensor picks up that a device travels 243 feet. So the 3:08:10 is the beginning of that trip. It's not the end of that trip. And at 3:10:37, the phone is unlocked for 1 minute 40 seconds. At 3:15:59, the phone is unlocked again for 37 seconds.
300 feet's fucking
At
weird.
3:19:07, the phone is unlocked once more for 28 seconds.
Where the hell is it
And at
going?
3:19:39 a.m., the phone is unlocked briefly for 3 seconds. We have a timestamp for a 911 call at 3:21:05. We have a receiver activation. We have a device, another activity movement, meaning the device is reporting that it had moved again. And then at 3:22, there is a receiver activation. And a receiver activation is when you hold a phone or a device up to your ear, say presumably your face to make a phone call. There's a proximity sensor inside the device that activates the receiver. And so there's an activation there at 3:22:12.
Thank you. You talked about the receiver activation. Is it possible that a call can start before the receiver is being used?
Yes.
How does that work?
If you dial a number, for instance, the receiver activation only reports when you place the phone up to your. It has to detect a proximity sensor.
So it's a movement.
It's a movement. Yes.
It's pretty cool the amount of science that goes into cell phones.
Did you also pull or look at data from Kouri Richins' phone from the morning of March 4th, 2022?
Yes.
We could show the witness exhibit 3-19. Do you recognize this?
I do.
What is it?
These are 3 thumbnails, PNG files recovered from Ms. Richins' device.
Does 319 accurately depict the raw data that you analyzed from Ms. Richins' phone?
Yes.
Move to admit 3-19.
Well, they want to avoid hearing about something. Here we go. Yeah, Kouri said she was asleep. Obviously, she wasn't. I want to know where the hell the phone traveled for 300 feet, because that means it went outside the house, I bet. Unless that's not an accurate count. Like, what the hell happened where the phone went 300 feet? I'm hoping that could be explained, because I'm like, that doesn't mean I'm like guilty, not guilty. I just like, I want to know what the fuck, like, what did she do that the phone's like, oh yeah, I moved 300 feet? Because that's a lot of feet to move. I get it's a master bedroom and they have a big house, but it's not that big. So, pacing around a room would do that too? Yeah. Maybe. I guess. She getting pacing in the house? Yeah. I guess. It just seems a little off to me, chat. It seems a little off. She's just sitting there like, she's all fired up. She's like, that bitch, I'm going to kill her. She's like, I'm going to see that bitch go to prison.
Sherman, please proceed.
Looking at Exhibit 3-19, you testified these were located on or in the analysis of Kouri Richins' phone. Where specifically in that data were these images located?
They were in the image folder. They're in the image files.
What does describe what the image file is? Is that a camera roll, or just more description about what an image file is?
So as it relates to these are PNG files. They're located in the image portion of. So if you open the extraction and you're analyzing it and you look under images, these are actually found in the timeline as well. Like you can just see them in there. But when you click into those, there's information that's presented to you, and it will tell you the file path where these belong, or where they were last seen by the device. And so in the image file, there's a pathway. And so these images were last seen in a SMS, so a text, like an iMessage. Photo search section is the pathway for those, meaning it was related to the messaging system inside the device.
I'll move to admit 3-19.
Mr. Rollins.
Can you explain a little bit more foundation in terms of which people in the text message chain communicated that they were indeed?
I'm not sure that's what he said, but
Or if we could get clarification on that.
sure. Mr. Sherman, asking another question about I heard the words photo search related to the SMS function.
Right. So let me be a little more precise with my questions.
Okay.
Were these part of a text message?
At some point, yes.
Do you know if that text message was incoming or outgoing from Ms. Richins' device?
No.
Why not?
Because the original images and the source of these images was deleted from the phone. It no longer exists on the phone. These 3 PNG files are what we call ghost or orphaned images. When an image is, like when a text is built and you add images to it, or when you receive images and you click those, it creates a print of it, like basically a thumbnail of it. Now, if you send that text or receive that text, and then you delete it from your system, and then the database overwrites it because of time has passed and there's no more room in that file, you'll never know the source of that text, whether it was incoming or outgoing, who sent it, that type of thing. All you're going to see is the remnant of that. And that's what these are, the small PNG files.
Again,
They're orphans. No one loves them anymore.
What Mr. Cortez found to remnant something.
I understand defendant's objection. It is respectfully overruled. You can explore these topics during cross-examination. State's Exhibit 3-19 is admitted.
We could publish, please.
No.
So these are
She's
the
trying to
images
build a
you were just
church.
describing.
Yes.
And you described that they were found in the image files as a remnant of possibly a text message.
Right. I would say a remnant. It's a thumbnail. I mean, it's a PNG file. I mean, it's a thumbnail. Yes.
From the data that you analyzed, were you able to tell if these images were accessed by Ms. Richins' phone?
They were accessed by the system in her phone. Yes.
How do you know that?
It gives an access indication in the file path, in the data and the extraction. It'll say when the device was accessed, and it will give a timestamp.
When we say accessed, what does that mean?
It just means when the file or when that image was either selected or viewed or, I mean, accessed. Yeah.
But it means it was selected or viewed by the person with that device.
Correct.
You mentioned there was a timestamp. When were these images accessed on Kouri Richins' phone?
8:29 a.m. on March 4th.
Was the phone also manipulated in some way during that same time?
There was activity on that device. Yes.
What do you mean activity?
There was prior to that at 8:28. There was an unlock event that lasted the duration of this access point. There was the device event log showed that the device was actually turned into portrait view and then turned into landscape view, turned back into portrait view until ultimately it was locked again. I think the lock was at 8:34, but I'm not 100% sure on the time.
So those, the turning of the phone, the unlocking of the phone, those correlate with the time that these images were accessed?
Yeah, around the same time. Yeah, during the same unlock event.
So now I want to turn your attention to the post April 13th, 2022 phones from Kouri Richins. We know from
Yes,
Scott,
let's get the meme.
3-37
Yes, let's look at her meme folder. Yes, I agree, Jeff.
D, please. And you can publish that to the jury. It's been admitted. So I'm referencing this, the date on here when the silver phone and the blue iPhone were being used by Ms. Richins.
Right.
Did you look at, when you were analyzing the blue phone, did you find web searches during April, that timeframe the phone was used, that were relevant to this case?
Yes.
Scott, if you could show the witness 3-26D. Do you recognize this?
I do.
Are these web searches that were located on that blue iPhone?
Yes.
If you could show Scott 3-29D. Do you recognize this?
Yes.
These also web searches that were located on the blue iPhone?
Yes.
And then Scott, also 3-30D. Same question. Is this a web search that was located on that blue iPhone?
It's like Jesus.
Yeah, this is web history.
A web history.
Yes, which meaning the difference is one thing is a search, the other is a site visit, a website visit.
And do these three exhibits, 3-26D, 3-29D, and 3-30D, accurately depict the raw data that you analyzed for that blue iPhone?
Yes.
I'll move to admit those three.
Wet droid, I don't know if she's hot.
You don't have an objection to these searches and the.
Oh, you mean the prosecutor?
How they're going to be presented, meaning that redaction. My understanding is that Mr. Cortez did not make those redactions. So I'd like to approach and present a proposal on how to submit it.
Oh, okay. Well, it's a little weird to speak that all out. Like, you start talking about redacting shit like that. I don't think you want the prosecution to know you want stuff redacted. I don't know. I guess you just got to be careful about what you say in front of the jury because they just fucking heard all that. So let me.
Question for the jury. Scott, could you go to 26 for me for a moment? Ladies and gentlemen, as you look at 26, 29, and 30D, you'll see these blue blobs that have no text behind them. Those are intentional redactions of information that has no relevance to this case. Please do not speculate about what was behind the blue blob. It's irrelevant. Just ignore it. Ms. Shervanek, please continue.
So as we were talking about these three exhibits that we will go through in turn, you mentioned web searches versus site visits. What are we looking at here?
These are web searches.
What's the difference?
So when you type a search into your device and just presumably search for something on the internet, when you type it in and you hit send to search, it logs the search that you had typed into your device.
And so someone could search for any multitude of things. We're all aware of that, but maybe not if the results come up. If they actually click on a result, that would be a site
Right. We normally see, analysts will normally see corresponding web histories related to those searches. So if you were looking for a type of vehicle, you would have a search for a type of vehicle, like a 2026 Toyota 4Runner, and you're looking to buy one. And then right behind that, you'll see web history, meaning what happened was you typed in that search field, it popped up, and then there's some suggested websites for you to go to based on your search. And if you click through to those will show as a web history, meaning a site that you actually visited.
And so what are we looking at here?
Right here, we're just looking at the search function. These are just searches that were inputted into the device.
And this is in that blue iPhone, right?
In the blue iPhone, yes.
Scott, if we could do the same expanding for each page of 2-2060 so the jury can see the different entries.
What is the F? This is bad, chat. There's no. Oh. Yeah, this is it. There you go. Yeah. Uh-oh. Uh-oh. I don't feel so good, chat. Kouri bros, I don't feel so good. If you bought Kouri coin, I don't know, man. I'd be looking to sell. Uh-oh.
So we saw some web searches.
That's actually a good question that was on there. What happens if you give somebody Narcan and they don't need it? Nothing. It actually won't hurt people. Narcan is actually very safe to administer. And for example, if you were to stand there with a thing of Narcan and you thought somebody needed it and you gave it to them and it turns out they didn't, they'll be okay. So if you're ever in that situation, chat, God forbid, don't worry. Don't worry. You're going to, like, you can do that to people. It will not kill them. I had a client once. Well, I had a client's mom ask me that once, and I'm like, because his client, my client was doing drugs, and like, what happens? The one for luxury prisons, yeah. So, yeah, Narcan's super safe. So, but yeah, this is the problem though. Those could all be like, I could, how much shit you guys Google for that'll look super suspicious if someone dies around you. Yeah, that's the problem here. Like, there could be a lot of explanations for stuff. That's the rough part of this.
On 3-2060 that related to.
Yeah, well, you kind of Google everything. Yes.
Remotely wiping an iPhone or remotely deleting text messages.
Yes.
Was the blue iPhone being used by Kouri Richins in the time after her original phone, that white iPhone, was seized by police?
Yes.
Scott, if we could put up 3-29D. So when we're seeing this activity on the phone, does that indicate a website visit?
Yes.
She's doing this as her husband's laying there in the aftermath of him laying there. Holy fuck. Holy fuck. You gotta maintain some level of calm, Chad, if you kill someone. Like, if you're gonna come up with a plan where you're gonna murder somebody, you gotta have some sort of, like, you know, calmate, man. You can't just be like, you gotta be steady. Ain't no room for shaky hands. Ain't no room for shaky hands, chat. Woo, this is not good. So. Oh, why did that do that? Just, you gotta be ready, chat. You gotta be steady.
Again, this indicates a website visit.
Yes.
I mean, yes, chat, take notes. Always take notes, but you've been following along here. You already know the answers to some of these questions that she's asking. And the time to do your research, remember, guys, is not at the time of the murder, not after the murder. You have to, like, remember, like, you have to do this stuff, like, almost years in advance. Plan out a murder. Because they'll go back and find everything you've ever typed, and they'll use all of it to come after you. You have to be very careful. Oh, Afix, dude, no. Stop. You got baked and forgot, brother. I appreciate you doing that work, period. You are under no obligation to do it. Don't apologize to me. I appreciate everything you've done. So don't apologize. Don't apologize at all, man. It's all good. Okay? We only got about an hour left anyway, so it's okay. And we got closed captioning right now. So please don't apologize. Okay? I appreciate you so much, so don't worry. But this all here, chat, these are all fucking bad. Okay, cops forcing you to do a polygraph. None of this is good. God, this is just awful.
And Scott, if we can move to 3-30D.
I've had retarded clients, but never one this retarded. So I guess I'm doing okay.
And these are the website visits.
Yes, correct.
Just a moment.
The spelling
Sir, those
sucks.
are all my
A
questions
lot of
for you at the
people's
moment. I think the
spelling
defense may have some as well.
Thank you.
You'd be surprised how bad people's spelling is.
Get a refill for the witness, please.
Thank you, sir.
Mr. Ramos, did you want to break before beginning?
Thank you.
Yeah, I think we got to get out of here on time.
Don't commit to anything. But let's just take a stretch the leg break. We'll come back at 3:45. Thank you. Please rise for the jury.
So you guys might wonder what that little bit was about. He's like, Your Honor, we'll be done in time for the day. He's like, don't commit to that. He's like, I'm not going to hold you to that. Like, just get your cross
We'll be in
done.
recess until 3:45.
So-
Mr. Hutchins, you want to stretch your legs, use the rest of it's fine. Just don't talk anymore. Yes, sir. Understood. Thank you.
Possibly have time.
We'll see
no.
here. All right. How many fent to eat a husband? Well, that too, yes. That look, I'm so going to fucking jail. Yeah. Yep. Mm-hmm. Oh, yeah. So we'll see what happens here. This is gonna be huge, chat.
All right,
Go ahead and have a seat, folks. Thank you. All right, please have a seat. Thank you. Mr. Ramos, please have a seat.
Mr. Kouri Richins, how are you?
Doing great, Mr. Ramos. How are you?
Good seeing you again.
Good to see you.
You know what? Let's just dive right into the GIFs, the DNG files.
Yeah, sure,
right.
Sure.
Can we pull up those that exhibit?
They're gifts, not
And
gifs.
just for the witness, Judge. So I have this document here. It's been marked as State's Exhibit 340. Do you recognize that?
Yes, sir.
Now, when you were testifying earlier, you informed the jury that it was all the image files that you received, correct?
Well, just for this representation is just for that, for the fourth.
Correct.
Yeah.
Yes. So what we're looking at are
It's part of that. Yes.
images, data files for that day. Specifically, I think there was a range. It was for the March 4th, correct?
Correct.
Okay. Now, in that, there were 39 images, right?
Correct.
Now, of those images, obviously, we've seen 3 of them. Okay.
Yes.
So I want to focus on those. Okay.
Okay.
All right. So what I'm going to do is I'm going to pull up those 3 images that you've seen.
Okay.
Okay.
Mhm.
And I'm going to show you the MAC, right?
Okay.
Which is the modified access created. Okay.
Yeah.
All right. Pull that out for him. Now, could you see those on the left-hand side there?
I do, yes.
Okay. 1 second. That's what he can see, right? Sorry, I have a smaller screen here, so
Okay.
we're on the same page.
All right. Yeah.
Okay. On the left-hand side, can you tell me, or tell the jury, if all of these images were accessed on the same date and time?
Yes.
Down to the second?
Yes.
Okay. Now, you mentioned that these are .png files. Okay.
Yes.
Now, if we look to the right, there is what appears to not be a GIF, I guess. It is a thumbnail, but it is of a, how would you describe it? What's the picture? What's that picture of?
I don't know which one are we looking at.
The one on the right-hand side, it looks like a house almost in the distance.
Oh, yeah. Yeah. There's a photo of a piece of property, it looks like. Yes.
Are you familiar with that property?
I can't tell what it is from the photo.
Fair enough. Now, can you just look at the time and date?
Yes.
Okay. Does that match the .png files that we saw?
It does.
Okay.
Yes.
To the second?
It does.
Okay. So just practically speaking, okay, we can take that down. Do you find that odd?
Not necessarily.
Okay. Let's walk through it.
Okay.
I'm gonna walk through an example for you.
Okay.
Okay.
All right.
And then I want you to explain it to me.
Okay.
Okay. Now, in fact, let's do this. So, if I pull up my phone right now, I just unlocked it.
Mhm.
Now, I'm going to send a text message. Okay.
Okay.
To my son.
All right.
Okay. Now, I'm going to go ahead and add a thumbnail.
A photo. Yeah.
Photo. Okay. And I'll do a GIF. Okay.
Okay.
And so I'm looking for one. I found one. So I just clicked on that.
Okay.
Okay. Now I just clicked on another one.
Okay.
And I just clicked on another one.
Yes.
Okay. Now I'm going to add also a picture. Okay. Just for my folder.
Okay.
Okay. Now I selected those 4 items. Okay.
Hmm.
And I'm about to send it.
Yes.
Okay. So if you were to get my phone and put it in your system, extract it, and you analyze it, obviously it would be a text message.
It would. Yes.
Correct?
Yes.
Now, the modified access created, would all of those be the same date, time, down to the second?
They could be.
Could be.
Yes.
There's a lot of reasons for that.
Yes.
Okay. For example, the type of iOS I have.
That could affect it. Yes.
The type of extraction that's done.
I don't know if the extraction type would determine that or not.
Logical versus physical.
I still don't think in the way these images were in the database.
Okay.
He knows what he's talking about. Okay.
I don't think that would be accurate.
So then let's look at the database.
Okay.
Where exactly were these images?
So they were in the database. There's a pathway in there.
Yeah, let's pull that up.
So that's where they're at. Okay. So they're in an SMS photo database essentially. All right.
So is it up there now for you?
It is not.
Not yet. Okay. Now the source file, is that what we're referring to?
Yes.
Okay. Yeah. So I see here it has a bunch of numbers, underscore files, full.zip, right?
Yeah.
Private var, mobile, library, cache.
Yes.
Right?
Yep.
Okay. Talk to me about cache.
All right. So, caches are folders. They're just places where the system stores data.
Okay. And if I were to go to my phone right now, I could find those .png files, that image I just sent, right? If I go directly to my text message, correct?
You could. Yes.
Yeah, right, because I just sent it. Okay. Now, here in this file, this doesn't lead you straight to a text message. Correct. Okay. And so it is, and I think what you said in your direct, I think it was the system. I think it was the word. You were very specific. The system in her phone, I logged it. Is that correct?
Yes.
Okay.
Those are databases.
Correct.
Yeah, yes.
Okay. So fair to say, and you indicated in your testimony early, so I think I'm right, that there are certain things in our phones that are there, but we can't necessarily access them.
Correct.
We need a process to go kind of below the surface.
Right.
Okay. Now, in this case, these .pngs, you had 39 of them, correct?
Yes.
Okay. Now you only selected 3.
Yes.
Okay. Did you select those? I shouldn't put.
I provided what I provided. I provided the entire extraction report, and then I provided the part of the extraction report for that day.
Okay. So you provided the full 39.
Yes.
Okay. Understood. Now, I want to go back to that other image. Okay.
Okay.
Now, these have the exact same date, the exact same time, down to the second. Okay. Are they tied together?
I don't know that.
You don't?
No.
In fact, it's impossible to know.
It really is.
Now, in what you do, there is, we heard the word a lot, analysis, right? You analyze, right? Okay. Now, we know that you can, we get the information from Grade Key, it's extracted, and we put it in Celebrite. The analysis comes in reviewing the report, correct?
Correct.
Okay. Now, and you're also very careful in your direct testimony that it's not necessarily, I don't think you use these words, but it's not infallible, right? This Celebrite report.
Correct.
Okay. In fact, Celebrite itself recommends its operators, is that the word?
Yes.
To make sure that they validate their data.
Correct.
Right?
Yes.
And there's a lot of reasons for that.
Yes.
For example, you do have hardware that you use, correct?
Yes.
You want to validate it's working.
Correct.
And then also the software that you use, you want to validate that that's working.
Yes.
Okay. Now, this might be an oversimplification. But I'm trying to process it. Okay. A lot of money went into making those phones.
Yes.
A lot of the data and how it works is all of it's proprietary. Correct?
Yes.
Now, in a way, Celebrite is trying to hack the phone to get the information.
Doesn't really hack it, but it parses the data.
It parses the data.
Yeah.
Okay. And when it spits out, that's not a common term. When the report gives you this information, you can't take it as God's truth.
There's context to a lot of stuff. So yeah, I mean, I can take it as God's truth, quote unquote. Yeah. That is how the system files within the are constructed.
You can take it that's how Celebrite put the data or extracted the data. Correct. Now, you've heard, I suspect, of the epoch time.
Yes.
Okay. Now, if you could explain to the jury epoch time in terms of digital forensics.
I cannot.
Cannot?
No.
Why not?
I don't have enough familiarization with it. I just don't.
Okay.
Not on the stand.
All right. Well, is it fair to say that, let's look at this created and modified access, that date and time.
Is this going to be important? I don't know what epoch time is.
That time isn't actually how it's stored on the phones.
Oh.
I'm not sure I understand the question.
Sure. So the epoch time, if you're not familiar with it, it's the number of seconds that has elapsed since January 1st, 1970. Are you familiar with that?
I am.
Oh, sorry.
What was the objection?
He said he couldn't testify about what epoch time is.
So foundation. I think you're laying foundation.
I am, Rich.
Let's see where this goes. Overruled. I interrupted you, gentlemen, if you would ask that question.
Absolutely. So the epoch time, and I'm just going to, I'll explain it how I know it, and if it refreshes your recollection, great. If not, we'll move on. Okay. So epoch time is the number of seconds that has elapsed since January 1st, 1970. Okay.
I've never heard of this.
Don't know why they did it this way, but that is how the phones have registered the information.
Really?
Yes, and I don't know the technical aspects of it, but it's a programming reason.
Correct. And because we're not going to do the math together.
No, we're not.
We rely, or in this case, you were relying on Celebrite to do that. Correct. Now, you also, a way to validate your data, because things even as little as time, you also have the ability to cross-reference the data that you have in your phone, in the Celebrite report, the extraction, with other information, correct?
Correct.
So, for example, the call logs, the text messages that you sent out, right? That's presented
Why
in the
January
extraction.
1st,
You could then compare
1970,
it
Chad?
to the call detail records. Correct. Right? And you could say, oh yeah, you know what? This matches up. Yes. Okay. And you do that in a way to make sure that the information you're getting is correct. Yes. Okay. Now, when we look at this 4 images, the 3, I'm going to call them the what's been admitted as the 3 PNGs, okay, which we all saw, or just call them GIFs, even though I know they're not right now, right? But just so everybody's aware. And then we have this photo that appears to be of a home, okay? Right. Now, you have records and you have call logs for March 4th, correct?
Yes.
Okay. And you can see who all communicated that day, correct? And you can also get that through call detail records, correct?
Not always.
So the call detail records you indicated mark the time that a call was sent out and a text was sent out.
If it hits the carrier. So if it's a Wi-Fi call or if it's like iMessage, like iPhone to iPhone, iMessaging, it can route around it and it won't hit the call detail record.
Perfect. So you had on March 4th at least some information in what you received from the extraction report that some calls were made, some text messages were sent from Ms. Richins' phone.
Okay.
Yes. Okay. Now, with that information, you can, if you wanted to, you can attempt to see whether this image was sent or received by somebody, correct?
Yes.
Okay. You did not do that.
I did do that.
Okay. And who did it come back to?
I don't know. It was not available in the system file.
Okay.
Would you like kind of explain why?
Sure. Yeah, that'd be great.
Why I think, based on, there is, from the time this event occurred on March 4th till the time the phone was seized on April 13th, I believe, 2022, there's an extended period of time that's passed in data terms. Okay. So the reason why going back to the source on this is challenging is if the text source of this, incoming or outgoing, is missing, you can sometimes go into the data file, like from the timeline and from the extraction, you can go into the database information. You can go in there and you can look at that to see if that information is contained in the database still.
So I guess I'm just asking, why is it January 1st, 1970? And they started then because they figured it was like well before anybody was using it. Okay. And Johan's saying it's a Unix standard and the basis for BIOS reference oscillator time on a motherboard. Okay. Interesting. Thank you. Danke. Yes. Nerds! Okay. But yeah, here we go. It was very helpful, chat. Thank you.
Problem is that data is overwritten. Once it's deleted, the database then overwrites it. So then what happens is the source in there goes away. There's small amounts of data that are in there.
Like traces.
Well, like PNGs, okay, that are still there. But like I kind of explained with the data space, think of it as a...
Oh, one second. Is that like the garbage collection?
Yeah, we're talking about that, right? So so deletion. So think of that as, think of that deletion file as like the trash can in your house, like in your kitchen, okay? So you delete things, you throw things into that. Well, eventually it gets full. And you got to take it out to the curb and the garbage man comes and gets it and it's gone. Right. Okay. So the more you use it, the more you have to take it out.
So
okay.
Let me stop you there.
Yes.
Because what I'm asking about is, I understand that you tried.
I'm getting there. I promise.
Oh no. Okay. Okay. Go ahead.
Okay. Yeah. All right. So those databases store that information for a while. Okay. Then what happens is that text information, that the text threads, they're stored in a different place than these. What happens is every, 30-ish days, don't hold me to that, but it's roughly, this iOS system performs a vacuum. And what it does is it takes deleted information that's in there that it no longer thinks it needs for the system files, and it vacuums it out, and it basically takes it out to the curb, and then it goes away. So to answer your question, I did attempt to look for the source for this, but there's none of that data remains in the device or in the databases at all. All I have is these, what I referred to previously as orphaned images.
Or ghosts.
Ghosts.
Yeah. No, and I understand that.
Okay.
My question is, there are other things you can do outside of that. Obviously, that's your first one, right? You try to go straight to the source. For whatever reason, it's not there.
Okay.
But there are other things you can do to see if you can locate whether they're tied together or where they could have gone. Correct?
Correct.
So you indicated that at a minimum, this is on the mobile messaging system, right?
Yes.
It says mobile SMS, correct?
Yes.
So you know that at one point it was sent or received to somebody from Ms. Richins' phone.
Yes.
Okay, so you have contacts in her phone, correct?
I do.
And if you had call detail record, for example, or just in her log, or any number of things, right?
Right.
You can go to those and see if the individual on the other end maybe did still have that message, correct?
Potentially.
Yeah, potentially. Now, you didn't do that in this case.
Are we talking physically contacting these individuals? And
absolutely.
Okay. Yeah. So I agree with that statement.
Okay. That you didn't do it.
That I didn't do it. Okay. But I would also add to that my role in this case is as an analyst, and I provide the information, and then any following, any update or following.
The police never did it is a better question.
100%. Yeah. I mean, I imagine that when you were asked to pull those images on that date, I imagine you explained all of this to the prosecution.
I did. Yeah.
Right. And you explained to them that, hey, you know what?
They should go get the original phones.
39 of these.
Oh.
And to your point and your question, I did go through call detail records. I did go through those types of things to see if there was a corresponding communication that would be contained in the call detail records that matches this.
Absolutely. And you did this because that is your job. Correct. Right. You're trying to say, hey, I have this orphan ghost.png. I'm going to try to find its home.
Yes.
Right.
Yes.
And hey, prosecution, I know you're going to use this just so you know. I can't tell you who received it. Correct. Right. I can't tell you who sent it.
Correct.
I can't tell you if it was viewed by Ms. Richins.
Correct. Correct.
But I can tell you that at that time and date, the system in her phone, as you said, registered it.
Correct.
Now, for example, if we were to find out that the image there, right, of the home, okay, if we were to find that other recipient, right,
okay,
and in that recipient's cell phone, it had the day prior, okay, so March 3rd,
okay,
say around 5 o'clock, okay, and that individual sent the image, okay, and then Ms. Richins opened her text message with that home there, okay, and maybe those GIFs or those .png, those thumbnails were attached. It could have been that the computer registered as it accessed it as it was opening up, correct?
Correct, because it would create a thumbnail.
Correct. Now, like you said, we don't know that, right?
Correct, we don't.
Okay. Now, I'd like to move on to the web searches.
Okay.
Yes. A lot of those web searches, as we saw, have no dates.
Correct.
Right?
Yes.
And we do see some of them when they were searched, correct?
Yes.
Okay. Are you familiar with, I think it's called like lifestyle analysis?
No.
Okay. Did you perform any searches around the time on those that you can see on the web searches that you can see the date that they were searched? Okay. Did you do any searches on Google or any validation to see what, if anything, was relevant to what was being pulled up?
No, like did I perform the searches myself?
And not the searches. So, for example, are you familiar with a certain Real Housewife in Salt Lake City?
Recently?
In April 2022?
Oh, no.
Okay. Are you aware of somebody maybe being sentenced around that time?
No.
Okay. And now that would provide context to you, correct?
I could.
Yeah. Because right now, just as we see the searches, we don't know why that would be a search, correct?
I don't know content or can't speculate on anything.
You can't speculate. No. You shouldn't speculate.
No.
You also can't tell me with the information that you have.
Okay, but that's a problem, man.
Correct. Right. It was done on the phone.
It was done on the device.
You could tell us the location of the phone, possibly, when those searches were done.
Okay, that doesn't
you could tell us
work.
possibly the Wi-Fi that it was connected to, if it was connected to one.
Correct.
Okay. But you can't tell us who searched it.
Correct.
Now, you can't tell us if we were at, if this happened on the 4th. Let's go back to the GIF images, okay? On that day at
Here's
that
the
time.
problem.
Are you aware? Were you told?
Here's the problem, though. You're going to have to tell that jury, oh, she was looking up whatever Utah housewife got in trouble. And it's like, how many people are going to believe that? That's going to be a stretch because I don't know any of you housewife watchers. I know the one that got sent to prison there. So, yeah, I heard Styx has an FTA. Yep. Styx has a warrant.
That there were other people in that home?
I'm aware of that.
You are aware of that?
Yes.
Okay, so did you reach out to those, or I guess that's not your job. You could not tell us who opened that phone at that time, correct?
Correct.
Okay. Now, I do want to talk to you about something you just brought up. It was you said, the Wi-Fi. You said not necessarily because it could be an iMessage, right?
Correct.
Was one option, and then the other one was that it was connected or sent through Wi-Fi.
Yeah, the file path on here indicates that it is a mobile SMS, which went through iMessage, and iMessage iPhone to iPhone typically will not hit a carrier, so it won't be in a call detail.
Right, but that also is helpful to you, right? Because you're able to see of all the people that she could have possibly contacted that day, you could then narrow it to like who has an iPhone.
Correct.
Okay. And so because of the communication, and correct me if I'm wrong, I'm guessing here, between iPhone and iPhone, it's a different connection, correct? It makes it easier to communicate?
It's a typical Wi-Fi connection, so it's not a different connection. Okay. It's just a different system, or it's the same. They're on the same system. It goes through Apple servers versus the carrier.
So, for example, can you pull up the Mr. Richins mobile activity on the night of March 3rd? Do you recall that state's exhibit where you laid out a graph of all the text messages that were sent from Mr. Richins to a Pedro Sonora?
Yes.
Right. Yes. I think it's up on your screen now.
Yes.
Okay. When we were talking about this, one of the last questions was about the text from Raul at 10:18.
Okay.
And I believe Ms. Sherbanak asked if it had been read, or if you could tell if it had been read, and you answered it very curiously, which is I'm left to wonder. I just want clarification whether or not you could actually tell if it was read, or whether there just wasn't enough data to determine whether it had been read.
I didn't see any. I don't remember.
Okay.
I'm sorry. I just don't remember the
No, and that's why I'm following up.
Yeah.
That's why I'm following up.
There's no response. The indication was that it was not read.
Okay. Now, here we see all these text messages, correct?
Yes.
And we just talked about the iMessage that you just discussed. That sometimes that won't register on call detail records, for example, right?
Correct.
Now that's different than this, right?
That is different than this.
Okay. You would expect an iMessage to show up here?
Yes, because this is from the phone's timeline itself.
Correct.
These are system file.
Correct. Just want to make sure. Could we take that one down, please? Thank you. Okay. So the movement of the iPhone. Let's start with Eric's.
Okay.
You had indicated that you had done make sure, how did you phrase it? You had actually compared it. It said you had done some sort of analysis with his overall use in terms of his activity on his watch, right?
Yes.
And that those 87 minutes, that gap was off, I guess.
I don't think I said it was off.
What was your
I said it was atypical.
Atypical.
Yes.
Okay. Now, can you please walk us through what exactly you did to get to that conclusion?
So those are spot checks. Those are looking at random locations within his activity. I did not take the totality of his activity and compare it day to day to one another. Those were spot checks and looking at the device patterns in his phone to see if there was large types of movement. Now there are sometimes large spaces of inactivity, but not in this context.
So what spot checks did you do?
Just periodically throughout the timeline, through that activity timeline, just to look at and see if his activity indicates that his device stays in motion, and to what extent day to day.
Over how many days?
Oh God, I probably looked at maybe 20 days or so, just random days.
And how did you log that?
I didn't report it. I just made a mental note of it.
Just a mental note?
Yes, sir.
Okay. So what was the largest deviation?
I don't know that, sir.
What was the smallest deviation?
I don't know.
So you didn't really, you just looked at
that it was atypical.
Well, it's like I said, in context, right? So there's communications with presumably Mr. Richins on the device, and there is Mr. Richins on the device with Mr. Richins, right? And so there was
So right now, just so you're clear, we're talking about the physical activity.
Oh yeah, okay, yeah. I'm sorry, yeah, physical activity, yeah. But in conjunction with that, there are text messages. There are other things going on around this time, indicating in the other exhibits. I don't know if we published them, but there's some discussion about what Mr. Richins was doing that day around
so like
11 a.m.
So this one specifically, on February 14th, 2022.
Yes.
You indicated that the gap was atypical.
Yes, and maybe I didn't put that in good context.
Sure, put it in context.
But in context with what was going on at the time, it is not typical, based on what I looked at, for Mr. Richins to lay down and take a nap, for instance, in the middle of the day.
So you could tell that he took a nap from this?
I cannot, but he indicated he was going to in the text. That's what I'm talking about in context.
Okay, so there's a bit of confirmation bias there. I would agree with that. And there's probably a little speculation there on that. The thing with device activity is you only know if the device is moving or not. All right, there is a bit of speculation, like you said, and we shouldn't do that.
Probably not.
Let's talk about, you can take that down. Let's talk about the activity sensor data, okay? Not in context of what was registered,
okay,
but in the context of you as an analyst, okay? Now, we talked about how what you do is digital forensics.
Yes.
And that's considered a forensic science.
Okay.
Yes. Do you disagree with that?
Yes, it is.
It is. Yes. Okay. And part of that field, right, is what we, I guess, grew up knowing as the scientific method, right? Yes. And so, for example, here we identify a phone, an electronic device, okay? And then we go from identifying that to preserving it.
Yes.
Yeah.
Right?
Yes.
And we either put it in a Faraday bag or we plug it in and we make sure that the hash values and the hex code and everything matches.
Correct.
And we do that so that when you get the information, you know that it's the cleanest version possible. Correct?
Correct.
Okay. And then once we preserve it, we then collect the information, which would be the extraction.
Yes.
Right? And then we examine it.
Yes.
And then we get into the analysis.
Yes.
Okay. So we examined it, and I'm going to go off of the the activity sensors, okay? Activity monitors. So we identified it, we collected it, we examined it. Now let's talk about the analysis of it, okay? Tell us what you did to validate the information about the activity sensor data. And we'll start specifically with the distance traveled. And this could be for either Mr. Richins or Miss Richins' phone, okay? In general. Yeah, what did you do in this case for either Mr. Richins or Miss Richins, okay, to validate the information that was presented to you in Celebrite regarding traveled distance or distance traveled?
So the distance travel is just reported by the device based on the sensors that are contained within the device.
Correct. Yeah. So then what did you do to validate that information was correct?
I'm not sure I understand the question. I did nothing to validate that information, like outside of that.
Okay. So for example, that information that was there, it indicates, let's pull up Miss Richins if we wouldn't mind. The state's exhibit where it shows, this one right here. Okay. So can we publish this one, Judge? It's been admitted. So let's look at that 3:08:10 a.m. Okay. Now, the 74.14 meters, that comes straight from the extraction report, correct?
Correct.
Okay. And the 243 feet, I imagine that's something that you converted?
Yes.
Okay. And using what?
Just a Google conversion.
Conversion. Yeah. Okay. And in this device travels, we know that it was 74.14 meters that was registered on the device.
Correct.
Okay. Now, what kind of iPhone was this?
I believe it was an iPhone 12.
Okay. And do you recall what iOS system it had?
I do not.
Okay. Now, did you, for example, going back to, so I can explain myself, did you grab your phone, a phone, and measure the distance from point X to point Y, put the phone in your pocket, walk over there, knowing the distance, walk back, plug in the phone, and see whether the Celebrite data that you received for what you just did in that controlled environment matched what was being produced?
No.
Okay. Did you purchase or have access to the iPhone make and model of Ms. Richins?
No.
On either of her phones that she had?
No.
Did you have access to Mr. Richins' iPhone make or model?
No.
Okay. And you did not do any tests, correct? Correct. So these numbers right here that we're seeing, you are...
Okay, guys, this all sounds great, but as J-Rock put up here, as J-Rock said, here's the point. All those searches are going to fucking kill her. Those searches are it. I mean, there's no way you're not... there's no way you're not getting a jury to look at those searches. Like, that's, stop the fight. Stop the fight. I don't know how she wins here at this point with those searches. So this is really good, though. This is a very good, effective cross, pointing out what he did not do and the reliability and why that doesn't make his determinations reliable. So he's doing a good job of that. Like, Ramos is really good at this. This must be his thing, is technical stuff. He must be the tech guy because he's doing a great job at it. And somebody said he's the poor man Bob Alessi. I mean, in a way, but Bob Alessi had his own problems. Bob Alessi was hyper technical and would get really into the weeds on shit. This guy is not. So they have their own. They each have their way. They each have their way.
Speculating that is correct.
I'm not speculating. I'm relying on the data being correct inside the device.
But you have no way of knowing that.
Well, I mean, the examples you're giving are not 100%. Wouldn't 100% verify this anyway, I don't think. I think you would have to use the exact device under the exact conditions.
Yeah.
In any way.
I mean, TM73, part of this is it's a high-profile case. It's a lot of work. The amount of discovery and witnesses, that's a lot of fucking work to do as an attorney. So yeah, the more also the bigger, higher profile it is. Like, short of the death penalty, they're going after her. They're using all the resources they have available. The defense should have a similarly sized team. So yeah, I mean, there's a lot of fucking work going in this. Think about all the stuff that's going on. One attorney would not be able to do this. Like, if you're worried about why do they have so many attorneys, they should be as equally as equipped as the prosecution should. They should be par for par. And that's usually not the case. Usually in these situations, you're either court appointed or you're retained. And guess what? It's just you. It's just you. It's you against the fucking world. So, yeah.
For one.
Yeah, so let's go with.
Yeah, that's the thing. Him chuckling is not a good look. That might be his nervous tick, but that's not a good look. Also, TM173, very good question. Thank you for stopping by again.
that. So
And two, and which I didn't do.
Which I didn't
do.
Real quick. Hold on. So let's be clear. We understand you didn't do it. You did have access or could gain access to the environment, correct?
I could.
Okay.
Yes.
So then let's go from there. There are body cams in this case. Were you aware of that?
Yes.
Okay. Have you been to the Richins home?
No.
Okay. Have you seen those body cams?
I've seen some images of the body cams. Yeah.
Okay. Have you seen videos of the body cams?
Very few.
Okay. Do you recall a video where one of Miss Richins' phones is handed from one of the EMS to an officer, and then the officer walks over all the way to where Miss Richins is to provide her the phone?
No.
Okay. Had you been aware of that, or had that, rather, I'll be fair to you, had that been told to you by the prosecutors or law enforcement, having that controlled environment, having this data, having access to the same phone, downloading the same iOS, could you have run a test to see if it was similar? And specifically referring to the 41 meters that's indicated there.
I could.
Okay.
But I mean, your statement just actually opened up why there's a tense movement later on.
It tends to, questions sometimes tend to do that. Okay, so now let's talk about even the phone unlock lock. Okay, that seems pretty intuitive.
Yeah, the locking
and unlocking.
Yes.
So for example, when we look at the 319, I'm sorry, can we go back to the other one? I don't know if it was me. Thank you. At 319.39 at the bottom, phone unlocked 3 seconds.
Mm-hmm.
So it was unlocked 3 seconds. Does that mean it was locked at 3 seconds?
Yes.
Okay. And then, to be honest, it's just out of curiosity. Why don't we show an unlock before the 321?
Oh no, because that 39 that. Oh, I don't know.
Sometimes these things happen, right?
I don't know.
Yeah. Okay, we could take that one down. Now, going back to the web searches, okay, just briefly. This was all after, to your knowledge, I imagine you're aware that this was all after, all these searches were done after Ms. Richins knew she was under investigation, correct?
Yes.
Okay. And I imagine at that point, and if not, you've probably been made aware of it now, and we've all seen, during that January to March timeframe that you mentioned, that there was a massive deletions in her phone, correct? You remember that?
Yes.
As well as Ms. Lauber's phone?
Yes.
You know that they were purchasing oxys, correct?
Objection, Your Honor. Hacker Foundation.
Are you aware of what Ms. Richins was doing during that time, either then or now?
Yes.
Okay. Now, you're a former law enforcement officer.
Yes.
Okay. Do you ever deal in narcotics?
No.
Okay. You're aware of them?
I am.
Okay. You're aware of purchases?
I am.
You're aware of the criminal mind, perhaps?
I am.
And you're aware that most individuals dealing in drugs might want to delete their information?
Yes.
And like you said, context matters, right?
Context does matter.
Bear with me. Are you familiar with Bayesian inferences?
No.
Okay. Or probability statements?
No.
I'm getting there, I promise. Just want to make sure. Okay. Oh, can we pull up the call record for Ms. Richins? I think it was 110 minute one, please. Do you remember this?
I do, yes.
Okay. To be honest, I don't know why you were asked the questions. But this was in March. Could you zoom that in?
Sorry,
no, I know.
things are.
Zoom it in when you find it, please. Oh, don't worry about it. It's fine. You remember what we're discussing, right?
I think I do, yes.
Yeah. If you can find the date, that'd be great. I believe it was March 4th or 8th.
And Your Honor, this exhibit on the screen is not March.
Oh, it's February. This says February 11th. It's 3-6, whatever.
Oh yeah, she's scared.
March 1st.
This is not a good look for her.
Is it March 2nd?
So let's be clear, for the record, the jury can't see what you and Whitney.
No, I want to make sure that Katie finds it first,
Okay.
and then
Let me know when you're ready.
Is that it? Okay.
Yeah.
Yeah, that's it. Yes, if we could publish it, and we could see the 101 minutes.
Mm-hmm.
Now, the date is March 2nd, correct?
Correct.
And you indicated that you reached out and you found out that was the IRS.
Yeah, I Google searched the number.
Okay.
I know the number.
Yeah. Well,
It ends in 1040. I mean, it's.
It will, and it's a month before tax season.
Yeah.
Correct. So context-wise,
Okay.
not unusual, right?
Not unusual.
Yeah. We can take that down. I do want to make sure did you come on in May 2020? When were you brought on?
I was retained in May of 2023.
May of 2023.
Yes, sir.
Now, you indicated that Verizon holds locations only for 12 months.
Correct.
Now, Ms. Richins' phone was seized on April 12th, correct? I'm sorry, April 2022.
Yeah, April 13th, I think. Yeah, of 2022.
Of 2022. Correct. Now, so by the time you had come on, that information was no longer available.
The records were still available, but records with location data were not.
Correct.
Tower data.
Correct. Yes. Okay. And to your knowledge, that's never been obtained. Correct.
Correct.
Okay. We went through a lot of those PowerPoints indicating where Ms. Lauber was and the communication she had, I think, with Kouri on the right-hand side, and then kind of following.
Yes.
I think you made it clear. Those aren't their actual GPS locations, correct?
Correct.
Okay, those are cell towers.
Those are the tower locations, yes.
Right. So every time that the jury sees that little image going with Mr. Crozier,
right,
those are all cell towers.
Right. You're seeing the tower that that device is communicating with at that time.
And so there was a time during your direct that you indicated that I think it was Ms. Lauber was near the Richins home.
Yes.
Do you remember that?
Yes.
To be clear, it's not that she was there.
Her device was.
Her device was connected to a cell tower.
Yes.
Okay. Now, with all this information that you have, the call details records, the cell tower information, the Carmen's phone, right? All of that, were you ever able to see, or were you asked whether she went to 75 East 100 North in Midway?
I believe I was asked to look at that.
Okay. And did you find anything?
It's the data is not that specific.
Okay.
It's not GPS location. It's tower location.
Right. Yeah. Right. Okay, talk about those. Okay, I think I'm almost done. I think I am done. Oh, two things. Biometric data. Okay, let's go back to the activity sensor data. Did you go into anywhere in the extraction to locate the height Ms. Richins put in her phone?
I don't recall seeing that.
The whether her weight?
I don't recall seeing that either.
The stride?
I don't recall seeing that.
Did you do that or recall seeing that in Mr. Richins?
No.
Okay. These SMS previews that we have been discussing,
yes.
Are you aware of the different settings that one can do on their phone to either show a preview or not show a preview?
No.
You're not familiar with those?
I don't think so.
Okay. Do you have an iPhone?
I don't.
Okay. We disagree on a lot of things then. Fair. So you wouldn't have done anything there to check, or did you do anything to check her settings?
I did not.
Okay. So you don't know if on her settings in her iPhone there was an automatic play previews?
No.
Okay. One second. I have a Wi-Fi switch.
Okay. Real quick, Johan for $20. Thank you, says. Thank you, Johan, by the way, very, very much. Being a you have tech foo knowledge. First, he can't back up his assertions with contextual data. Also, he's proving this first guy doesn't understand the tech he's relying on. Third, for data to be forensically sound in the eyes of the law, it has to match exactly. Yes, it does. But here's the problem. Like, once again, as J-Rock pointed out, and I think is very important, those searches, that's it. The jury's not going to latch on any of this shit. They're going to see those searches. Why is she Googling all this shit? As her husband's dead. Can you subpoena Google for some of this data? Sure, but some of it might be proprietary. Google's, it's kind of like when these lolcows sue Google. They come in and tell you to fuck off. I mean, remember, after the San Bernardino terrorist attack, when they killed the husband and wife team who shot up their work party, they had iPhones. And the FBI went to Apple and said, open them up. And Apple said, fuck off. We're not doing that. Like, it's a thing. It's a thing. And I doubt Google would help. So, but yes, thank you, Johan. So. An island, yeah, here's the big deal. When did she make them? Who sent them? Did she do them? Like, what actual time did she do all this? Because remember, if these things are opened up at a different time, when were they sent? If they were sent 2 days before and she opens them the day he dies, well, then it gives you a problem about the timing of everything. So, yeah, there's a lot of problems here, but I think the jury's going to see those searches and just think that's it. So. I think that's ultimately what's going to fuck her over. So. So. So we'll see what they do here. Yeah, Apple's been very resistant to things. And ultimately, there's not enough information here. But I think the jury's going to see those searches, and they're just going to want to kill her. But also, once again, Johan, thank you.
For clarification purposes, because as I was talking about the web searches, I did not specify, and I want to make sure we get it clear. Those came from the blue phone.
Correct.
So those were after the April 13th, April 12th, when the white phone was seized, correct?
Correct.
After Ms. Richins obviously had been under investigation.
Correct.
Correct. After her, I'm not sure if you're aware, after her home was searched.
I don't know anything about that.
Okay, but it was on the blue phone. Yes. None of these web searches were on the other phones, correct?
Correct.
Okay. That's all I have. Thanks so much. Appreciate you.
Yeah, thanks.
Mr. Burnett, within the scope of cross.
Sorry. Sticky notes.
Two things I want to follow up with you on. We talked a little bit about CDR data and Wi-Fi, maybe why things wouldn't show up on Wi-Fi.
Sure.
What type of messaging can happen over Wi-Fi?
Most app messaging happens over Wi-Fi. So third-party apps like WhatsApp, Kik, Signal, those types of apps. But also, again, iMessage.
And so when talking about those 3 image files located on Ms. Richins' phone from March 4th, 2022 at 8:29 a.m., we don't know all of the information about those because it was deleted.
Correct.
If it hadn't been deleted, we'd know more.
We might.
Talking about the web searches on the blue phone, when you looked through and analyzed that blue phone, nothing indicated to you that that blue phone was being used by someone else.
Correct.
I want to talk about Exhibit 3-14D. And this is the device. Scott, if we could put that one up.
One moment, please. The witness has it. Do you want to publish it?
Please.
Okay. Go ahead.
Now, you made this exhibit in conjunction with the context of what was happening during this time frame. Is that correct?
Correct.
Meaning that you looked at messages between Kouri Richins and Eric Richins during this time frame.
Yes.
And in those messages, Kouri Richins was telling Eric Richins to go take a nap.
Yes.
And based on what you've created with this exhibit, does this movement in context indicate to you that during this time frame, Mr. Richins could have been laying down or
Yes.
not moving?
Yes.
I want to talk about this activity sensor data. That data is proprietary to Apple.
Yes.
And tell me if I'm wrong, but Apple probably puts a lot of money into making that data.
I'm sure they do.
They want it to be correct for
Yes.
their users.
Yes.
And they would want it to be accurate for their users.
Yes.
Because their users want that activity data to reflect what they're actually doing.
Yes.
Have you looked at activity data in other phone downloads that you've analyzed?
Yes.
And looking at phone activity data for other hundreds, maybe thousands of phones that you've analyzed, have you been able to tell if that data can be checked in other cases? Meaning that if somebody said, hey, I went for a 1 mile walk today, giving you a hypothetical, and then you could look at their phone and say that they went for a 1 mile walk. Have you been able to look at that type of data in other phones and verify that it reports in the way you would expect?
Are you asking about corroborating witness statements based on their activity in their devices?
Right.
Yes.
That activity data in other cases when you've analyzed it has been accurate and corroborated by other information?
In my experience, yes.
Just a moment. That's all I've got for you, sir. Thank you.
Thank you.
Mr. Ramos, within the scope of redirect?
Yes, of course. Thank you, Judge. Indicated that the Mr. Bank was talking about the information that was deleted.
Yes.
Regarding those thumbnails GIFs, correct?
Yes.
Certainly it would have been better for all of us.
It would have.
Does that file path and the information tell you who deleted it?
No.
And as you explained with the garbage collection, it could have been that way, correct?
It would have to be, if it wasn't deleted from the device, it would not have ended up there. There would be a remnant of it.
Right.
Yeah, it would be a data line.
Okay. Now, You were also asked about that you did not investigate or you don't have any reason to believe that anybody else had the blue iPhone. Do you recall that question?
Yes.
And you said that no.
Yes.
How do you come to that conclusion?
The big thing for me is there is a text in that phone from that device to Mr. Grossman in which the defendant indicates that.
So to be clear,
yes,
I'm not saying that the phone wasn't Miss Richins.
Right.
Right.
Yeah.
My question is.
Okay. Well, I'm trying to answer it.
Yeah. So I'll clarify my question to make sure I'm asking it. All right. Is your testimony that there was nobody else who had access to that phone at all?
I don't know that.
Okay, that's my question. Now, you were asked about Apple software and proprietary software, and did you attempt to get information from anywhere else, whether it's Apple, whether it's another peer, whether it's another case, where you can get the information that you have in these extractions to validate it?
I kind of don't understand that
Sure,
question.
I'll rephrase.
Okay. Yeah.
Yeah. So I understand that you don't work for Apple.
No, I don't.
That you don't know how it works. That you don't know how the activity sensor data is logged, correct?
I don't know what their programming looks like.
Correct. Yeah. Okay. Do you make any efforts in this case with this information to try to validate that the information you had was up to Apple standards?
No.
You indicated that you've been able to rely on other cases before. How many cases?
At least 100.
And so in those cases with activity sensor data, in those you did test?
Oh, okay. So analyze data in phones, at least 100 phones. There have probably been, I apologize, there have probably been a dozen or so cases where I've had to corroborate like witness statements and suspect statements, that type of thing, against their phones. And I have not found any inaccuracies.
I misunderstood. You, in those cases, corroborated the data that you received, but you did not run tests to make sure that the data you had was accurate.
Not physical tests, no.
Correct. Okay. That's all I have to know. Thank you. Thank you.
Thank you.
I have one question.
Oh, no, don't let her. No.
That no one else
We're not doing a redirect. Come on.
was using Kouri Richins' blue phone.
Yes.
There was a text message that indicated to you how you know that.
Yes.
How did that message indicate it to you?
Not word for word or verbatim.
Summarize the message.
The message summary was a text from the new number, the 9592 number, which is the blue phone number, to Josh Grossman's phone. And Ms. Richins indicated to Mr. Grossman in that text that she had activated one of, I believe it was her mom's phones, and she would be using that now. So, to that effect.
So she told him, this is the phone I'm using to contact you now.
Yes.
That's all my question.
May we release this witness, counsel?
Subject to rebuttal if we need him.
Understood. And you are still subject to subpoena, so that means you can't. Well, he's an expert, so the exclusionary rule does not apply to him. Correct, Mr. Ramos? Okay. Maybe we'll see in the future. All right, thank you, sir.
Thank you. I appreciate it.
Okay. Now's a good time to recess for the day, Mr. Rubnik, yes?
Yes.
Mr. Ramos? Very well. Ladies and gentlemen, we are going to recess until 8:30 tomorrow morning. As always, please affirmatively avoid talking about or listening to anything about this case. Avoid any person that's trying to talk to you about the case. Please do not read, watch, or listen to any report about the case at all. No online or other research about the case. Please travel safely. Enjoy your evening. Please rise for the jury.
We'll see where this goes. Oh.
Counsel, have a seat, please. Ms. Shervanek, Mr. Bloodworth, anything else on the record today?
No, Your Honor.
Ms. Lewis, Ms. Nestor, Mr. Ramos?
Do we want to address the journal issue?
What I propose, and let me just say it out loud, and then you can tell me whether you have any objection to this, is to let all of you consider whether you want to have the court forward hire that witness regarding his prior interactions with Ms. Crosswhite tomorrow morning. And if so, we can do that. Or if you prefer not to do that. But give that some thought overnight. We can take it up first thing in the morning. Any objection? Mr. Bloodworth?
No objection.
Okay. We'll be in recess until tomorrow morning. Please travel safe.
Johan says, if I ever win the lottery and I have fuck you money, I'll do your forensics and comp expert work for free. You'll be the most feared defense attorney in Ohio. Well, thank you, Johan, for $5. I appreciate that. Yes. Tomorrow they will interview the juror and figure out that information, which hopefully that's actually, sadly, that's probably not going to be available, but that would be pretty fucking cool if we could see that. I'd be curious to know. Those are actually always very fun. Those are always very fun things to do. Like interesting when you have to like voir dire one because shit's going sideways. So yeah, something to think about. Yeah, chat. That was really interesting. Things were looking kind of good for Kouri until the whole fucking search engine thing. So Yeah. Yeah. I think she's toast, chat. I think she's toast on a cracker. She's done. I don't have. I'm not holding out hope for her at this point. So, just something to think about. Yeah. Be careful with everything you do, guys. Be careful with everything you do. Everything can be interpreted and used against you. So keep that in mind, chat. Keep it in mind. So, yeah. But thank you guys for your support tonight. I appreciate it. Thank you all for being here. Thank you for the new faces. Hope you guys are doing well. And people who are kind of new, thank you for being here. And, for the people who've been here all along, thank you guys all. So, yeah, be careful when you're doing this stuff, guys. You leave trails everywhere you go. So, Libby says the money memes could be selling the house, sure, but now, but it's just bad timing. So, that's the problem. Afton says watching Ryan on my TV. I don't know who Ryan is, but this is this is a problem when you're an attorney and you have to say, ladies and gentlemen, this is what it looks like. If you say it too much, there's only so much you can do there. So, oh, my friend Ryan. Oh. No Keno tonight, yes. TM says, you must like abuse. I mean, in what way? Malali, thank you. Human Resi, your gay friend, right? Thank you. Well, how would you know he's gay? Did you proposition him? Ooh. Yeah, the casino's taking the week off. They're being lazy Canadians. The finest acting like true snow Mexicans. They just take a week off for siesta. So, lazy PPP. It's off for a month? Ooh. Jesus. PPP being lazy. Yeah, they're mourning. They're coping. International coping. So. Oh. Take a week off and they're hopping the border. Yes. All right, chat. So the Olympics broke them. I'm sure it did. We broke the back of Canada, chat. All it took is a hockey game, and we shattered them. People are soft as pudding up in Canada. So, all right, chat. Yes. Failed nation, buck broken. Yes. Safa Leafs. Although that could also be for the Maple Leafs too, because yeah. All right, chat. We're gonna end here. And we're gonna call it good. We will be back at this tomorrow, same time, day 7. We'll see how things are going. Oh yeah, apparently if Runkle is saying it, there's a newspaper article out. 100,000 people have used MAID so far. 100,000 people have committed suicide. Model stream tonight? No, Sweet Tooth. Tomorrow night we will do a model stream though. I'm still tired. Still sleeping off from the dogs keeping me up all night. So we're going to leave it here, chat, and I will see you guys tomorrow. And yes, you're so excited for the outro music. I'm glad. Robert says, relax, Sean. I am relaxed. Are you relaxed? All right, chat. I will see you guys tomorrow. And remember, until next time, just because you did it does not mean you're guilty. Although, once again, those search history results, Kouri, I don't think you're long for this world. So, good night, chat. And no locals tonight, guys. We would have ended anyway, or like in 20 minutes. This trial's actually getting good. We're getting into the good part of the trial, guys. We had to waste a whole week to get to the good part. We're in the good part of the trial now. This is the sexy part of the trial. You guys are going to enjoy this. I promise. So good night, chat. Take care, free Kouri. Yeah, okay. Good night, chat.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick Hayden yelled at? Why, yes it was.